Trying to focus on the death reference cases now.
Not
We'll put it as to be mentioned, right? To be mentioned. Will to be mentioned, right? The caption will be to be mentioned. Yes. Very well mentioned, Belin. Yes.
May I permit to mention one mandamus appeal, Lordship?
Forget it. Without certificate. Yeah, you have got a copy. I mean, very well. Yes, leave is granted.
Section 1 bail in connection with appeal.
Yes. Yes. Correction. Yes. Yes.
Lordships,
Correction. It. Yeah, we'll come to the online mentioning. Please wait. Yes. Yes. Oh, yes. Yes. Online mentioning, please.
Lordships, one, the London single judge has passed an order on 23rd of July. We are filing a mandamus appeal today, Lordships. We need a leave, Lordships, and my writ has been admitted by the London single judge, but my interim has been rejected, and there is a consequences of recovery of around 15 crores of refund sanctioned to
No,
me
Mr.
3 years
Kanodia,
back.
what sort of leave are you wanting?
Lordship, leave to file appeal without certified copy.
Yes, we have. Yes, we are granting it.
Lordship, I will mention this, Lordship, 3. I will service only one respondent. I will service it today itself at Siliguri. If it can be taken on Thursday, Lordships.
In this circuit, Mr. Kanodia, very difficult.
Lordship, I will try my luck on Thursday, Lordships. I will try
Try
my
your
luck.
luck, but probably we can't assure you. Yes.
I will.
Else anyone
Lordship,
else wants to
Lordship,
mention? Yes.
Lordship, may I kindly mention, my lord.
Yes.
MAT 16 of 2025, my lord. Last Tuesday, hard, my lord. GST matter, my lord. It will appear tomorrow, my lord. So I am praying, my lord, little higher side in the list, my lord.
No,
tomorrow.
Mr. Rai, we cannot assure you now. We cannot assure you now because we have these death reference matters. This
My
week, no preference, please. Sorry. Yes, Miss. Anyone else wants to mention online?
My lord, may I be allowed to mention item number 73, my lord? My lord, this is a WP LRT item number 73. 73, but this is a WP LRT, my lord. On last Monday, my lord, it was mentioned before, my lord, and my lord was kind enough to fix it on Friday. But unfortunately, it was then on Friday, it came as item number 40, but it was unable to be heard. But kindly, my lord, takes it up today, my lord. I am coming physically before my lord. Kindly takes it up today.
No, Mr. Shah. No, Mr. Shah. We cannot give preference. Now death reference preference only.
No, but kindly, my lord, at my lord's convenience, my lord, but we have been trying to get it
No
heard for
preference.
since more than a year
No
now, my lord.
preference. Sorry, no. Yes. Yes.
Grateful.
Call on this. What?
But the CRAN is right for
Which item? Which item? Which item?
one
What is the CRAN for?
for bail.
Bail in connection with appeal. CRAN to application দিয়ে দেবেন তো খালি 10. Write the item number and hand over the slip. Write the item number just and hand over the slip. এটা application bail in connection with appeal দিয়ে দেবেন. Yes, call on the list. Accordingly, MAT number 53 of 2025 is allowed on contest, thereby setting aside the impugned order dated such and such passed in WPA 1140 of 2025, as well as reversing the orders of the appellate authority and the order passed by the proper officer in respect of the assessment with regard to the appellate firm. It is made clear that nothing in this order shall preclude the respondent authorities from issuing a fresh notice under section 73(1) of the Act and from proceeding afresh on the basis of the same upon due compliance of the relevant provisions of the said Act and in accordance with law in the light of the observations made above. Consequentially, can also dispose of no order as to cost, interim orders vacated. Respondent authorities shall specifically take note of the observations made in paragraph numbers 52 and 53 of this judgment and take curative steps accordingly at the earliest in order to obviate any future doubt being created as to whether the uploading on the GST portal would constitute a proper communication of the notice under section 73 within bracket 1 of the Act and rules. Mr. Rahman, we have just indicated in those paragraphs that these tabs, this is creating a problem. Your unnecessarily good orders are being set aside.
Because it is already.
Very well. If that is the so, it is already. We have stated we have given you an alternative either to just give it a thought. If it's already done, either a single tab, or if it's ordinary this notices and orders and additional, you have to clarify in the portal itself what will be additional. That guidance will be there in the portal so that nobody can come up tomorrow and say again these things. Because every other matter, this point is being taken.
Lordship is rightly point.
Thank you. Just this portion, please communicate to your authority.
Lordship.
We have mentioned in our order itself,
Lordship.
52 and 53 paragraphs.
Grateful, Your Lordship.
Thank you. Call control.
Matter was mentioned before the honorable single bench.
Yes,
There's a mistake on our part on that.
what is this?
This is the matter, my lord, that I am seeking direction for the paper book, my lord. Question of law has been formulated, but there was no direction.
You are giving the direction right now. You're for the appellant. Although, comma, strictly speaking, comma, the matter pertains to the jurisdiction of a learned single judge, comma, in view of the innocuous nature of the prayer, comma, we do not want to relegate the appellant unnecessarily to the learned single judge. Full stop. The appellant seeks directions for expeditious hearing of the appeal. Full stop. Accordingly, the appellant is directed to put in the postal costs and requisites for service of notice of the appeal on the respondents within a week from date. The trial court record shall be brought by special messenger at the cost of the appellant, comma, also to be deposited within a week. Full stop. The appellant shall prepare and file the requisite number of paper books, informal paper books, without comparing with the records within 6 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to the parties to mention the appeal for inclusion in the list before the appropriate learned single judge as and when the same is ready for hearing. Thank you.
Number 3.
Yes, Mr.
Short passover, Mr. Sadnik Shankar Siddhar is on the way.
Short passover will
Five.
very well. Short passover.
Sorry, Lordship.
No, no, it's okay.
Number 4.
None appears for the parties at the time of call. Let the matter stand adjourned for the day.
Stand listed.
Yes. 5 who is for the petitioner? 4 we have already made not today. Yes. Yes. Board is showing 3. Your matter is 4. You will not be in court. Strange. Yes. Who is in 5? What is the mitigating circumstance, Mr. Shaha?
Yes, Lordship. It could be.
Right.
The appellant has been sentenced to suffer 20 years imprisonment under section 6 of the POCSO Act.
Right.
Lordship, the petitioner as on today, Lordship, 4 years, 4 months, 4 years, 4 years, 5 months almost is in custody. Lordship, the prosecution has relied upon 11 charge sheeted witness they have examined. Lordship, the allegation, according to the FIR, the allegation was that the de facto complainant, while went to his grocery shop at 7 o'clock, at that point of time, leaving his minor daughter and his son inside the room.
What was the age of the daughter?
Daughter is aged about
Was
9 years.
9.
Yes.
9. Very well. Yes.
And son is 5 years. At that point of time,
And your age?
yeah, my age was at that point of time 22 years.
Achha. Yes. Then what happened?
Then thereafter, the victim, the petitioner had entered into the house of that of the de facto complainant, and thereafter, the daughter, the son of the petitioner was put into dark, and thereafter the daughter was taken away from the room, and she was ravished, and subsequently on that they had approached the petitioner, the de facto complainant and her husband and one Gopal had approached to the police station to lodge complaint, and immediately thereafter the victim girl was taken to the hospital by the police station without registration of any FIR, admitted.
What is your best mitigating circumstance?
Base mitigating circumstances is that medical does not support it. The kindly see the first the deposition of the victim girl.
Medical does not support it means there is no sign of penetration.
No, nothing. The medical injury report indicates that no injury found. This is the categorical of findings, and everywhere no injury report, nothing that sort of. Immediately, the examination was done immediately after the incident, Lordship.
Right.
But no injury was.
All right. Then what else?
I'm showing lordship.
What do you do otherwise? Your client?
Student or school student? Student? No.
22-year cannot be a school.
20, no, just.
If you're a school student in 22, then you should be.
Not college student.
What sort of college?
Because I don't have any specific
Very
information.
well, very well. Fair enough. You're telling
But
the
Can you
absolute.
see the deposition of the victim?
What does it say? Which page of this? We don't. Deposition of victim. She was PW1?
PW1.
Yes.
At the
Have you
initial,
got an extra?
at the initial stage,
Sorry.
she has stated that I read in class 4 in Bagan school. So thereafter, also kindly see last paragraph or the first page. The relevant portion, myself along with my brother was lying in our house. And then Nilkamal covered my brother with a kantha. Nilkamal dragged me in the bush outside our house and put off my dresses. He is lying down me. He put his penis inside me. I sustained injury and started yelling. He pressed my mouth and threatened to me and to kill if he raised alarm. This was the statement, and in this cross, she has stated in that I studied in class 3 in the relevant portion.
Before?
No, subsequently, I had not sustained any breathing injury or of such act. I sustained pain in my private part. Then kindly see the medical examination, medical doctor, the deposition of the doctor at the PW9.
You should have just flagged the pages. In PW9?
PW9. On examination, I did not find any mark of injury on the entire body and private parts of the victim. This is first. In the cross, if a guy of 22 years forcefully commit any penetrative sexual assault upon a 9-year-old girl, then there ought to have a marked injury on the private parts of the girl. And then in the same case, if the guy tried to commit penetrative sexual assault upon a 9-year-old girl, then there may be an injury mark on the private part of the girl. This is a complete, and I did not find any injury mark on the private parts of the girl, and that is why I did not give any opinion in the same medical report. The medical report I have shown, Lordship, one of the best evidence that is supposed to become, that is the brother of the victim girl, a girl. He has not been come before the court. His evidence has been withheld.
Let us hear them. Yes.
Lordship, Lordship, the minor is 9 years old, minor.
Everything else is in your favor, in favor of refusing, but nothing, no injury. And she said that she was dragged. Otherwise, we were with you. But dragged in the bush. If someone is dragged in the bush and she's 9 years, I mean, yes, under force she may wilt. I mean, that can happen. But if she was dragged, put the penis inside her, then no injury whatsoever, entire body, private parts, nothing. And this is aggravated sexual assault. The charge you have put is not credible. Your medical examination, the doctor's examination demolishes it, prima facie.
Lordship, but the minor girl stated and it's not necessarily the penetration must be a injury, Lordship.
Penetration need not be hymen rupture or something like that. Definitely not. We fully agree with you. In POXO, it's of a high standard. But whether that presumption of POXO is raised at all, because if the doctor's report says this, you have seen the doctor's evidence also.
Yes, I have gone through the PW9.
Huh.
But Lordship,
That creates a doubt.
others, even a victim also stated, but only 9 years girl, Lordship. So why
Fully.
is he implicated that person's, particular that person that he's committed?
There may be various reasons. We don't know.
Lordship, my humble submission.
Because even prima facie, there has to be something to show, because aggravated penetrative sexual assault, no injury, don't go together. If it was something less, we could have still understood. That is the difficulty. We are granting bail, we would not have otherwise. If there was something in the examination of the doctor, something remote, we could have understood.
Even Lordship, the others sexual, that cannot be.
Those are of a
sexual
lesser.
Could be
Yes, other sections could be.
aggravated.
Yes, Lordship.
In most cases, we are seeing that the offenses they are charged with don't tally with the, evidence. That is the difficulty. We are granting bail, but strict condition means we would not approach in any manner. Live in the same.
Granting bail.
Yes.
They didn't turn up for the final hearing, Lordship. With lots of cases, Your Lordship, they got bail.
Huh.
Subsequently, they didn't turn up for the hearing of the
The
bail.
next day, file an application for cancellation of the de facto complaint can file.
The
The very next day, file an application. The day they jump the bill, immediately cancellation will be very strict. We are very strict. Particularly in POXO matter, definitely a presumption goes with you otherwise. Learned counsel for the petitioner submits that the petitioner, who has obviously a serious objection. We also would have objection unless this
Yes,
doctor's
Lordship.
report was there. This was there. Learned counsel for the petitioner submits that the petitioner has been charged, convicted of primarily of the offense under section 6 of the POXO Act. First up, the petitioner is about 22 years old. First up, the victim girl was 9 years at the time of the alleged offense, and her 5-year-old brother was accompanying her when allegedly the petitioner dragged the victim to a bush and perpetrated the offense on her. First up, next para, in her evidence, the victim stroke PW1 stated that due to the insertion of the penis inside her, she sustained pain and started yelling. Full stop. Next para. However, it is pointed out that the medical report produced by the prosecution in support of the charge entirely exonerated the petitioner, since all through the medical report, it transpires that there was no injury whatsoever on the body of the girl, including her private parts. Full stop. The doctor, in his examination in chief, corroborated such stand by stating that he did not find any mark of injury on the entire body and private parts of the victim girl. Full stop. In cross-examination, the doctor stated that if a guy, GUI within double inverted, of 22 years forcefully committed penetrative sexual assault upon a 9-year-old girl, then there ought to be an injury mark on the private parts of the girl. First up, he further stated that in some cases, that in the same case, if the guy to double inverted tried to commit penetrative sexual assault upon a 9-year-old girl, then there may be an injury mark on the private parts of the girl. Full stop. The doctor said further in his cross-examination that as he did not find any injury mark on the private parts of the girl, he did not give any opinion in the medical report. Full stop. Next para. Taking into consideration the fact that the offense leveled against the petitioner is not at all corroborated by the medical report and the doctor's examination, rather contradicted by it, and the fact that if a victim is dragged to a bush and an aggravated penetrative sexual assault is committed on her, there had to be at least some marks of injury on her body, we are of the opinion that the benefit of doubt should be given to the petitioner. First up, accordingly, CRAN 2 of 2025 is allowed, thereby granting bail to the petitioner on condition that the petitioner shall furnish bond of rupees 10,000 with 2 sureties of like amount each, one of whom must be local. First up, the petitioner shall not leave the territorial jurisdiction of his residential police station throughout the period of the appeal, and shall not, in any manner, try to contact or approach the victim girl or her immediate family in any manner whatsoever, and stroke or tamper with the evidence or try to contact or intimidate any of the witnesses in the case. First up, the petitioner shall make himself available as and when so required by this court. First up, this much. প্রথমে একটা affidavit of service filed to be kept on file.
I suggest some service.
আচ্ছা, the affidavit of service and the receipt of service handed over respectively by the learned counsel advocates for the petitioner and the state be kept on record.
ACGM
আচ্ছা, to the satisfaction of ওই যেটা বন্ডটা, to the satisfaction of the ACJM,
No, CGM Alipurduar.
CJM Alipurduar, CJM Alipurduar.
Grateful.
Thanks, sir. Thank you. সব ভেতরে চলো পরেরটা। পাসওয়ার্ডটা কেউ এসছে? হ্যাঁ, ডাকুন।
Item number 3, password item.
Yes, Mr. Bhattacharya.
I'm sorry.
No, sir. What is the matter?
Conviction under section 6 of the POCSO. Convicted for a period of 25 years of rigorous imprisonment with a fine of 50,000.
How many years?
25 years
25 years.
with a fine of 50,000 and in default of payment to suffer further 1 year of rigorous.
Your age?
At the time of conviction, my lord, on 20, I was 35,
The girl?
15. Now, my
All
lord,
right.
I'll be candid, my lord. The allegation is of committing that offense on my own daughter.
Medical report?
Yes, medical report shows certain penetration and bodily injury. But during my lord the trial, I was granted bail on the ground that the victim in her deposition has stated that nothing of this sort had ever happened. She was tutored by the police to give a statement before the magistrate. If your lordship kindly comes to the order of bail passed by the learned trial court at page 18.
Which page?
Page 18, my lord. And the typed copy is at page 19.
What is this? Her state? The ground of bail.
This is, my lord, the.
No, what was her evidence? In evidence, she corroborated the offense. Her evidence is considered.
The evidence has been considered. Kindly see, my lord. The last line, my lord.
Have you got a copy of the evidence?
Yes, I have. The learned public prosecutor had not objected to my bail and even the.
Public prosecutor non-objection
Yes.
is a non-issue. Non-issue. Identify. হ্যাঁ একদম identify. Sorry, Mr. Bhattacharya. No bill.
Well, there was completely, my lord, she retracted. And the judgment, my lord, went on the basic conviction, my lord, the learned court gave on the basis of certain medical documents, my lord. Kindly appreciate, she says in her statement, my lord, that her stepmother was informed. Stepmother was never, my lord, examined.
Appreciated.
And also, my lord, she says that she had come out of the house when she was beaten up. And no, my lord, not a single neighbor was ever examined, my lord. It is only on the basis.
No, Mr. President.
of this.
A learned counsel for the petitioner contends that the petitioner was framed under section 6 of the POCSO Act, since the victim girl herself, in her evidence, categorically denied the offense and also said that she had no part in lodging the complaint. For next para, it is further submitted that there was an allegation of the victim being beaten up by the petitioner, her father, in regard to which no evidence or witness has been produced as well. Next para. However, we are unable to accede to the prayer for bail for the following reasons, colon diye niche. First, comma, keeping in view the relationship between the victim and the petitioner, within bracket, daughter and father, bracket closed, comma, the possibility of the victim girl having been pressurized to retract from her complaint cannot be ruled out. Full stop. Particularly, comma, from the judgment of the trial court, comma, we find that the learned judge categorically recorded that the victim girl as PW1 identified her signatures on the FIR as Exhibit 1, comma, on her statement under Section 164 CRPC as Exhibit 2 and 2 by 1, comma, on her medico-legal examination report as Exhibit 3, and also identified the accused as her father. Full stop. Next para, the victim girl was about 15 years of age at the relevant time and was sufficiently intelligent to have signed documents by knowing the purports thereof. Full stop. Subsequently, comma, it she was declared hostile witness, comma, since she retracted from her allegations. Full stop. However, comma, the medical report as well as other documents clearly suggest the involvement of the petitioner in the offense. Full stop. Keeping the heinous nature of the offense, comma, the fact that the relationship between the parties require a far higher standard of rebuttal on the part of the convict to get a bail during the pendency of the appeal, as well as the corroborative evidence on record, comma, we are of the opinion that the prayer for bail ought to be rejected. Full stop. Accordingly, CRAN, this is CRAN 2. CRAN 2 of 2023 is dismissed.
Grateful, my lord.
Thank you. What are why are the two matters appearing together? Service is not complete. Very well. Learned counsel for
The state,
that not being served on the victim, on the de facto complainant. Acha. Learned counsel for the petitioner in both the matters submits that the service on the de facto complainant could not be completed as yet. Full stop. Accordingly, let the matter stand adjourned till July 30, 2025. Very well. July 30 is this circuit.
Dispatch, state can be directed to.
Let the report come. It has been dispatched.
No, the state shall also effect service on the de facto complainant in the meantime.
Copy. Copy.
That's a different thing. When the bail application is taken up, we'll consider.
Appeal, we are not made in the de facto complainant in the petition, my lord, so kindly give liberty.
Leave is granted to the appellant to implead the de facto complainant as a party to the memorandum of the appeal. Next. Then NDPS, Mr. Majumdar. Yes, Mr. Shahabudar. Please take your seat, Mr. Majumdar. We'll just hear. Yes. Yes, Mr. Shahabudar. You have been convicted in bail, no presumption. Rather, in an event, best case, quick.
Yes.
What is your best case?
CPW2, my lord. CPW2, my lord. Independent Cesar witness, my lord. My best one. My lord, PW1, thereafter, my lord, PW2. My lord, internal page, my lord. After page 7, my lord, PW2 starts.
Yes, PW2.
My lord, PW2, my lord, can you see the PW2, my lord? He was equivalently stated, my lord, he was forcefully taken by the BSF camp and he signed forcefully. My lord, he was forced to sign the Caesar list.
But does he say he forced to sign?
My
He
lord,
was picked up, that we see.
My lord.
But forcibly signed, where do we see
Well,
that?
can you see the next page, my lord? Cross-examination, I made all this signature before dawn, this statement was not written by me voluntarily, I wrote this signature on instruction of the BSF personnel, I was stated, if I did not accordingly, I would be implicated falsely in this case,
Acha,
we were picked up by.
was he declared to be hostile? The other witness, others is a witness?
My lord,
Others is a witness, corporate?
my lord.
This is your,
Another thing, my lord, I.
quickly, quickly. What is the other thing?
PW4, my lord.
PW4.
PW4, last, my lord, cross-examination, my lord. My lord, last, my lord. My lord,
Should have flapped the pages.
cross-examination by defense on head, my lord, 20.
Where is the cross examination? We find this. Oh, yes, yes. No, no, we'll find it. No cross examination.
Cross-examination, my lord, by defense on date 24th August 2023, my lord.
Yes. Next page, yes.
My lord.
Page 22 or 20, whatever.
My lord,
Cross examination,
cross-examination.
24th August, yes.
Yes, my lord, not first page, my lord, page 20, my lord. Next page, my lord, page 23, my lord.
Yes.
Portion, my lord. My lord, from the.
Who was he? A Caesar?
Yes, my lord,
member-
last page, my lord,
He
sample.
was a member of the Caesar party. Was he a member of the?
Investigative
Acha, yes,
Investigative.
yes, yes.
The sample were of 24 gram each, but it is true that laboratory report shows that sample received by the laboratory was of 21.3 and 22.2 gram respectively. Two packets of sample were taken for 24 gram each, but laboratory report showing 21.23 and 22.
There may be some discrepancy, yes. Some discrepancy does not vitiate.
Yes, madam. And another thing, my lord, it is true that next page, my lord.
Yes.
My lord, it is true that exhibit 14 gross weight alamat were destroyed 207 kg. It is net weight shown 209 kg. My lord, next, my lord, after some lines, it is true that there is a variation in the weight of the seized alamat with weight mentioned in the inventory report, my lord. There is a discrepancy. If your lord, my lord, there is a 2 point. I want to cite one judgment, two judgment, nothing more, my lord. And he was on bail. There is nothing bad conduct, my lord, or 10 years imprisonment, my lord.
Yes, for judgment site.
My lord, one, my lord. It's your. Well, para 12 and 4. Nothing.
Yes.
My lord, in the instant case also, my lord, there is a discrepancy, my lord. Para 12 and 14 clearly says if there is a discrepancy, the chain of custody of the sample cannot be, my lord, truth, my lord. Para 14, my lord. This Supreme Court judgment, my lord. 12 and 14 and similar circumstances, there is a discrepancy of weight of sample and the conviction was, my lord, set aside, my lord.
What was the material in your case? What was the?
My case was Gaja, my lord. My case was Gaja, my lord. Discrepancy, my lord. Another thing, my lord, there is a, my lord, I have made an arguable case, my lord. My right of appeal, my lord, if I have not on bail, my right of appeal will be infructuous. My lord, can we see another judgment getting suspension of sentence?
There the discrepancy would become half almost. 100 gram, no, 100 gram.
There is a discrepancy, my lord. This silk packet, inventory also showing something, my lord. There is a discrepancy, my lord.
Well, let us hear Mr. Majumdar.
It's also, my lord.
Mr. Majumdar, let us hear Mr. Majumdar, yes. Yes, Mr. Majumdar, what about this? On what point? This is the general finding. In every case, then bail has to be granted. And this was not an NDPS case, sorry. These are unnecessary citations, yes.
Lordship, I will very short, my lord. I will rely on his free judgment to counter Mr. Shahabuddin's submission. My lord, the first thing is whether Mr. Shahabuddin pointing out the evidences of the trial report is permissible at all. My lord, the Honorable Supreme Court in Janardhan Rai versus State of Bihar, my lord, takes paragraph 33 onwards. Easy. Lordship's got it? Internal page number 4, my lord.
Yes.
Bearing in mind the aforesaid principles of law, the endeavor on part of the court therefore should be to see as to whether the case presented by the prosecution and accepted by the trial court can be said to be a case in which the ultimately convict stands for fair chance of acquittal.
Yes.
This is not the case now, my lord. Subsequent paragraph, having regard to the aforesaid settled legal position, we are of the opinion that the High Court has committed gross error in appreciating the evidence already appreciated by trial court at the time of considering the application seeking suspension of sentence pending appeal. So, my lord, what Mr. Shahabuddin wants this honorable court to do, the honorable apex court said it should not be done. So, when the honorable apex court says the evidence cannot be appreciated, my lord, then
Whole Caesar witness says this.
my lord, that will be heard in the appeal. He will fight it out in the appeal. But right now, while granting bail, another regard that he has to mitigate is section 37. And Honorable Supreme Court in Sheru versus and Union of India versus Ratan Malik, my lord, I could not carry the judgment of Ratan Malik. It is referred in this judgment, my lord. What are they?
Have you seen the entire judgment, Mr. Majumdar?
My lord, bail was granted on the consideration of COVID.
Not reflected here.
My lord, it is there, my lord.
No mention of COVID.
However, we are faced, page number 2, my lord.
Yes.
However, we are faced with the unusual times where COVID situation permeates. We
Yes.
are also conscious that this court has passed orders for release of persons
Right,
on
you are
bail.
right. I was wrong. You are right. COVID.
And my lord, if my lord gives me, I will right now produce another judgment, Ratan Malik, where the Honorable Supreme Court has said 37 is a bar, even in granting.
37 is a bar provided the presumption arises. Sole Caesar witness says no, I was forced. BSF took me in the wee hours of the
Right,
morning.
my lord, but that is evidence that your lordship cannot look into right now.
That will consider. Justice Trivedi's judgment will distinguish.
So while Justice Trivedi's judgment says we cannot look into the evidence while granting bail.
We'll quote that judgment and we'll say why it is not applicable. We'll quote that judgment. The relevant portion you have cited, we'll quote that. Mr. Majumdar, you will be probably satisfied after that.
My lord, with any judgment that the Honorable Court passes, we are satisfied. It is not the question of that. It is a mind game, my lord, nothing else.
My expression was wrong. True. Heard learned counsel for the parties. First up, learned counsel for the petitioner submits that although the reverse burden of presumption is cast on the offender in a case under the NDPS Act, in the present case, the sole Caesar witness militated against the prosecution case entirely by vitiating the same in his cross-examination. First up, it is pointed out that in the cross-examination, the sole Caesar witness categorically admitted that the statement written by him on the Caesar list was not written by him voluntarily, but he wrote it on the instructions of the BSF personnel. And he was threatened that if he did not write, he would be implicated falsely in the case. First up, he also said that he was picked up forcibly by the BSF personnel at around 8 a.m. First up, next para, learned counsel for the petitioner cites a judgment, the judgment of such and such, namta dekhe kore deben, reported at 2005 9 SCC 773, where the Honorable Supreme Court observed that if there is a discrepancy in the seized article and the articles which were sent for examination, which were received for chemical analysis, it casts a doubt, and the court cannot ignore such discrepancy, since the credibility of the recovery proceeding itself is considerably eroded if it is found that the quantity actually found was less than the quality sealed and sent to the sent for the forensic examination. Push up next para. Learned Counsel also cites the judgment of such and such reported at 1999 4 SCC 421 for the proposition that if that unless the sentence is suspended, comma, the right of appeal is an exercise in futility and is rendered infructuous. Puts up next para. Learned Counsel, learned DSGI, comma, on the other hand, comma, appearing for this NCB cites Sheru versus Narcotics Control Bureau, where the Supreme Court categorically observed that the stringent provisions of Section 37 of the NDPS Act cannot be overlooked in granting bails under the said Act. Push up, although in the said case, comma, the Supreme Court took into consideration the unusual times prevailing during the COVID situation, comma, granted bail, comma, nonetheless, comma, the proposition as indicated above was categorically laid down. Who's the next para? Learned DSGI further cites Jonardon Ray versus the state of Bihar and another, where the Supreme Court, comma, in similar circumstances had observed that the appellate court should not reappreciate the evidence at the stage of section 389 of the CRPC and try to pick up a few lacunae or loopholes here or there in the case of the prosecution, which would not, according to the Supreme Court, comma, be a correct approach. For sub next para, by relying on the said judgment, comma, learned DSGI submits that the rigor of Section 37 of the NDPS Act should be fully attracted and the prayer for bail rejected. For sub next para, we are fully conscious of the constraints of the appellate court, comma, while granting an order of suspension of sentence and stroke or bail, comma, since one competent court has already convicted the appellant. Push up next para. Seen in the light of the above context, comma, we undoubtedly agree that the appellate court should not reappreciate the evidence, comma, as reiterated by the Supreme Court, comma, at the stage of an application for bail in connection with an appeal and try to pick up a few lacunae and loopholes here or there. Full stop. The regards of Section 37 of the NDPS Act definitely apply, comma, with or without the principle laid down, principle being reiterated in Sheru versus NCB. Push up next para. As such, comma, we are required to look into the circumstances of the present case to ascertain whether the principles as laid down in Jonardon Rai and Sheru Supra apply. Push up next para. The Supreme Court itself, comma, in the judgment of Rajesh Jagdamba Supra, comma, categorically observed that the if there was a discrepancy between the seized narcotic substance and the quantity sealed and sent for forensic examination, comma, the same vitiates the conviction, comma, since it would vitiate, comma, in turn, the process of recovery itself. Full stop. We take note of the fact that the said judgment was also rendered in connection with an appeal against a conviction. Full stop. Next para. Although the principle laid down in Bhagwan Rama Shinde Supra is of a general nature and does not specifically take into consideration the rigors of Section 37 of the NDPS Act, comma, it is well settled that unless suspensions of sentence is granted in normal cases, comma, the appeal may be rendered illusory. Full stop. However, comma, the proposition laid down in the said judgment is too general of a nature to be of importance in the present case. Full stop. Next para. The Supreme Court, comma, in Janardhan Rai Supra, comma, did not categorically debar an appellate court from granting bail in connection with an appeal altogether, comma, which, comma, in any event, comma, would negate the law in that regard. Full stop. What was held by the Supreme Court in the said judgment was that the trial court, that the consideration for bail in an appeal should be that the trial court must have committed some error due to which ultimately the convict stands for fair chances of acquittal. Full stop. Next para. It was further reiterated by the Supreme Court that the appellate court should not double inverted reappreciate double inverted clause the evidence at the stage of section 389 CRPC and তারপর আবার double inverted try to pick up a few lacunae or loopholes here or there double inverted clause in the case of the prosecution. Full stop. The point raised in the present case, comma, however, comma, is not cannot be categorized as a few lacunae and loopholes here or there. Full stop. The arguments made by the petitioner are compelling and indicate that the convict stands a fair chance of acquittal in the appeal. Full stop. The very root of the recovery process is vitiated due to two vital factors. Full stop. First, comma, the sole Caesar witness categorically demolished the prosecution case in his cross-examination by stating that he had not signed the document, the Caesar list voluntarily, but wrote it on the instructions of the BSF personnel who picked the said witness up and threatened him that if he did not write it, he did not sign, comma, he would be implicated falsely in the case. Full stop. Next para. We do not find any recording. Was he declared hostile? We do not find anything in the from the papers that the said witness was declared hostile, and as such, comma, the statement of the witness in cross-examination has to be taken on face value. Full stop. The other aspect of the matter which cannot be ignored is the discrepancy between the seized items, the weight of the seized item, and that which was received for forensic examination. Full stop. If the quantity of the contraband received for chemical examination does not tally with the seized article, comma, that itself throws a doubt on the recovery process, comma, as categorically held in Rajesh Jagdamba Avasti Supra. Full stop. In such view of the matter, comma, we are of the opinion that there is fair chance of getting an acquittal for the appellant in the appeal. Full stop. However, comma, we however, no. As hence, comma, the rigor of section 37 of the NDPS Act does not arise at all in the present case and is vitiated, since the very root of recovery is vitiated. Which of next para, we, however, make it clear that the above observations are limited to the consideration of the bail and shall not and cannot prejudice the appellate court while deciding the appeal finally. Full stop. However, comma, in view of the above, comma, this is CRAN 2, 1. CRAN such and such of 2025 is allowed, comma, thereby granting bail to the petitioner on condition that the petitioner shall not, you are a local resident or somewhere else, shall not leave the territorial jurisdiction of the jurisdictional police station during the entire pendency of the appeal and shall meet the officer in charge, stroke inspector in charge of the said police station once a month, as well as make himself available as and when required by the appellate court. Full stop. The petitioner, the appellant stroke petitioner, shall not in any manner try to influence the witnesses and or tamper with the evidence as well. আচ্ছা, যেখানে বললাম যে granted bail on condition of furnishing bond of rupees 10,000 with two sureties of like amount each, one of whom must be local, to the satisfaction of which court? To the satisfaction of the CJM Kuchbihar. বাকিটা যা আছে।
My lord, on indulgence, my lord. This is not a, this case belongs to NCB. So local police will not have any jurisdiction.
Oh, right. So satisfaction of which? Local police station, he'll meet the whom?
NCB office, zonal office, superintendent.
আচ্ছা, ওসি অফিসার ইন চার্জ অর ইন্সপেক্টর ইন চার্জ অফ দ্য লোকাল পুলিশ স্টেশন যেখানে বললাম তার বদলে হোয়াট শুড বি দ্য এক্সাক্ট ডেজিগনেশন?
Superintendent, zonal office, Siliguri.
সুপারিনটেন্ডেন্ট
Siliguri zonal office.
কমা শিলিগুড়ি জোনাল অফিস
Narcotic control.
কমা নার্কোটিক কন্ট্রোল ব্যুরো এনসিবি।
Grateful, my lord.
থ্যাংক ইউ। নেক্সট। Not completed. We'll direct this. Learned counsel for the petitioner submits that the service on the de facto complainant is not yet complete, full stop. The state is directed to serve a notice on the de facto complainant at the earliest. Full stop, let the matter be listed next on July 31, 2025.
For the de facto complaint, this is the
Let
hearing
the
matter.
application be moved. Hearing matter? What hearing matter? This is a bail.
Hearing.
Oh, then it has to go on. Oh, wrongly then. Learned counsel for the parties point out that the matter is ready for hearing. So let the matter be listed under the heading, under the appropriate heading for hearing of the appeal. Thank you. Next.
Twelve is main petition, my lord. And 13 and 14 is kind of this is the base.
What is the matter? Mister? If you're led by the court, that would be the first ground of rejection of. Yes, Mr. Banerjee, we can't see Mr. Banerjee. Item 12, who is there? So, it's similar, the consideration is similar. So we'll hear the Mr. Banerjee, yes. Mr. Banerjee is not there online. We are de facto complaint is appearing.
No, my lord. De facto
Oh,
complaint is not appearing.
Learned counsel for the all these matters, I think all these matters arise in connection with the same proceeding and are taken up together. Push up learned counsel for the petitioner in CRA CRADB 1 of 2025 fairly points out that service on the de facto complainant is not yet complete. Full stop. Accordingly, the state shall ensure that such service is effected in respect of the matters at the earliest. Full stop. Let the applications be listed together for hearing on July 31, 2025. Thank you. Next. 31st July. ডিবিবি আচ্ছা ডিবিবি ওটা হ্যাঁ ডিবি হাইফেন বি হবে শঙ্ককে একটু বলে দাও শঙ্ক আগেরটা শেয়ারের নাম্বারটা ডিবি হাইফেন বি ওয়ান অফ ইয়েস 15 হুইজ অ্যাপিয়ারিং রাইট
One was lost by the appellant, and another was lost by the de facto complainant, the wife of the deceased.
One was lodged by the appellant.
One was lost by the appellant.
Acha, against your wife.
Against the deceased and the son of the deceased who claims to be the eyewitness.
Deceased is your wife?
No, my lord.
Somebody else?
Somebody else. The wife of the
What is the offense? Murder?
Murder, my lord.
State is appearing, Mr.
না এটা অন্য কিছু চলছে
Who is for the state? You're appearing. Yes. Please continue. Two counter complaints were lodged.
Yes. One was registered at the behest of the appellant and the other was registered at the behest of the wife of the deceased. And
What was your allegation?
My lord, I said that the deceased along with his son, PW3, came to my house. It is admitted fact that they came to my house. They assaulted me. The PW3, the son of the deceased, accidentally hit his father and he died. This is my
There was a scuffle. His own son hit him. His own son hit him.
My lord, this is my defense.
What was the age of the son?
And it's 24 years.
Very well. Then, but you have been convicted ultimately on consideration of evidence. Why should we grant you bail at this stage?
Kindly see the date, the PW number 1, the wife, de facto complainant, says her husband died on 14th November.
Yes.
Kindly load, my lord.
Yes.
The de facto complainant, the wife.
Which year?
24th November 2022.
2020?
2022.
Right. Then?
PW1, the wife of the deceased.
Understood. Yes. Please proceed.
My lord, PW3, the son of the deceased also says the deceased died on 14th/11/2022. But surprisingly, the investigation reveals that the deceased died on 19th/11/2022. First and foremost, my lord.
So when did the offense take place?
14th/11/2022.
Very well. He was taken to hospital or something?
My lord, he was taken to hospital
Hospital.
allegedly by the PW3, the son of the deceased.
Acha.
My lord, kindly see the exhibit 5, the
What?
injury report.
What does it say?
It says the deceased was admitted on 14th/11/2022
Ah.
at about 18.16 hours. It means 6 p.m.
Yes.
But the PW3, the son of the deceased, says that the deceased was admitted to hospital at about 4 to 4:20 p.m. That apart, my lord, the deposition of the doctor who prepared the injury report, that is PW.
What does he say?
It's, my lord, kindly have a look for a moment, my lord.
Is it
It's
annexed?
very peculiar. It's
Acha.
very peculiar.
Is it annexed here?
Maybe with the main application or with the judgment copy.
You should have prepared copies of this. Since you have a copy, why didn't you prepare copies for the convenience of the court? It always makes it easier for the court. Just
No.
tell us what he said.
My lord, it says on 26/11/2023. It may be a typographical error. 2023. He examined a patient. How could he examine a patient if the said patient either died on 14th or died in 19th?
He said 26th he examined.
Oh, he says in evidence on 26th he examined the patient.
Understood, yes.
Bhavesh Vishwakarma, which cannot be done.
The death certificate shows
No,
the
my lord, there is no death certificate proved by the prosecution agency. There is
postmortem report says
no postmortem
date of
report is
death.
there. Postmortem report is
Date of the death is 19th.
19th. Postmortem report is there.
20th বলছে
2011.
2011
No.
তাহলে তো আরো
Postmortem was done on 20th.
Inquest was also conducted on 20.
No, the death occurred on 20th. The postmortem took place on 20th.
Postmortem and.
Date of death is 19th, you were saying.
Well, one says the investigation says it was on 19th, and the alleged eyewitness, the wife of the deceased,
14th. Both say 14th.
both says on 14th. That apart, my lord, the PW3, the son of the deceased, says the victim was taken by one Buddha Tamang in his vehicle.
Yes.
In the entire investigation, there is no such vehicle has come out. Either the deposition of Buddha Tamang says that the victim was allegedly taken by the said vehicle. There is no recovery of such vehicle.
What about the doctor's examination?
My lord,
2611.
we have been, my lord, supplied a copy, my lord, without having any annexure, my lord. Only the application of the friend has been supplied. There is no annexure with regard to, my lord, the impugned judgment as well as, my lord, the.
No, the CRAN does not carry any annexure. That's why you have been supplied. We also don't have any annexure.
My lord. My lord,
So
second,
you must have the records. I mean, regarding this doctor's evidence, we are the other two maybe 1411 also. PW1, PW3, the 1411 he died.
That he was admitted in hospital on.
My lord, that apart, my lord,
After discrepancy, minor discrepancy.
doctor,
How long you were in custody?
2 years.
Early হয়ে যাবে।
I'm in custody for
Early হয়ে যাবে।
2 years, 8 months, 13 days.
The doctor said in his evidence that he was admitted in 14th. It must have been an error, technical error, 26.
My lord, this doctor has not conducted the treatment. The treatment was conducted by someone else, the Dr. Anup, who has not been examined. And the document showing that the disease was admitted has not been brought into the record. It is the only injury report which has prosecution admitted.
If you say this doctor has not examined, then his evidence that he has examined on 2611 cannot be of any importance.
My lord, the injury report which has been annexed, which has been marked as identification, says otherwise দাদা একটু আমাকে দিও এটা
What otherwise? Date of death is 19. That is corroborated by everything. These are minor discrepancies. Will be looked into at the appeal, not at this stage. In the appeal, it will.
ready with the appeal. I am ready with the appeal hearing.
We'll
I'll
direct
fix it on any day. my
No,
lord.
no, the paper books have been
Trial
prepared.
court record has already reached, my lord, is about to be, my lord, the paper book is about to be.
We'll
That-
we'll direct
kindly
that.
Consider the,
We'll direct that.
kindly consider that the alleged offending people has not any
Yes,
such
yes.
report.
Learned counsel for the petitioner raises several questions in support of the application for grant of bail during pendency of the appeal. Which of the appeal is against a conviction, inter alia, under section 302 of the Indian Penal Code. First, it is argued that the wife of the deceased within bracket PW1 and the son of the deceased bracket PW3 both stated that the victim died on November 14, 2022, whereas the death occurred as per the medical reports, on November 19, 2022. Secondly, from the injury report, it is evident that the victim was admitted on November 14, 2022 at 6:16 p.m. 6:16 p.m. in the hospital, whereas PW3, the son states that the admission took place between 4 and 4:20 p.m. Next para, apart from that, the injury report indicates that the deceased was examined on November 26, 2023, which is not corroborated by any of the other witnesses. Moreover, if the victim died on November 19, 2022, there could not be any occasion of his being examined by a doctor on November 26, 2023. এটা কিন্তু 2023, অন্যগুলো 22. Next para, thirdly, it is argued that the plaintiff's, the deceased, the son of the deceased within bracket PW3, stated in his evidence that the victim was brought to the hospital in the vehicle of one Buddha Tamang. However, the vehicle was not produced or seized or recovered. Next para, lastly, it is contended that there was a counter complaint lodged by the appellant against the deceased, which was never taken into consideration. The prayer for bail is vehemently opposed by the state. Learned counsel for the state points out that the injury report shows that there were multiple injuries, and upon conviction, at this stage, it would be premature for the appellate court, while considering a bail application, to reappreciate the entire evidence. Next para, the discrepancies pointed out by the petitioner do not, in our opinion, bring out something which is so palpable that the court, while considering a bail application, will reappreciate the entire evidence before hearing of the appeal. Insofar as the chain of events are concerned, it is borne out by the evidence that the offense took place on November 14, 2022, and the demise of the victim took place on November 19, 2022, as borne out by all the medical documents as well as the injury report and the post-mortem report. Next para, the minor discrepancy in the PW1 and PW3 stating about the date of death erroneously does not matter so much that it would vitiate the entire trial. Moreover, the non-recovery or production of the vehicle in which the victim was brought to the hospital is entirely beside the issue. There might have been some discrepancy in the statement of PW3, the son of the victim, as to the time of admission, with that shown in the injury report. However, such minor discrepancy is only but natural in case where the witness speaks truth. Moreover, the paraphernalia involved in admitting an injured person in a hospital might take some hours, thereby mitigating the doubt sought to be cast on the difference of time between the PW3 apostrophe S version and the injury report apostrophe S version of the time of admission. Full stop. Also, comma, counter complaints do not by themselves, comma, uh, form a material part of the evidence so as to vitiate a conviction which has been handed out by a competent court. Full stop. Next para. The uh, mention of the examination date of the victim as November 26, 2023 is obviously a stray aberration, 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 comma, inconsistent with the entire body of evidence and, comma, as such, comma, cannot be looked into for for considering the merits of the appeal at this premature stage. Full stop. Thus, comma, we are unable to consider the benefit of bail to the appellant at this stage. Full stop. Next para. Accordingly, CRAN 1 of 2025 is dismissed. Dismissed. Full stop. Next para. However, comma, we direct that the paper books shall be prepared at the earliest, comma, preferably within 3 weeks from date, comma, keeping in view that the trial court records have already arrived. Full stop. Liberty to the appellant to mention the appeal for inclusion in the list before the appropriate circuit as and when the same is made ready for hearing. Next. Next. Please give both all of your names.
My lord, I appear on behalf of the petitioner.
Yes, what is the matter?
Section 6 of the POCSO Act. my
Right,
lord.
right.
My lord, in the when the FIR has been lodged by the VG, she was 18 years of age, my lord, and the accused is of 21 years of age. My lord, in the deposition of the VG, it is evident that she has been raped from. She told that she has been raped from 2015 to 19, but no eyewitness is there of this evidence, my lord. Regarding pregnancy also, my lord, no medical report has been seized. My lord, in the FIR, she has stated that Shubham, that is the accused, present petitioner, taken to NBC hospital, Kodgupta hospital for diagnosis, my lord. But no medical documents from the Kodgupta hospital as well as
Diagnosis of pregnancy.
my lord,
Diagnosis of pregnancy.
no medical report has been seized, my lord. My lord, rather, in the deposition, she has stated, my lord, I am reading, on 14/8, year has not been mentioned. I visited temple with my friend. When I came back to my house, I was started vomiting. Since I was vomiting, that is why my parents took me to hospital. In the statement, she is stating her parents took her to hospital. In hospital, doctor gave me the medicine of stomach pain, my lord. Kindly note that one, stomach pain. When I came back to my house, then miscarriage was happened. No medical report has been seized regarding this.
FIR was lodged after the alleged pregnancy. FIR was lodged in which year?
2019. My lord, FIR date I am telling. Lord, 17/9/2019.
When did she become 18? Turn 18?
My lord, that time only, my lord, in the forwarding only.
So at the time of the offense, as per her allegation, she was a minor. That's why POCSO.
Before 5 years,
Section 6.
my lord, no sufficient ground has been mentioned for delay of lodging of the FIR.
Right. Yes.
My lord, and furthermore,
We are satisfied. Yes.
officer,
Mr. Chakravarti, you are granting bail.
My lord, I have objection in this case, my lord, because this is not a case of love and affairs. If my lord goes to the
2015 to 2019,
it is a case of 4 years. Said ki 2015 first it happened.
continuous.
And it's continuous. But thing is that both of them, they said ki their love.
We are
and
not saying
affairs.
people may not have love between themselves, but their sexual activity may be consensual. Need not require a love to be there. Love is a many splendid thing.
Both of them denied, my lord. When they were asked, my lord, even the.
May not have an affair, but they consensually agreed to a sexual act for 4 years,
my lord, and
16 to 18.
also been there. The
No? No,
medical report, my
no. What is there?
my lord, in medical report, I
No
found
injury.
evidence of recent
Don't have to complete all your sentences. Just give our answers.
injury in the private private parts.
Very good.
It's sufficient.
Maybe.
It's an admission, my lord. If there is an injury in the private purse, it cannot be a consent date.
No injury.
Learned counsel for the petitioner submits that there are several mitigating circumstances, full stop, when the victim girl lodged the complaint, comma, she was already 18 years of age. Although the offense on which the appellant stroke petitioner has been convicted is primarily under section 6 of the POXO Act. Full stop, next para, that apart, comma, allegedly the offense took place between the years 2015 and 2019, but the complaint was first lodged in 2019. Full stop, next para, it is further submitted that no medical report regarding pregnancy was brought on record, although there was an allegation that the pregnancy prompted the complaint. Full stop, moreover, comma, there was no eyewitness of any of the alleged acts of offense. Full stop. The case of the victim girl was that she had visited a temple and returned to her house when she started vomiting. Full stop. Her parents thereafter took her to the hospital where, according to her, comma, medicine for stomach pain was given. Full stop. When she returned home, comma, she had a miscarriage. Full stop. In the absence of any evidence in that regard, comma, it is argued that the appellant stroke petitioner has made out a sufficient case for acquittal in the appeal. So that apart, comma, the injury report does not, the medical report of the victim also did not show any injury commensurate with section 6 of the POXO Act. Full stop, learned counsel for the state vehemently opposes the prayer for bail and points out that in the circumstances, comma, the learned trial judge was justified in convicting the appellant, and a presumption, a reverse burden of proof is imposed under the act itself. Full stop. While considering the mitigating circumstances, comma, we find that even from the records, it is evident that the victim girl's version is that the offense was perpetrated during the years 2015 and 2019. Full stop. At the relevant juncture when the complaint was lodged, comma, the age of the victim was 18 and the age of the appellant stroke petitioner was around 21 years of age. 21 years. Full stop. Next para. Keeping in view the above two circumstances, comma, the element of consensuality and strong probability thereof cannot be ruled out. Full stop. Although both sides, comma, as pointed out by the state, comma, have denied amorous, AMOROUS, relationship, comma, there need not always be an amorous relationship to substantiate the consensuality of the sexual activity between two persons. Full stop. Next para. Moreover, comma, the discrepancy in the allegation of pregnancy and absence of any direct proof of the offense by way of injury marks, comma, etc., also points out towards a fair chance of acquittal uh, for the appellant stroke petitioner in the appeal. Full stop. Thus, comma, keeping in view the above mitigating circumstances, comma, particularly the nature of the allegation that the act alleged continued for 4 long years between people who were respectively 18 and 21 at the time of the complaint, comma, we are of the opinion that there is sufficient doubt cast in order to mitigate the reverse burden of proof under the POXO Act. Accordingly, the benefit of doubt is given to the petitioner. CRAN 1 of 2025 is allowed, thereby granting bail to the petitioner on condition that he furnishes bond of rupees 20,000 to rupees 10,000 with two sureties of like amount each, one of whom must be local. Full stop. During the entire pendency of the appeal, comma, the petitioner shall not leave the territorial jurisdiction of.
Quite difficult.
Where do you live?
Cash
Where do you live? You are a people of the person of the locality.
tea garden.
He is a tea garden labor. You said he's a student. He studies also in a college.
My lord, he's a student of class 12, but he stayed as tea garden quarter, my lord.
Even the local shoot is required, my lord, this district, my lord.
POXO is serious. One local surety have to apply. One of whom must be local. Full stop. Next para. shall not leave the territorial jurisdiction of his residential police station apart from attending the court, comma, if and when so called by this court. Full stop. Next para. Acha, territorial bond to the satisfaction of. What is the POCSO code?
Section of learned judge special court under POCSO Act Shiliguri. My lord, may I write down and
To the satisfaction of the learned judge special court POCSO Act at Shiliguri. আর তারপর যেটা বললাম যে সেন্টেন্সটা তারপরে হচ্ছে the petitioner shall not comma in any manner comma try to contact or approach the victim girl comma her family and or any of the witnesses and or attempt to intimidate or influence them in any manner whatsoever. So the petitioner shall not try to tamper evidence in any manner during the entire period of the pendency of the appeal. Next. Thank you.
affidavit of service.
প্রথমে একটা এফিডেভিট অফ সার্ভিস ফাইল করে দেব। নেক্সট।
Lord, we have served upon the victim girl, my lord, it has not yet reached.
It is submitted by learned counsel for the petitioner that the service has not yet been completed on the de facto complainant. First of the state shall ensure that such service is completed at the earliest. The matter shall next be listed on July 31, 2025. Dr. Chaudhary, anyone else appearing with you, just give the appearance. Ask somebody to give the. Yes. The state also in the previous matter.
Lord, I'm for the appellant in item number 18, my lord.
Yes, Mr. Mukherjee. What
Your
is it?
lordship,
Yes.
it's a case, my lord, which is built on entire case. When I've gone through it, subject to corrections, my lord. The offense which has been committed when the FIR was lodged was section 10. Right, my lord? Thereafter, my lord, when the charge sheet was filed, it was filed under section 10, read with section 85 of the Juvenile Justice Act. Well, before I go, well, I don't know whether the victim girl has been informed or not. My junior can say that, my lord.
Served. Yes, Mr. Mukherjee served and affidavit has
Grateful,
been
man.
filed.
I'm grateful, man.
Yes.
So, my lord, what happened thereafter, my lord? Charge sheet was filed in those sections. Charge was framed under section 6, read with 10 and 85 of the Juvenile Justice Act. Right, my lord? This relates to a lady, 14 years of age, who has a disability. And there is provision under the Justice Act for disability, as well as in POSCO. Now, my lord, on the present petitioner before, or the appellant before lordship, my lord is a teacher. And he was an expert in teaching disabled children. Right, my lord?
Right.
Now, this gentleman allegedly, but I'm using the word allegedly,
Yes.
pinched, my lord, the word in the medical report is he pinched the girl just on her breast. That is the medical report. There is no evidence of penetrative sexual assault.
No, pinched on the breast is the allegation where in the complaint.
Yes. And medical says the same.
What are you saying? Then why are you appearing in the matter? There must be something wrong since you are appearing, Mr. Mukherjee. Then your presence is not justified. Justice Kumar says it's a very fundamental question.
I'm grateful. But then he has the other side then. And the medical, your lordship will see.
Same. Yes. What is this? Section 6.
Of section 29, where the presumption lies upon the victim of accused that is innocent or not, and the 161 and 164.
Section 6 has been clubbed.
Yes, but
convicted of section 6.
Yes.
The depositions of the victim is slightly contradictory to the medical report. What he has said in 161 and 164.
Should we record that Mr. Mukherjee's presence is not justified? Should we start with that, Mr.
Yes, please. Grateful to your lordship, sir.
Affidavit of service filed today be kept on record. First up, it is seen that the de facto complainant has been served. First up, next para. The learned senior advocate appearing for the petitioner argues that although Section 6 has been clamped against the petitioner, along with Sections 10 and 18 of the Juvenile Justice Act, the allegation under Section 6 of the POCSO Act is not at all corroborated, since the complaint itself, as corroborated by the medical report, indicates that the allegation was merely that the petitioner, who is a teacher, being an expert in teaching the physically challenged persons, pinched the victim girl, who is herself physically challenged, on the breast. Full stop. Next para. There also transpires to be some discrepancy in the prosecution evidence, which raises a fair chance of the appellant stroke petitioner being acquitted in the appeal. Full stop. Accordingly, we intend to grant the benefit of bail to the petitioner. Full stop. Cran 1 of 2025 is accordingly allowed, thereby granting bail to the petitioner on condition of furnishing bond of rupees 10,000 with two sureties of like amount each, one of which whom must be local, to the satisfaction of which court, Mr.
Special court, Darjeeling, I think.
Darjeeling, very.
Yes.
We'll do. Special court, bracket POCSO, Darjeeling, POCSO Act, Darjeeling. We'll do that at the end. Just let us complete this. The petitioner shall not in any manner attempt to contact and or approach the victim girl and her family and or the witnesses and or influence or intimidate in any manner throughout the pendency of the appeal, and shall make himself available as and when so required by this court. For some next para, the petitioner shall not also attempt to tamper with the evidence in any manner throughout the said period.
CCTV footage.
প্রথম লাইনে যেখানে বললাম at the outset, learned counsel for the state vehemently opposes the prayer for bail. Thank you, Mr. Mukherjee.
I'm grateful, man. I'm really grateful.
Thank you so much. Yes. Mr. Lakshman, give all your names. Give all your names, yes. 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 Criminal appeal. You are against acquittal or? Why is it appearing as an admission of criminal appeal?
Well, it's supposed to come under the heading of that.
Do we formally admit the appeal first?
Well, it does not require.
What is done, we don't know.
Well, your lordship kindly direct the state to call for the case diary. And
No, there is no application with us.
it's an appeal. It's supposed to be come in the form of an appeal.
Acha.
Kindly seize the section 4.
একটা দিন for admission বলে দিচ্ছে section 14, yes.
8 of the STSC Act. The offences are under the STSC Act.
14?
A.
14A, yes. Oh, the appeal.
Yes.
Appeal
Mail change. Well, it's any application with.
That says an appeal shall lie.
Yes, yes.
Yes.
So let the case diary be called for, and
We'll admit the appeal. We'll admit the appeal. Issue usual notice of the usual order in appeals. Same. That will suffice.
Generally, what happens in such type of cases, the appeal itself can be allowed on the admission stage. If your lordship kindly.
No, without looking into the records, definitely. No. This is item 19.
My lords. And a defect has been shown.
No, sections 302, 376, these are also.
But there is STSC Act.
You belong to the SC category?
No, the victim.
This 376, 302 are also there.
Yes, but as because there is a STSC Act.
Yes.
I cannot come with the general application. I have moved general application that has been turned down. If your lordship kindly comes to the annexure P1. It's in page 9, the observation of this honorable court.
That says it has to be presented before the division bench.
Yes.
So how does it justify what you're now saying? How can an appeal be treated to be an application? Bail application was directed to be placed before the division bench.
And that will become through an appeal. If your lordship kindly sees the act for a moment.
Where does it say that?
My lord, it's
We
very
don't find
simple.
anything of that, sir.
My lord,
Which provision?
my lord, A
Yes.
clause 2.
An appeal shall lie.
My lord, last slide.
That is against an order of the special court, granting or refusing bail.
Bail.
He-
I'm asking for bail.
Here you are challenging an order refusing bail.
Yes, your lordship.
Oh, sir, we do not understand. We thought it was against conviction.
No.
Acha, oh, you are challenging Justice Chatterjee's order.
Yes.
Ah, very well. What is the ground of challenge?
But it's that. If
No, it has been dismissed only on the ground. It should have been gone before
Yes,
division bench.
yes, yes.
So actually, you're renewing that prayer on merits.
Yes.
What is your ground?
Well, it's until and unless the case diary comes, I think.
Oh,
Well, it's kindly
you are
appeal
appealing for the state.
Day after tomorrow.
Let the matter be. No, there's a condonation. There's a delay of
Yes.
153.
That I will explain, your lordship, what has happened.
Make a one-page application at least.
Well, I have filed this application with a view that the bail should lie, but subsequently it reflects when I have been briefed that bail should not be lying. Thereafter, when we moved before the single bench. the
Give a
single
one-page.
bench-
Make a one-page application. In the meantime, let the case diary come.
That's-
Uh,
Day after tomorrow. I will be
Leave is
filing
granted to the petitioner to file an application for condonation of delay and serve a copy thereof on the state. Full stop. The the state shall produce a case diary on the returnable date. Full stop. Let the matter be listed on July 30, 2025.
Well, it's how many days delay? What have stated, how many days delay?
153.
One. Great, your lordship.
এই বইটা ফেরত বইটা ফেরত দাও। এই বইটা আনি রাখতে হবে, হ্যাঁ? SC ST অ্যাক্ট বললেই হবে।
Lordship, item number 20, I am paying for one accommodation.
An adjournment is sought on behalf of the appellant. No, before go to the next bench.
Whether defect has been cured or not.
What are the defects?
Lordship, there is no defects, Lordship.
দেখি।
Defects in the certified copy, date in the certified copy, so that not be cured, Lordship, as your Lordship stated.
Oh, that has to be sent down.
Yes,
Acha, very well. You are asking for a day's adjournment.
day after tomorrow.
An adjournment is sought on behalf of the appellant. Full stop. Let the matter stand adjourned till the next circuit. Next.
Grateful.
21, who's you are for the appellant? Yes. Lost in both courts or one court? Lost in both courts or one court? This is a second appeal.
Second,
You lost in both the courts or one?
both
You are the plaintiff.
the plaintiff.
Suit for?
Declared
Why dismissed?
Dismissed
On what ground?
Document has not been produced at the time of the evidence, but the certified copy of the document as relied by the petitioners in their suit, that has been exhibited. But only on that ground that the suit has been twice dismissed. In the trial court and also the first appellate.
Was the finding of the appellate court? First appellate
Finding
court?
of the appellate court is the same as like the,
Acha, yes, that's why you are wanting to see only one court. This was the appellate court, last court.
please, take the.
Oh, suit was ex parte.
Expert.
So you did not comply with the provisions of the Evidence Act to show why you did not have the originals?
Lordship, original document.
Let us
has
see.
been,
Preliminary admission. So far as
the original documents has been destroyed. This is the plea of the petitioners.
Acha, let us see.
That's why the certified copy has been produced before the court.
Mhm.
And that has been exhibited also.
All of those documents you produce certified copies? No, it also says that you have not proved Heromonath expired on such and such, substituted in suit and all those things.
that from him, my solicitor has purchased the property in the year of.
What is this suit in which you have not proved that you were substituted or something like? Certified copy time main ground here. Also that there was no partition or something like that.
Yes, partition was not there.
So if there is no partition,
Name- Petitioner, their name has been inserted in the record of right. By specifying the.
if there is no partition by meets and bound, how can you claim exclusive title? That is also one of the grounds. Nothing on record that the aforesaid properties comprised in plot number such and such got partitioned over the kosher. Even if you go by your title deed, your predecessor's title deed, if there is no partition, you cannot claim exclusive title in respect of a particular portion. That is a valid ground. Others are co-sharers have to be brought on record and you have to claim for a share. You have claimed exclusive title.
Registered.
Your predecessor had that registered. It's an admitted position. There are other co-sharers. You rely on the mutation certificate and other documents to show that separate, but mutation does not tantamount to. So dismiss the appeal on that. Learned counsel will record your arguments.
Material is there. Let it be.
No, substantial question of law has to be there. Not in a first appeal, that would be a good consideration, but not in a second appeal. Learned counsel for the appellant argues that learned judges of both the courts below substantially erred in law in refusing to rely on the certified copy of the title deed of the predecessor in interest of the appellants, comma, despite the said document having been duly admitted in evidence and exhibited. Push up. It is contended that separate mutation certificates and all other documents have been produced to show the exclusive assertion of title and possession of the plaintiff stroke appellants in respect of the suit property, and as such, the courts below erred in law in dismissing the suit. Push up next para. Although the appellants might have a valid question to raise with regard to whether the certified copy of a deed of the title deed of their predecessors, comma, having once been admitted in evidence upon satisfaction of the admissibility and having been marked as exhibits, comma, could not could be refuted by the courts, comma, we are not satisfied that there is any error in the concurrent findings of both the courts below, that in the absence of anything to suggest that there was ever any partition by meets and bounds among the co-sharers, comma, the suit in its present form, comma, seeking exclusive title over a portion of the property by the appellants could be decreed. First up, it is well settled that unless there is a partition by meets and bounds, comma, either by a registered deed and or a decree of court, comma, mere mutation in separate names does not tantamount to partition. First up, we also do not find any reference to any particular oral settlement or mutual arrangement between the family arrangement between the parties as reflected from the judgments. First up, hence, comma, although the learned courts below might have erred in not giving appropriate credence to the title deed of the appellants, comma, just because a certified copy of the same was produced, comma, the courts below were justified in dismissing the suit on the ground that it was not maintainable in its present form, comma, in the absence of any proof of a partition by meets and bounds between the co-owners. First up, accordingly, there is no scope of interference and we do not find any substantial question of law to be raised. Hence, SAT 02 of 2025 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Pushed up. Bas, this much. Can 2 is there. Can 2 of 2025 is consequentially dismissed as well. Can 3, what is Can 3?
Substitution.
Substitution? No, Can 3 is something else.
Of the respondent. Original respondent.
After passing the.
Substitution has not yet been allowed. Substitution filed within time.
No, limitation petition is also there.
No, the substitution application was not filed within time.
Lordship, after passing the judgment by the appellate court, during this particular period that the original defendant died. At the time of institution of the second appeal.
Before the institution of the appeal and the passing of the first appellate court degree.
Yes.
In the meantime, he had died. প্রথমে যা বললাম তার উপরে করে দাও। Since the deceased, who died?
Original defendant. Lordship.
What is the respondent number? Party.
Bhavani Chetri was the original defendant.
As a can two of since the original defendant late Bhavani Chetri alias Bhavani Prasad Chetri died in the interregnum between the filing of the present appeal and the passing of the impugned decree, comma, can 3 of 2025 is allowed, comma, thereby granting leave to the appellants to proceed with the appeal against the present respondents. তারপরে বাকিটা যেটা বলে can two we allow permit you to prefer the appeal against the respondents because they died in the meantime and then dismiss it. What is can 4?
Can 4 is the continuation of it.
Of
Substitution.
তাহলে তার আগে দিয়ে দাও in view of in view of sufficient. None of the applications have been allowed.
It has not been heard. There was some defect that has been rectified.
Regarding the section 5?
Section 5 has not heard.
You are saved. Learned counsel for the appellant shall serve copies of all the applications on the respondents, indicating that the matter shall be returnable before the appropriate division bench in the next circuit when an affidavit of service shall be filed by the appellants. Thank you. You are saved.
If you are.
Yes, obviously. We'll continue. May continue after recess also today. None appears for the parties. Let the matter be adjourned till the next circuit. Same. Yes. Just in time, otherwise next circuit. Oh, that's gone. Yes. 24.
Item 24, Mr. Ghosh is up, on his legs in court number 2.
At least you get a not today. On the prayer of the appellant, the matter is adjourned for the day.
Passover Lordship, he will be
No passover. We'll take up the death references. Give your appearances. 25. রেজিস্ট্রেশন অ্যাপ্লিকেশন অ্যাপিয়ার করছেন সেকেন্ড ডে আজকে This is the second occasion when none appears to move the applications. First of, we find from the records that can 1 of 20, that can 2 of 2020 is an application for restoration of the appeal, and the connected can 1 of 2019, and can 3 of 2020 is an application for condonation of delay in filing the same. First off, it transpires that the appellants are habitual defaulters, since not only was there a delay in filing the restoration application, the appellant remains consistently absent. Appellants remain consistently absent at the time of call, even to move the restoration application and the connected condonation application. Push up, since this is the second such occasion, we give a last chance to the appellants stroke petitioners to move the applications. Pushed up in default, appropriate orders will be passed in the absence of the appellants. Yes. Restoration within time. Why didn't appear?
I was
Another court.
my landed senior was in another court, but I was in leave. One of my relative were deceased.
Achha. We will go by you because the other ground is not a good ground. Order 17. Where is the order? Achha. Since none had appeared for the respondents when the appeal was dismissed for default, we apply the principle of Order 9, Rule 4 of the Code of Civil Procedure, read with Section 107 of the Code, thereby dispensing with service of notice of the application on the respondents, in view of sufficient reason for the absence of the appellants having been appellants on the relevant date having been made out, can 1 of 2025 is allowed, thereby recalling the order dated June 13, 2025, whereby SAT 8 of 2025 was dismissed for default and restoring the said appeal to its original file and number. The matter be, are you ready with the order 41 or no? The matter be placed under the heading Order 41 Rule 11 of the Code of Civil Procedure before the appropriate bench in the next circuit.
Okay, good.
Thank you. The learned advocate and record for the appellants shall defect the shall cure the defects in the meantime. Please check up the defect and do it. Preamble some defects. You will get time. You can do it later. You can write. Yes. 20. Yes. Filed within time, within 30 days. Filed within 30 days of the dismissal. Very good. Yes, within time. What was the reason for the absence?
And my senior was also out of station also.
Very good. আগের যে অর্ডারটা হলো তন্ময়
14 May.
one minute. May, the matter was adjourned and directed to appear on the next.
And he placed in this book. And next, case listed 30 June 2020. And on that day, I am
Appeal ready হয়নি hearing এর জন্য। Why was the appeal appearing in the first place? Why was the appeal appearing in the list? First appeals are not required to be formally admitted. It was appearing under what heading?
Social landed book, when I come to know the signature of testator is down, then I have made an application for verifying the signature of the
Since the application has been made
for the order.
within time and none appeared 30th June 25. হ্যাঁ ওটা কেন দেখবো হ্যাঁ সেই জন্য তো রাজশেখর ডাইরেক্ট করেছিল যেত হ্যাঁ তারপর ও ডিসমিস করতে হবে দ্যাট কারেকশন এখনো তো এফেক্ট হয়নি না বলছি কমিউনিকেট করেছে সার্টিফিকেট বলছে কারেক্ট করে দিয়ে এখনো কারেক্ট হ্যাঁ না ও তো দেখি তারপরে বলছে রিসিভ সার্টিফিকেট অরিজিনাল স্যুট নাম্বার রেস্টোর করতে দিন এখানে বলছে যে রিসিভ করেছে কপি রিসিভ করেছে তো কি what should have been the correction? Title suit number 2, it is not original suit number 2. এখানে বলছে রিসিভ সার্টিফাইড কপি অফ দ্য সার্টিফিকেট অফ অরিজিনাল সুট নাম্বার সাচ এন্ড সাচ সেন্ড ডাউন করতে হবে হ্যাঁ সেন্ড করতে হবে সবে বেরোল Since the application has been filed in time and none appeared for the respondent on the date when the appeal was dismissed for default, we take up the application ex parte by applying the principle of Order 9 Rule 4, read with Section 107 of the Code of Civil Procedure. Full stop. Since sufficient reason for the absence of the petition appellant on the relevant date has been made out in the application, can 1 of 2025 is allowed, thereby recalling the order dated June 30, 2025, whereby FAT 9 of 2025 was dismissed for default and restoring the said appeal to its original file and number. Full stop. Let the certified copy of the impugned judgment and decree be sent down to the trial court in terms of the order dated May 14, 2025, passed by a coordinate bench for the purpose of effecting the necessary correction. We have restored the appeal, sent down. Justice Rajshekhar Mantha's division bench had sent down original suit. It will be sent down. We have restored the appeal. Yes, next. দেখি the appeal has been এটা তো ডেথ রেফারেন্সটা অ্যাডমিশনের দরকার লাগে না the present matter arises out of a death reference within the contemplation of section 366 within bracket 1 of the Code of Criminal Procedure. Full stop. The issue usual notices, the records be called for. Full stop. Paper books be prepared in the matter within 4 weeks from the arrival of the trial court records. নোটিশে চলে এসছে উইদিন 4 আচ্ছা লাস্ট সেন্টেন্সে যেটা বললাম পেপার বুকস বি ওটা সিন্স দি ট্রায়াল কোর্ট রেকর্ডস হ্যাভ অলরেডি কাম টু দিস কোর্ট কমা আচ্ছা তাহলে প্রথমটা কেটে দাও দ্য প্রেজেন্ট matter arises out of a death reference under section 366 within bracket 1 CRPC. Both of you are appearing in this matter for the next matter. Full stop, since the trial court records have already arrived, comma, the paper books be prepared within 4 weeks from date. Full stop, issue notices, issue usual notices. Very well, thank you. The High Court Legal Services Authority shall ensure that the appropriate legal representation is given to the convict in connection with the above matter. Full stop, a copy of this order be communicated to the district legal services or to the High Court Legal Services Authority at the earliest. Eta ekটু communication ব্যবস্থা করতে হবে. Thank you. Next. Yes. Dr. Chaudhary, be very precise. You have gone to the judgment. Highlight the points. Have you prepared the written notes?
Yes.
So file it. And if you have to cite any judgment, cite those. We want to reach at least one more death reference.
I'll be taking your lordship in brief with.
Don't take us through anything. Just point out what are the. Yes. Page?
13, last page 97.
Yes, 313.
But here, the accused was asked whatever he wants to say.
Explanation, yes.
Yes. To that, my lord, he says, I am, my lord, a story comes up, my lord, before the learned trial court. I am innocent and falsely implicated in.
Yes, matrimonial life, mama, discord, matrimonial discord and all. And this is one of the grounds of sentencing you to death. That you are mature enough and all those things.
He says that on that fateful day, my lord, there were two unknown persons in the house.
Yes, in the he insinuated that they were in the room of mummy. Mummy came, asked for water. Mummy refused. When they came out, why did you come in the first place, Dr. Chaudhary? At 12:30 midnight. Why did you come in the first place from Delhi? There, one comes to his mama's house at 12:30 to ask for a glass of water. And when did you come back at 3:30 a.m.? And when you saw people, why did you go out? Entire evidence you have seen, everything you have seen, Dr. Chaudhary. Conviction we cannot save, but death sentence we are intent to save, subject to what Mr. Chaudhary says, Mr. Chakravarti says.
On that,
Death sentence was on a ridiculous, preconceived notions of the judge.
the point of, my lord, on the merits, my lord, the law point which comes out is, my lord, the recovery of the offending weapon, my lord, could not be proved.
Yes.
My lord, section 27, benefit of section 27 cannot be taken by the prosecutor.
Dr. Chaudhary, you said something on the last occasion. Section 27 for that also, two witnesses had to sign.
Yes.
Where do I get that? Where do we get that?
It's a part of the judgment, my lord, rendered by the Honorable Supreme Court.
That judgment was also cited before the trial court. No, probably not. Because the other judgment cited by the trial court, we have whatever. But this judgment we could not find. So where do we get that?
But I'll say, the bringing it.
Cite that only, that is the only purpose of today's hearing.
Babu Sahiba Gauda, Rudra Sahiba. 23, my lord.
You all people have this by heart, but we don't. I don't, Justice Kumar may have. Yes. Cite that judgment, that is the, this mama mommy angle we might have been matrimonial discord, but there is no explanation why you came at 12:30 first. From Delhi, you stayed, everything you have admitted, but and there is substantial corroboration of the other evidences. There are some discrepancies. One of the witnesses, PW9 Abul Hussein, was the owner of the car that starts with N. Nirod. Nirod was the driver. No doubt on that. There is not no material discrepancy in everything else. They were coming, the Dhalai party was coming by a pickup van. She was taken by a Maruti car owned by Abul. Abul is a resident of the locality, so therefore they were coming from the Dhalai team was coming. Yes, they came there. She was not waiting on the road for 20 minutes like you said. She was hiding behind a boundary wall. And when she saw the Dhalai party, she called them. They took her to Ashok Rai's house. The person where, not Ashok Rai, yes, Ashok Rai, where the children hid, that person was not adduced in evidence beside the point. And Ashok Rai adduced evidence, and then there is some discrepancy as to who called that Nirod for taking to hospital. Very minor discrepancy. People say neighbors, some claim I, the other person says I. Whatever it was called, they went there. And yes, while coming back, these people were apprehended, kept in that Murgi hotel, quite appropriately named. I don't know whether this hotel has come up for in other cases also for the same purpose. But that hotel was appropriately used. And 10:30, 8:30, we have seen the entire chain. There were two police parties going to two different places. One police party came to the place of occurrence, and therefore that there is no discrepancy actually. That three occasions of GD entries. First, the initial GD entry. Second, when they were apprehended and another police party took them to the police station, took their statements. The place of occurrence party. Then this Ronendranath also lodged the complaint, and then another GD entry and FIR was lodged.
Chain of has not come in evidence by the investigating officer.
How do we know?
But he has not.
Investigating officer did not know the entire thing. He was a part of the party which went to the place of occurrence. But there could have been another team which went to the hotel and brought nabbed the accused and arrested and brought to the. But may not be the no, that is clear. There are two sets. That whatever we are saying, Dr. Chaudhary, we were not there. So whatever we are saying, we are within the four corners of this. So the entire evidence says this. There is nothing much to argue on that. But you can argue 27, we could not find out any judgment referred to by the trial court. Two witnesses necessary, that you are entitled to. Please cite that judge. The other judgments, yes, appropriately dealt with by the learned trial judge. You cited good judgments, but there was not poor representation of the accused was represented properly.
Some of the vital witnesses, PwC.
Cross-examination, there might be some difference, but as we said, Dr. Chaudhary may be left deliberately open. Some of those might have been. There was some discrepancy in there. ও মামা মামি গন্ডগোল ছিল হচ্ছে মামামি গন্ডগোল মেটাতে এসেছিল রাত 12:30 শেষ করবে waiting for the judgment, and Mr. Chakraborty, you may argue 10 minutes in the meantime. Yes, because we are satisfied of the conviction.
I'm with the death sentence, my lord.
Achha, very well. On that submit. 10 minutes are not necessary for death sentence. 19-year boy came and committed dacoity.
Time of incident 21, very mature.
Very huge difference between the two. 21 years, mature person came, killed his mama. 21, 22, whatever, yes.
The thing is that when we read section 27 of the Evidence Act,
Yes.
section 8 of the Evidence Act has to also take into consideration.
All right. So section 8 with section 27. Evidence Act আছে বাবু দেখতে
It's very unfortunate that petitioner is aged about 21 years. On the other side, my lord, if my lord takes just a view, because being an advocate from the side of the prosecution, my lord, at that first instance, I also thought it's a very young age.
Not only age, you're right.
Simple, my lord,
Age itself is not a.
just when we imagine the situation, the incident, how it happened, two boys, minor boys, in front of them, the father has
Absolutely.
who has done nothing. Had it been there anything against the accused, any revenge or not like that? He is an innocent person, an honest person, in front of two minor boys. What reaction, what a trauma. If we imagine that our father is killed brutally in front of us when we were very minor, we could not restrain anyone. We were so young that we could not even help our father to save his life. At that time, my
Not
lord,
the rarest of
right,
rares.
my lord, just the situation, my lord,
Undoubtedly.
Until and unless there is a
If
death.
this is called a rarest of rare case, what would happen to the heinous crimes? And this person is
It's a pre-planned because everyone were carrying
the
sharp weapons, my lord.
court compares sorry.
Because every person, 6 persons from the scissor list, if my lord goes to the scissor list, they differ for 6 weapons, 6 sharp weapons, out of which 2 29 inches
Why
centimeters.
they wanted to commit murder of whole family?
My lord, this
What was the
petitioner,
motive?
he is so clever. Even in the judgment, your my lord will find he had heard all the evidence. At his 313, he has made a good case, my lord, which my lord has definitely at 1230. And he is so clever that he is so matured also.
How do you know he was so mature? His advocate could have advised him.
Definitely.
Then,
That-
and he has been compared with Ajmal Kasab and that Delhi murder, the Nirbhaya thing. This crime, this is the rarest. If this is called the rarest of rare cases, what would happen to those cases, Mr. Chakraborty, which cannot be thought of?
No, that's true, my lord, but it doesn't mean that, my lord, this type of cases.
He should be hanged. We don't have the right to give a life. Don't have the power to give a life before hanging a person. First of all, this is not a prejudice or bias.
Even
If it is,
life-
if
life
it is a hanging
imprisonment-
case, we definitely
No,
concur.
he is not 22. If it's a case of life
There is
imprisonment,
chance of reformation. That is
there
the
is no
reason.
chance of his even if he's sent in correctional home, there is
How do you say that? That is the what is the premise of that? The maturity which he showed in his 313. That is advocate's advice.
he was first, my lord. If my lord goes through the evidence, my lord can see that he used to stay with his maternal uncle. So a childhood was with the maternal uncle. Thereafter, he shifted to Delhi.
Mr. Chakraborty, we are giving our reasons for not agreeing with you. You give your answers to this.
File a
No, not that. You just give your answers because we are asking you questions on one of the grounds on which this sentencing was done, death sentence, was he was shown mercy by the mama when his father died. He was under the care of his mama and he was so ungrateful that he came back from Delhi and killed his mama. Now, first of all, if there was a position of trust, if the mama had killed the Bhagne, then we could have understood. That is a relevant consideration. This was not a position of trust. First, so it was the other way around. He was taken care of by his mama. He was ungrateful. But we don't know, Mr. Chakraborty, what happened, why he left that house, was residing in Delhi, why he came back, we don't know. Nothing has come from record. So there might have been many reasons why he went back, went away from the mama's house to Delhi. Might have been turned out also, we don't know. At the relevant point of time, he was not under the tutelage of his mama. He has left for Delhi long back. Why would he leave for Delhi? These are in the realm of conjecture. Secondly, it has been stated that he is cold, mature, and he appears to be a hardened criminal. All this is based on 313 and the nature of the offense that be in front of the children, the mama was killed. Definitely in front of the children, killed. No motive has been made out, as my learned brother was saying, that he came pre-planned with a pre-planned motive to commit murder. Dacoity, yes. They were staying at a hotel. These people came. Dacoity, there was some pre-planning. But again, there was a lack of maturity in that planning also. If they had some maturity in the pre-planning, they would not have been caught in the first place. Secondly, just see their activities. They come to that hotel, register under their own Aadhaar cards.
No, that was all fake. Only one was original of this accused.
This accused, we are speaking only about this accused. This accused, he registered with his own Aadhaar card, stayed there. Not only stayed there, he came to the place of occurrence, committed the murder, and then they were walking after hiding the things. They did not have anything. They were walking down to that tea stall.
They waited in the forest.
Waited in the forest, and they were walking to the tea stall in in front of everybody's eye, where a car came and just snapped them. They were naive, actually.
Contradiction, my lord, definitely.
Not only the contradiction, this is not the way a murder, dacoity is committed by a hardened criminal. That is where we are asking. I mean, if it was a hardened criminal pre-planning, they would be committing the dacoity, murder, missed dacoity, move away from the state. They are residents of Delhi now. Moved away from the state. They are going for taking tea and all these things. They are amateurs. And if this person is hanged, there is no scope of reforming him. Even if we grant him 14 years, 20 years, he is now, say, around 22. He would come out, there is fair chance of reformation.
Means 20 years.
Life, we don't have a second chance.
It can be 30 years also.
Throughout his life, unless, yes, he cannot be,
We have seen, my lord, there are some judgments where it can be, death can be into 30 years also. It can be converted into 30 years. So those things are different, my lord. But yes, my lord, but thing is that, my lord, whatever contradiction Mr. Chaudhary has, Dr. Chaudhary has placed before my lords.
Conviction.
No contradictions, my lord. In every contradictions, my lord, I have answer, my lord.
Contradictions are very minor.
Regarding the PW1 that he has stated while before the doctor as well as before the 164,
Yes.
as is 160 and the stat and the deposition, my lord. These contradictions are very minor contradictions. And not only that, only the thing is that when he has described the facts of the case, maybe some lines has been up and down, nothing else. Somewhere he has said, I have told this to this person, then said, then happened. Then he said, this.
One
these are
contradiction
very
is
contradictions.
PW8 Rafiq said that he had gone to we had taken her, Momita, to hospital.
Right.
If he had taken her to hospital, the rest could not follow because he said he was in the place of occurrence, informed by Abul.
But the Sastho Kendra, the hospital was very near to the place of occurrence. It was only 10 to 12 minutes.
No, not that. Mr. Chakravarti, the case of the party who took Momita to the hospital is there. They took her to the hospital.
Right.
While returning from the hospital,
They
they
came
stopped for tea
tea.
and they nabbed these accused persons and put them at Murgi Hotel. But Rafiq says that after Momita was taken to the hospital by them, Rafiq received a telephone call from Abul. If he was a part of that party, he would not have received a telephone call from Abul. There is a contradiction, and there is also some contradictions like the timings. There may be some minor, but overall it tallies. 2 to 3, this happened. I mean, it tallies, more or less tallies, and nothing yes, Nirod Roy, the driver, he said that after admitting Momita, they returned home. He said not a single word regarding this tea stall episode. But there were 4 persons in total in that car. 2 of them corroborated, or 3 of them corroborated. One person, he does not contradict that also. So yes, there is lack of evidence on his part because 2 witnesses have already said. Probably prosecution thought that was sufficient. Therefore, Nirodha not saying that he saw anything in between, we are taking it lightly. I mean, it's not a serious discrepancy. Acha, we'll take that also. Cross-examination, Nirodha, he says?
That they were admitted at Sonakhali Court. And he came to know about it almost after 1 hour of coming back from there.
How do you deal with that? Can you give us the page, Dr. Chaudhary?
Yes.
If you know the page, then give us the answer.
Page 78.
Yes.
Cross-examination, last, third line from the bottom below.
But here, my lord, it's the hearsay I heard. The word
He was the
heard.
driver.
No, I heard that Aftab was apprehended by police from the jungle. It's not that. I heard from someone. So hearsay.
He was the driver who had.
He was the driver of the team who had apprehended.
He was asked, my lord, he said, I heard that Aftab was apprehended by police from a jungle of Demoli.
Just visualize, Mr. Chakravarti, you and I am Nirod, I am driving the car. You are, say, Abul. We are in a car, I am driving the car. Your case, the other, Mr. Ganguly was also in the car, suppose the other person, Rafiq. Your case consistently, it will be easier to imagine. You apprehend Dr. Chaudhary, who is the offender, on the way back from the hospital. You consistently say, yes, we have nabbed him and put it in Murgi Hotel or whatever. I am the driver of the car. I say, I heard from one of you that he was apprehended from a different place, from a jungle in Devamali. If I am the driver, I am the first person who will be the witness of that. That I will say, yes, my team apprehended. In his evidences, does not say anything regarding apprehension while returning. Rather in cross, he says, I have heard that he was apprehended somewhere. If he was the driver of the car, why didn't he know?
That in all cases, it may not be, my lord. But thing is that I am here, I have come with my driver today. My driver knows what cases I am bringing for. But what is my So whatever it is, my lord, whatever it is.
There's some subtle difference between what you are doing in court and what you are doing there. It's subtle, very subtle, but there's a difference.
The contradictions, my lord, whatever written notes he has filed, but we'll give a report.
This is a serious contradiction. Yes, very well. Thank you, Dr. Chetty. And your judgment.
My lord, before I give the judgment, my lord, two things. My lord, there were 6 accused persons in total. My lord, after being adult, my lord, he was tried separate. My lord, in addition to Aftab, my lord, the remaining 5 persons, 2 are still yet to face trial in the Juvenile Justice Board, Jalpaiguri. 3 are facing trial before the Children's Court, my lord, who are being tried as adults. My lord, in that proceedings, 5 witnesses has already been examined. Now, my lord, the totality, my lord, has scanned the entire evidence. My lord, the totality of circumstances, my lord, since Aftab was known to Momita, my lord, his name has transferred everywhere. But
And unluckily, he was an adult.
yes. But my lord, we do not know exactly what role who have played. How much role?
Aftab's role has been borne out clearly by PW's 1 to 3.
My lord, since he was known to Aftab was known to them, but she also says that other I did not know, but I have identified. So, my lord, under such circumstances, my lord, there is a case.
No, not that, Dr. Chaudhary. Otherwise, they would have said that the others also did the same thing as Aftab. The main role apparently was played by Aftab, the stabbing, all these things.
My lord, may I visualize
And
one.
because he knew, and all the neighbors knew him, it was obviously Aftab who brought the others there.
If my lord visualize one thing, Momita says that Aftab and another guy was there when she opened her eyes. At the same time, my lord, she also hears that her husband was being stabbed by other person. So, my lord, it was the other accused persons who had stabbed her husband first, and thereafter Aftab and his associate went there and joined them.
That is not exactly how she says it. Let us come to her evidence. Not exactly how she says it. Something is lost in translation, maybe, well, in evidence. You understand that, but even then, if you come.
Lord, page 50.
50, yes. She was sleeping in another room.
Yes.
1:30, someone was standing, woke up, found Aftab and his male associate. Identified them because the light was on. Seeing them, I screamed out of my bed and started shouting. The accused, Aftab, gagged mouth, put a knife to my throat, managed to give a bite, such and such. Thereafter pushed him to the. When I fell down, both of them sat on her, assaulting, tried to free the story regarding herself. Hearing my screaming, husband woke up and tried to enter. At that time, I heard that my son started crying and saying to leave their father. They were holding the father. In order to rescue, I acted like I was dead. She acted like dead. Then the accused persons felt that I was expired, so left me and they went to the room. When they left me, I came near the door and saw all the 6 armed with knife. Now, therefore, these 2 persons, assailants, attacked her. She somehow feigned being dead. They left her, went to the other room. Then the stabbing incident occurred. Before that, the other 4 were holding his father. Children were shouting. See, she went to the door. When they left her and went to the other room, then she went to the door and saw this happening. Which is all the more a reason, Dr. Chaudhary, we suppose that there was not enough maturity of a criminal, hardened criminal behind this offense.
The companions, my lord, of the authority, they will be who are participating in this case. They will, even if they have not committed the murder.
Similar, yes, similar footing, yes.
Judgment, Supreme Court 1998.
Similar footing. That was probably considered here.
My lord.
That was considered here.
Another thing is, my lord, Dr. Chaudhary has not relied on the 313, the defense case. Nowhere in the written notes I have found. So whatever the case is there, my lord, he has just found out some contradictions of the PW.
That the trial court was justified in observing that those were subsequent concoctions. Just like your Delhi antecedents were also subsequent concoctions. Nowhere in the conviction, throughout the trial, it came up. The PP gladly goes up at the time of sentencing. Can new material be furnished? And no material was furnished. When the sentencing was about to happen, the PP said there were past antecedents of Delhi. He did similar things and cases are going on in Delhi. That comes in as a consideration for sentencing him to death. That is a bad consideration. Other considerations will definitely, we will be considering. Other considerations are serious discrepancy is that, as Dr. Chaudhary today points out. What is your answer to that? You also have to say that. Because this Nirod, The person was driving.
My lord, that up to, my lord, give me 1 day time, my lord.
No,
Tomorrow-
no further time. We don't have time.
Keep it tomorrow, my lord. In the
No,
meantime-
no.
In the meantime, my lord, we will give you a reply of the written note also. We'll file a written.
Written notes you have to come prepared today itself. They said, they indicated that they.
He has served.
Your written notes are not dependent on them. He has argued in open court. That will only be there in the.
Yes, nothing more.
He cannot add anything. Written notes means you have orally argued. That will be in their notes. So hand that over, Mr. Chakraborty. Written notes we won't.
I will hand over the written note. my lord.
No, you just give us your answer to this Nirod Roy's wait. You can consult your page 78, that discrepancy. He said, I learned from Aftab. And the place of apprehension is also different. That is all the more, I mean, if I'm a driver of a car and persons are napped, you may have a point, Mr. Chakraborty, in saying that yes, they stopped at a tea stall and they saw some people loitering and they went and napped. This person might have been in the tea stall, might have known. Aftab was also part of that party, the hospital party. There are two parties, Dhalai party and a hospital party. Aftab was a part of the hospital party. Maybe explained away.
Actually, what Nirodha has stated, my lord, he stated that on 28/7/2023 at around 2 p.m.
Yes.
he received call from one neighbor.
No, there is no discrepancies.
That
Only.
is not PM, or 2 a.m., whatever it is.
No, those are not discrepancies. Those are not valid discrepancies. We don't find anything there. Some timings, both two people claimed that they had called Nirod Roy. Those are not very serious. PW 1 to 3 was very crucial eyewitnesses. You were right on the last occasion. Yesterday also you argued, day before. Yes, clinching. You will only cite that judgment, Doctor. What is this? This is your written notes, the right hand side. Keep it with you. Then thanks. This itself, the weight of the written notes itself should be considered as entered as an offense under some act. Offense against the judges. This is that judgment, 27. I give another copy. আচ্ছা very good.
We would now discuss about the requirement under law so as to prove a disclosure statement recorded under section 27 of the Evidence Act 1872, hereinafter being referred to as the Evidence Act, and the discoveries made in furtherance thereof. The statement of an accused recorded by a police officer under section 27 of the Evidence Act is basically a memorandum of confession of the accused recorded by the investigating officer during interrogation, which has been taken down in writing. The confessional part of such statement is inadmissible, and only the part which distinctly leads.
This is settled, Dr. Choudhury.
Yes, this is settled. My lord. Coming to the requirements, discovery of the fact is admissible as evidence as laid down in the court, by this court in state of UP versus Devman Upadhyay. Now, my lord. Thus, when the investigating officer steps into the witness box for proving such disclosure statement, he would be required to narrate what the accused stated to him. The investigating officer essentially testifies about the conversation held between himself and the accused, which has been taken down into writing, leading to the discovery of the incriminating facts. As per section 60 of the Evidence Act, all oral evidence in all cases must be direct. This section leaves no manner of ambiguity and mandates that no secondary hearsay evidence can be given in case of oral evidence except for the circumstance enumerated in the section. In case of a person who asserts to have heard a fact, only his evidence must be given in respect of the same. Now, my lord, the manner of proving the disclosure statement under section 27 of the Evidence Act has been the subject matter of consideration by this court in various judgments, some of which are being referred below. My lord,
No, it has been held by various judgments. The exact words should be said.
My lord, thereafter, my lord, thereafter, lordship may kindly come to 77. Para 77.
The first.
Oh, it's an internal paragraph. Sorry.
Yes, paragraph of the other judgment.
Yes.
Of the cited judgment.
Yes.
Yes, 77.
76.
Lord, the first and the basic infirmity, the evidence of all the aforesaid prosecution witness is that none of them have deposed the exact statement said to have been made by the appellant herein, which ultimately led to the discovery of the fact relevant under section 27 of the Evidence Act. If it is, say, of the investigating officer that the appellant accused while in custody on his own free will and volition made a statement that he would lead to the place where he had hidden the weapon of offense, the site of burial of the dead body, clothes, etc., then the first thing that the investigating officer should have done was to call for two independent witnesses at the police station itself. Once the two independent witnesses would have arrived at the police station, thereafter in their presence the accused should be asked to make an appropriate statement as he may desire in regard to pointing out the place where he is said to have hidden the weapon of offense, etc. When the accused while in custody makes such statement before the two independent witnesses, punch witnesses, the exact statement or rather the exact words uttered by the accused should be incorporated in the first part of the Panchnama that the investigating officer may draw in accordance with law. This first part of the Panchnama for the purpose of section 27 of the Evidence Act is always drawn at the police station in the presence of independent witnesses so as to lend credence that a particular statement was made by the accused expressing his willingness on his own free will and volition to point out the place where the weapon of offense or any other article used in the commission of offense had been hidden. Once the first part of the Panchnama is completed, thereafter the police party, along with the accused and the two independent witnesses, punch witnesses, would proceed to the particular place as may be led by the accused. It is from that particular place anything like the weapon of offense or blood-stained clothes or any other article is discovered, then that part of the entire process would form the second part of the Panchnama. This is how the law expects the investigating officer to draw the discovery Panchnama as contemplated under section 27 of the Evidence Act. If we read the entire oral evidence of the investigating officer, then it is clear that the same is deficient in all the aforesaid relevant aspects of the matter. So, my lord, this is the exact procedure, my lord, how a statement by an accused, my lord, has to be taken, and thereafter, on the basis of that, my lord, a recovery has to be effected. My lord, in the instant case, lordship has seen the statement itself was recorded at the place of seizure, my lord, as the investigating officer says in his cross-examination. So, my lord, the disclosure statement and thereafter the subsequent recovery, my lord, is not proved in accordance with section 27 of the Evidence Act. So, my lord, this is the limited point of law, my lord, what I have elicited. My lord, so far as the point of sentence, my lord, this is not a rarest of rare case. My lord, the learned trial court has not asked the prosecution to adduce any evidence that the convict is not prone to rehabilitation. My lord, under such circumstances, my lord, taking the principles of my lord, the Bachchan Singh, my lord, Machi Singh, and thereafter Manoj versus State of MP, very recent judgment, my lord, death sentence cannot be awarded in this case. My lord, death sentence is usually an exception. My lord, life imprisonment is the rule.
Exception means the rarest of rare
Yes.
cases is a high term.
Yes, yes,
Bachchan Singh has been relied on by the trial court also.
Yes, but-
Somewhere it was referred.
yes.
We see what we want to see
My lord,
on a judgment.
reply on that point, my lord, from which he has raised, my page
Section-
number 73, my lord.
Yes. Yes, you can take this.
The-
73.
On interrogation after this that we apprehended, my lord, third line.
Yes.
Last word, we apprehended them and started interrogating them. This is at the time of chief, my lord. Third line, last word, we apprehended them and started interrogating them.
Yes.
My lord, if my lord comes to the cross-examination, nowhere there is any denial, my lord. On this point, specifically on this question. Number one. Second, my lord, another thing, my lord, that is page number 78, my lord, that is of Nirod Rai. He has stated that in the second line of his examination chief, I knew Aftab since the childhood as he used to reside in the house of my lord. Now this chief he has given, when he was cross-examined, my lord, he knew Aftab from his childhood, my lord. Now he may be gained over, my lord. This line which he has stated that
He had not been declared hostile.
He has no, at the time of cross, my lord. If at the time of chief it would have come, my lord, we could have declared him as an hostile witness. But here, my lord, it came at the time of cross. There is no chance, my lord. That one for 2 points are there. And regarding the recovery and discovery on the basis of reading statement, my lord, though he has cited, my lord, I have gone through that citation also. 2024, this is Apex Singh versus State of Rajasthan. And another is 2024, 23. That is in favor of us. That is reported in the CRLJ. That's our own High Court on 2006 CRLJ.
You can just file a compilation of the judgments also. One or two judgments. Most
lord,
he has filed, those are you will be relying on also because
But I don't know which they have not given a written notes. He has written, but has given a list of which judgments. 2006 Criminal Law Journal, page 4656. It's a Calcutta. my
just
lord.
hand over a copy by the end of the day.
My lord.
By the end of the day, just hand over a copy. We'll give it on.
my lord. ঠিক আছে, judgment গুলো বার করে একটু complex. So my submission, my lord, this is one of the rarest of the rare cases where this petitioner who was very matured at the time when he has committed the offense, and it was a pre-planned dacoity and murder, and all the petitioner as along with his company and the participants, they were carrying deadly weapons with them. Those were seized on the basis of the statement, though he has raised one point that prior to the discovery or recovery, whatever it is, there was no Panchanama, no independent witness was called as he was in custody of the police. Those things, and he obviously has cited a citation, my lord. But taking on overall consideration of the case, my lord, the Caesar list as well as the independent witness in the Caesar list, maybe after the incident at that relevant time, my lord, there was not, did not get the, may have not taken the statement, but there was an oral information on the basis of which the leading statement was an oral information. Even if there is an oral information, and in that case, which cannot be taken into writing, my lord.
Under section 27, otherwise you are right.
And 8 of the Evidence Act also, that has to be considered, my lord. Motive, preparation and previous and subsequent contact, my lord. The motive has also to be also taken into consideration.
What motive? Why is that?
Committing, well,
No, this is on section 27. It's on a different context.
my lord.
How does section 8 come in here? Section 27 is regarding the recovery.
My lord.
Those parts of the statements you can rely on which led to the discovery.
My lord.
But the judgment says that it should be done in a proper manner, statement taken, and that has not been done here.
Well.
So how far that vitiates the rest of the evidence, we'll have to look into that.
But the entire case, one thing, just for one point. So the entire thing, my lord, the case was based that they went there to commit dacoity. My lord, what was recovered from?
No, that's a failed dacoity. That was a failed dacoity. You murdered somebody, people, you escaped.
They did not cover their mouth, but went there in that manner only, so as to not get recognized by the.
They did not cover their mouth, but that may be argued either way. They did not even care to cover their faces. Went and committed murder of his mama. That's what they're saying. They're hardened criminal. Go and commit the murder of their mama and just go out. I mean, they're callous in a sense. They don't care to.
That their maturity level was.
Maturity level is obvious from the way this person registered with his own Aadhaar card in the near vicinity in a hotel in the area. And maturity is very evident. Maturity of the lawyer is also evident from the 313. So he should be then hanged, as for Mr. Chakraborty. So Mr. Chakraborty, if you want, you can file a 1-2 page note. I mean, today itself, Mr. Ganguly will prepare.
My lord,
Leave all other matters alone.
I'll just file the.
You take assistance from your juniors. Your bearded junior is very keen on the matter, and he has been assisting you very well along with Mr. Ganguly. So he has to do it, and you will just check it. You and Mr. Ganguly. You please do it. Very good. Tomorrow morning, do it. We'll incorporate in our judgment.
If your lordship allows me, I will make some markings in the written notes. It will be a bit convenient for you.
Yes, do that. By all means. No, it's your written note, so you can always do it.
No, if your lordship allows me, lord, because I cannot mark on your lordship's copy. If your lordship.
No, do that. But you have to mark their copy also then. Whatever is before us has to be given to them.
I have already mentioned the paragraph number of the judgments. I will just mark the relevant pages for your lordship to find
The
it out.
relevant pages of the judgments.
Judgment.
Yes, yes, do that.
Find it
If you don't do it, we'll have to do it, the
Yes,
same
yes,
thing. So
that
please
is-
do it for us.
yes.
Thank you. Thank you very much to both sides. Hearing is concluded. Judgment is reserved in the matter.
Written note is taken on that.
Written notes of arguments filed by the appellants be kept on record. Full the state shall file its written notes of arguments by tomorrow.
Great.
Try to do it by tomorrow morning, latest. এইটা ফাইলটা দীপঙ্কর বাড়িতে যাবে আমাদের, উনি রিটেন নোটস স্টেট কাল ফাইল করলে সেটা কালকে পাঠাবেন, আজকে এমনি ফাইলটা পাঠিয়ে দেন। This matter you are mentioning, no, somebody was mentioning it was fixed on Friday, one Friday, we kept it on Friday, not this matter.
Yes, Lord, this was the.
You had mentioned, right?
Yes.
You were complaining that we could not reach it, but we had kept it on Friday. Complaining not in a bad sense, I mean.
I said the notes are ready, so.
Oh, yes, yes, that,
this can
yes,
be
right. This is the matter.
But I am
So
for the
conscience
de
satisfied.
facto. Here I am for the de facto complaint.
De facto complaint, that's it. State, Mr. Ganguly. Yes, be very precise. Where are the written notes?
Yes.
You start with the written notes.
Fairly submit, my lord. This, my lord may go through the written notes. If my lords are come up with any doubts, my lords may contact me on that.
We also need to file our written notes, my lord.
Yes, do that tomorrow.
There are glaring discrepancies in the investigation itself, starting from the initiation, which is the inquest. The inquest itself is vitiated by law. The second point is, my lord, circumstantial evidence. There are, my lord, three.
Have you referred to the page numbers?
My lord, I have referred to the particular witnesses. The page numbers, my lords, will find from the paper. The paper books, my lord, is indicative of the relevant page numbers of the depositions. I have, my lord, indicated the PW numbers.
All right. Yes, what was the discrepancy? Give us some examples of the discrepancy in the inquest.
First is the inquest, page 2 of my written notes.
Yes.
The inquest, my lord, is purportedly done by ASI of a police. His name is, my lord, Probir Roy. So next morning, my lord, he proceeds to the North Bengal Medical College and Hospital without any intimation to the nearest executive magistrate and holds, my lord, a purported investigation under section 174 of the CRPC. After holding up that investigation, my lord, he does not send that report to the magistrate to effectively give result to the inquest, which is contemplated under section 176 of the CRPC. At the time of his evidence, he says that the investigation that he had apparently conducted under section 174 of the CRPC was the inquest. Inquest was in this case, my lord, was not conducted at all, because the inquest, the empowerment is with the nearest magistrate. His job is to conduct the investigation under section 174. After giving an intimation to the magistrate, he conducts the investigation, then reports the investigation to the magistrate, who then holds the inquest.
Here it was not reported to the magistrate at all.
Nothing. Prior intimation was not given before holding the investigation. After holding the investigation, that report was not submitted to the magistrate to conduct the inquest, ultimately under section 176. So my lord, the initiation, which sets the ball rolling, is itself vitiated by law. So my lord, next is the chain of events. Now, my lord, here the entire prosecution case hinges on circumstantial evidence. There are, my lord, altogether 4 witnesses. First is, my lord, a witness of the police itself. He says that he was posted at that relevant day at a point called Lexicon More on NH 31, where he says that he apparently saw a man who is later found out to be the accused as per the prosecution case. He saw a man in his bicycle and the lady.
He was the complainant, this PW 21.
No, the complainant is the father. The father files a missing complaint and sets the ball rolling. Now, my lord, this man was posted at Lexicon More as a traffic constable.
Yes.
I mean, my lord, a traffic inspector. And my lord, he sees a man in a bicycle with a lady on his carrier proceeding towards the PO, the apparent PO.
That is, my lord, the first chance.
What is the what was the charge? I mean, the murder, rape and murder.
Rape and murder.
She was a schoolgirl. Schoolgirl.
Yes, my lord. 16-year-old school.
So POXO.
Poxo is also. So, please let me know.
No, expression was very vital. Yes.
So, my lord,
Yeah.
he sees this man
Yeah.
on a bicycle with a lady on the carrier.
Girl.
Proceeding towards.
He says girl.
Yes,
Boy, girl. Yes.
Boy and girl.
What was your age at that point of your client say?
22. 22. So, my lord, he sees them proceeding towards the PO. The next evidences are, my lord, 3 persons who apparently sees this boy
Yes.
coming out from the PO after apparently committing the crime. Nobody sees this man committing the crime. A police witness first sees him proceeding towards the PO.
May not be always, eyewitnesses may not always be there. Nobody commits murder deliberately in front of eyewitnesses.
Yes, ma'am.
But circumstantial evidence can also, if the chain of events is unshakable, then
It is
definitely.
completely broken. I'll show that to you. Kindly
Police
go-
sees boy girl going on a cycle
Yes.
to the place of occurrence
To the place of.
and returning.
No. He does
Therefore,
not see them
therefore, that's the first
And my lord, when he comes.
boy returning, the girl not returning.
Yes, the boy returning and the girl not returning.
Yes.
And my lord, when he comes out from the PO, 3 witnesses apparently see him with his face covered by the mask and running away in the bicycle. This is, my lord, the chain of circumstance that the prosecution has attempted to establish.
The place of occurrence was where?
Place of occurrence was, my lord, this point, Lexicon Mode. And my lord, there's a building to the eastern side of it called Benio Building. Benio Building's adjacent plot is the place of occurrence. They say that it is an abandoned place. It is a gated with an iron gate. And inside that, this crime had apparently happened. That is what they say. And my lord, next is the CCTV evidence. So, my lord, all these witnesses, they never identify the accused. They only say that they see a boy and a girl moving. And my lord, these 3 eyewitnesses, they see only the boy coming. Nobody identifies him. So they try to match this boy's appearance with the CCTV footage. Now, my lord, the electronic evidence is completely laughable.
Completely?
Laughable.
Why?
No compliance under effective compliance under section
65.
65B is there. So, my lord, they seize the CCTV footages. They bring on record a CCTV technician. A CCTV technician who is apparently the owner of this electronic evidence, and he deposes with regard to this electronic evidence and sets the ball rolling with regard to the electronic evidence. That is completely beyond the purview of section 65B of the Evidence Act. So to match this man,
CCTV footage showed what? That the boy going and coming, these things.
CCTV footage only shows the boy going on his bicycle with the lady, with the girl, and then that same CCTV footage captures this boy.
But that is also independently corroborated by other witnesses.
No.
CCTV, let us leave aside the CCTV. ASI, this person, PW21, 3 other witnesses.
No, my lord. There was no test identification parade conducted during the investigation. They first see this boy on the day of occurrence. The next identification is on dock. In between, my lord, there is no test identification parade because they never saw the boy before that.
But how does it vitiate? Just clarify.
If in such a circumstance, my lord, there is no test identification parade conducted, it vitiates the entire investigation. Because identification is the main thing here.
Unless there was identification, there could not be any prosecution, in fact.
Yes, my lord. If I see a random man on a particular day in this circumstance, and in between the investigation, in between the period that the investigation is conducted, is proceeded, the police does not make me identify that particular man. How can I say that the same man is standing on dock at the time of evidence during my deposition? That is completely beyond the purview of law. Test identification parade was of utmost necessity in this investigation. And what does the Milord investigating officer in his deposition say? When he is confronted with this particular question, that why didn't you conduct the test identification parade? He makes a bold statement that there was media attention. That is the only explanation on the part of the
investigation. Have you taken this point in your written notes?
Yes,
TI parade?
Yes.
What is that point?
My lord, page 3 is page 3 is my purported chain of
yes.
Yes, my lord. This entire argument deals with the test identification parade part, because these are all the witnesses who have apparently seen this man.
Where is the point specifically taken? I mean that there was no TI parade.
That kindly takes up the bold argument
Yes.
Lord, the deposition of this witness bears no relevance or value for the purpose of convicting the appellant, as the purported date of his witnessing the boy on the bicycle is 21/8/2023,
The note here.
and the date of his purported identification on dock is 18/1/2024, both dates being sparsely situated with no test identification period having been done during the period of investigation in the interregnum. This is, my lord, same for PW 21, PW 12, PW 13, PW 14, and my lord, thereafter, there is another. Now, my lord, this is with regard to the test identification.
So you have cited 3 judgments also on TI period.
Yes, my lord. 3 judgments are there.
Yes.
Now, my lord, the next discrepancy, my lord would certainly laugh at this when I indicate this to your lordships. From the place of occurrence, the investigating officer apparently seizes 2 bricks. Those bricks are apparently blood smeared. Now, ultimately, after the FSL report is received, this blood on the brick matches with the blood which is found on the clothes of this appellant. And how does the police seize the clothes of the appellant? On the night of this day of occurrence, the police conducts a raid at his house, arrests him. Police says that when the police is asked that how did you recover the wedding apparels, this appellant's wedding apparels, the police says the appellant pointed out to me that these are his wedding apparels. There is no section 27 statement on record, no witness to identify that section 27 statement.
So it was recovered from the spot.
Yes.
27.
No, my lord, because it was pointed out. This has to go through the entire rigor of section 27 because it is ultimately a discovery of a fact. I am arrested. The police cannot randomly say that these are the wearing apparels. There has to be a particular chain of motion. The police has to say, because the investigating officer in his deposition says that these are the wearing apparels which were pointed out by Abbas, by the appellant. So that has to go through the rigor of section 27. That the first statement has to be recorded in the presence of witnesses. That statement has to lead to the discovery. It has to then lead to a seizure list in the presence of independent witnesses. Now, this entire discovery only goes through 2 things. He says that Abbas points out the wearing apparels. He seizes his wearing apparels in the presence of his constable, who he takes along for the arrest and the seizure.
Yes.
And, my lord, one independent witness, Rajia Khatun. Rajia Khatun is not, my lord, examined during the entire prosecution. There is no independent witness. The sole independent witness who had apparently witnessed that seizure of the wearing apparels is not examined by the prosecution. The only witness who is examined is Ruben Ekka, who happens to be the constable who accompanies the investigating officer during the point of seizure. The sole independent witness, she is not examined. And there is no section 27 statement leading to this particular discovery.
What was your explanation, the defense explanation about the boy last saw her when he went there with the girl?
Yeah, I have denied everything, my lord, during my 313.
The entire thing. I mean,
Yes,
you're
I was
going on a
there.
cycle, on a bicycle.
Cases, I was not there at all.
You did not take the girl on a bicycle to that place at all, according to.
At all. I was not there on the day of occurrence, at the place of occurrence, because the prosecution itself has not been established.
You knew the girl previously. How were you acquainted previously? Was there any
I
acquaintance?
was not acquainted with this lady or this girl, my lord, at all. I was not present on the day of occurrence or the place of occurrence. And, my lord, the wearing apparels which were seized, I have indicated to your lordships that since it is a discovery on the basis of a confessional statement, it has to go through the rigors of section 27.
What do you do otherwise? Your client, what did he do? I mean,
Lord, he's a daily wage level.
Where you was on the date of occurrence?
Yes. Yes, my lord.
Where you were on the date of occurrence?
On the date of occurrence, my lord, that I have to go through, my lord.
Any alibi?
He was on his way to work.
Might be there in the evidence. We'll look into the evidence for
Yes.
that.
If your lordships come up with any doubts, my lord, your lordship.
ইনভেস্টিগেশন নিশ্চয়ই আসবে তাহলে কি আজকে একটুখানি কন্টিনিউ করে যাবো এটা We'll continue with this matter till 3. We'll try to proceed as much as possible. You restrict your arguments. You have put in your written notes. Just indicate as you are doing. Try to conclude, and you come ready at least to start, Dr. Chaudhary. Up to 3, we'll take up the revision base. From tomorrow, we'll make it put it on the list also. So So we'll go like that.
But I firstly stand corrected on one point.
Hmm.
I indicated that this policeman who was deputed at Lexicon Mode
Hmm.
saw this boy on a bicycle with the lady going and coming back. Not I stand corrected on a part there. Not he only saw this boy going. There was no witnessing the return
Coming
of this
back.
boy.
Very well.
So, my lord, inquest I've dealt with,
Hmm.
chain of events, and my lord, this test identification period I've dealt with. Next is, my lord, the recovery of the wearing apparels. As I had indicated, my lord, the PW22, the investigating officer says that
He pointed out 27
that
has
day-
not been complied with. Yeah.
yes, 27 is not being complied with because, my lord, there are two implications here. When he is effecting the arrest, either he has to be armed with a search warrant to search the house in which the accused resides. Either that is one implication, or, my lord, he has to go through the rigors of section 27 to effect that particular seizure because it is discovery of a particular fact. In this case, my lord, he had no search warrant with him. He only conducted the raid to commit the arrest of the appellant. And, my lord, during that arrest, he says that on being pointed out, this recovery
And
apparatus
sole independent witness was not examined.
was also not examined. Thereafter, my lord, I come to the unreliability of the electronic evidence. Now, my lord, this point is very interesting. One PW20, I'll read out from the relevant part, my lord, page 7. Page 7 of my written notes, my lord.
Yes.
PW20 Ritik Rai, a CCTV technician on 23/8/2023, in gross violation of the laws surrounding admissibility of electronic evidence, states that he handed over the digital video recorder pertaining to some CCTV footage to IO Paresh Babu at Matigara police station. He then suddenly talks about handing over some hard disk to the IO. This is, my lord, the crux of his evidence. Now, my lord, what are the arguments? The aforesaid process is completely violative of the provisions of section 65B1, 65B2, and 65B3 of the Indian Evidence Act. Nowhere does he clarify in his evidence as to the preconditions enshrined in section 65B2 of the Act. At this juncture, it shall be pertinent to revisit the provisions of section 65B of the Evidence Act, a bare perusal of which shall establish that the opening words of section 65B are, notwithstanding anything contained in this Act, any information contained in an electronic record which is printed on a paper, stored, recorded, or copied in optical or magnetic media produced by a computer shall be deemed to be also a document if the conditions mentioned in this section are satisfied in relation to the information and computer in question and shall be admissible in any proceedings. Moreover, there exists no concept of primary and secondary evidence as regards the admissibility of electronic evidence by reason that neither of them fed into the computer nor its output is in a readable and humanly understandable format. It is always, my lord, in binary. Here, my lord, I'll elaborate on this more. Moreover, it is only through data processing and conversion of the binary into readable and comprehensible format that the computer makes the input and output readable for the users. One cannot claim that if the original hard drive is produced, it constitutes primary evidence, as the same is merely a connotation of the primary evidence which lies in binary format. Any deviation from the aforesaid argument shall render the word notwithstanding used at the very beginning of section 65B of the Indian Evidence Act redundant. The words without production of the original cannot be read to mean without production of the primary evidence. The term original used in this section means the original machine or device and has been used to essentially relieve the proponent of the electronic evidence from an obligation to produce the entire machine, server, or system in the court of law. More so when the term original is not used as a substitute for the words primary evidence. Therefore, even if someone produces an electronic record in the form of a hard drive containing information, it will amount to information contained in an electronic record which is stored in magnetic media and would therefore inevitably require compliance of the conditions mentioned in the aforesaid section. It is moreover necessary to indicate that an electronic record shall be deemed to be a document only if the conditions referred to in section 65B2 of the Indian Evidence Act 1872 are complied with. In this regard, it is relevant and imperative to demonstrate that from the four corners of the examination of PW20, namely Sri Ritik Rai CCTV technician, can it be gathered that the conditions mentioned in section 65B2 of the Indian Evidence Act had been indeed complied with, thus invalidating his evidence in its entirety. The next very important aspect of the electronic evidence purportedly produced in the case at hand is the failure on the part of the prosecution to effectively prove the chain of custody of the said evidence. Now, my lord, here it is very important. So, my lord, the chain of custody of any electronic evidence goes through 5 stages. First is the acquisition.
Sorry, yes, acquisition.
First is the acquisition, then is preservation, analysis, copy for the court and parties, and presentation in evidence. In this regard, it is thus submitted that chain of custody of the alleged CCTV footages, having been brought on the court's record through PW20, has not been proved at all. Hence, any subsequent use or any reference to the same by other witnesses, namely PW4 or PW21, are of nil value and cannot be considered for the purpose of adjudication of the case at hand. Moreover, it shall also not be out of place to submit and indicate that the purported certificate under Section 65B of the Indian Evidence Act having been allegedly signed by PW20 and PW4. My lord, this is very important. Kindly refers to page 21 of the second part of the paper. The paper book is divided, my lord, into two parts. Second part, page 21.
Certificate.
Yes,
Certificate under
this is the certificate on Section 65B, the most important one here. This is a joint certificate executed by this PW20, Ritik Roy, the CCTV technician, and my lord, the person who conducted the FSL, the forensics of this particular CCTV footage. Now, my lord, the last paragraph is very important. First paragraph itself is vitiative of, my lord, Section 65B. It does not state anything. What was the custody of this electronic evidence, in whose, from which computer, from which machine this was transmitted, in which particular device was it stored, what was the condition of the computer from which it was transmitted? Nothing, my lord. But the last paragraph is very important. It says the above process of extraction was done in the presence of IO of the case, and to the best of our knowledge, the contents of the 3 seized hard disks have been kept unedited, unaltered. Now, my lord, takes up thereafter the first paragraph. The first paragraph, the last word is very important. It uses the word NVR. My lord is found?
Yes.
NVR. So, my lord, there is a stark difference between a DVR and an NVR. A DVR is a hard disk, a particular storage device, which stores the raw camera footages from only one camera. In this case, these CCTV footages were apparently seized from a control room, from a police control room, which consists of a network of cameras. So when there is a network of cameras, it can only be an NVR which stores that particular information. And my lord, there is a stark difference between DVR and NVR, because in a DVR, this camera sends the raw footage to the, my lord, DVR device, which stores that footage. And then, my lord, from there on, the hard disk transmits it to the other devices. But in an NVR, my lord, the processing of the footage happens in the camera itself. That is not the most important, because the first point of reference, the first point of computation of this particular CCTV footage has happened in the camera itself. It did not happen in the DVR or the NVR. Because in an NVR, the computation of this process happens in the camera. My lord, this is a small analysis of the differences between a DVR and NVR. Science. Now, my lord, the second document is important, which defines NVR. It says an NVR is a specialized computer system that includes
But the difficulty is the bottom line of this paper. The last prepared by ChatGPT is not accepted.
My lord, this is only a my lord, explanation from a relevant source, my lord. This information was derived from the website of Cisco, which is, my lord,
makes mistakes, my lord. That is.
So ChatGPT often makes mistakes, and the source cannot be verified in most cases.
My lord, I'll provide the source, because this ChatGPT has, my lord, referred to the Cisco website, which
You have given the entire thing. The source should have been disclosed.
My lord, I'll then
Do that anyway.
Yes, I'll do that. So, my lord, may I just read out the explanation?
Yes, yes.
It says an NVR is a specialized computer system that includes a software program that records video in a digital format to a disk drive, USB flash drive, SD memory card, and other mass storage device. The NVR is typically deployed in an IP video surveillance system, and unlike a DVR, it receives video streams from over a network from IP cameras and stores and manages them efficiently. Now, my lord, this next line is important. Processing done at the camera itself. It says in an NVR system, the cameras used are IP network cameras. These cameras capture the video, compress it using codecs like H.264 and H.265 and convert it into digital data within the camera itself. The NVR does not perform the video encoding or compression task. It simply receives the already processed encoded digital video stream from the cameras over the network. The point, Milord, I'm trying to make is the first computer in this particular chain of
You say that the camera should also have been produced.
because the camera was not produced, then Milord, section 65B(2) should have been complied. They had to say that which are the cameras from which the footage was received in this particular hard disk, in whose custody were the cameras, during the entire period, what was the situation of the cameras that the cameras were in, and why were they not able to produce the cameras. These are, Milord, the material conditions under section 65B(2). Just because they produced the hard disk without complying with the conditions, and because they could not produce the original computer, section 65B cannot be said to have been complied. Now, my lord, I'll read out from my arguments. It is said that it is thus submitted that the chain of custody of the alleged CCTV footages having been brought on the court's record through PW20 has not been proved at all, and hence any subsequent use and or reference to the same by the other witnesses, namely PW4 or PW21, are of nil value and cannot be considered for the purpose of adjudication of the case at hand. Moreover, it shall also not be out of place to submit and indicate that the purported certificate under section 65B of the Indian Evidence Act 1872, having been allegedly signed by PW20 and PW4, is a laughable piece of document and is completely violative of the provisions of the said section, and the most important facets of the said section has been given a complete go-by by the said persons. It is, however, important to note that the aforesaid certificate does make a very important reference to NVR, and as such, it is important to briefly elaborate on the said subject. Then, my lord, I've elaborated upon NVR and DVR. Now, my lord, I'll read out the last paragraph. It says that the aforesaid explanation needed to be provided in the case at hand, as it is an admitted fact on the part of the prosecution that the alleged CCTV footages were generated from an NVR, consisting of many cameras which in their individual capacities captured, processed and transmitted digital data to the alleged storage devices, thus making the said cameras the first point of reference as regards the word computer used in section 65B of the Indian Evidence Act, which made it necessary on the part of the prosecution to have laid sufficient evidence with regard to the specific CCTV cameras forming part of the NVR network to establish the alleged footages in accordance with the said section, which they have miserably failed to do. Another very important aspect is the absence of any hash values. I'll refer to a judgment, my lord, of the Bombay High Court. How do you prove a chain of custody of any electronic evidence? It is proved through hash values, because hash values remain consistent throughout the chain of custody. The first point of reference to the last.
It's encrypted and it has a unique signature.
Yes. So hash values are not provided in this particular case at hand. So it says another very important aspect is the absence of any hash values having been alluded to the electronic evidence purportedly led, thus failing to attribute any distinctive character to the said electronic evidence throughout its purported chain of custody. In other words, it is not without doubt as to whether the electronic evidence which was allegedly led in court happened to be the same as it existed on the first point that it was first generated. It is also pertinent to note that the hard disk allegedly seized had never been sent for forensics, thereby casting serious doubt on the chain of custody of the electronic evidence sought to be led. This is also not very important.
But one of the forensic experts signs the 6B certificate,
Yes,
65B certificate.
but the pen drive which was taken from the hard disk was sent to the forensics. The hard disk was never sent.
Yes, SanDisk
Yes,
32.
that pen drive. That 32 GB pen drive was the one sent to the forensics. Hard disk was never sent. In view of the aforesaid detailed discussions, the electronic evidence forming part of the very basis of the initiation of the prosecution and its ultimate conclusion is by itself sham and devoid of any value. Now, my lord, next I come to other material discrepancies. This, my lord, concerns the forensic evidence. Now, my lord, I had referred to the wedding apparels. Surprisingly, my lord, these wedding apparels were seized on the intervening night of the date of occurrence. On 21st of August 2023. The FSL receives these wedding apparels on 31st of August 2023 after 9 days. There is no explanation as to during this intervening period where were these evidences. Now, my lord, the this Shondip Ghosh, who is the assistant director of the biology division, I'll read out, my lord. It says PW3, namely one Dr. Shondip Ghosh, being the assistant director biology division, FSL Calcutta, deposed in his evidence that upon examination he opined the blood stain found from the brick and t-shirt of the appellant collectively matched with the postmortem blood sample of the deceased victim. However, in his cross-examination, he categorically admitted that he, on 31st of August 2023, 9 days after the alleged seizures, received the said articles, being one black and white handkerchief in wet condition, having some dirty stains, one sleeveless gray colored t-shirt in wet condition. This is the Milord incriminating wearing apparel. One sleeveless gray colored t-shirt in wet condition having some dirty stains, and one black orange colored trouser in wet condition having dirty stains all over, said to be wearing apparels of the appellant. It is utterly surprising that alleged blood-stained clothes seized on 22nd of August 2023 were wet when received by the concerned laboratory on 31st of August 2023, casting serious doubt on the integrity of the said articles from the point of seizure to the point of their receipt at the laboratory. It is also surprising that two other alleged seizures of the same nature effected on 21st of August 2023, being two pieces of bricks on one hand and a broken fiber part with dark brown colored earth and brown colored earth from the alleged PO, were received by the concerned laboratory, but it was the bricks that matched the postmortem blood samples, but not the broken fiber and earth. That apart, all other seizures were found to be degraded by the concerned laboratory, save and except the aforesaid matches, casting serious doubt on the seizure, packaging, preservation, and transmission of the alleged DNA evidences to the concerned laboratory. This is, my lord, the FSL evidence. Now, my lord, point number 2 is also very important. Point number 2 is important because to establish the presence of this accused in the PO, the prosecution comes up with a utopian concept of a digital ration card. So, my lord, in that regard, one evidence is of particular importance. I'll refer to, my lord, Odun Roy. Lord, kindly takes up page 6 of my written notes.
What's a digital ration card?
It's a ration card. Lord, Milords know very well, Milord. Now every identity card comes in that plastic format.
Yes.
It is that. So it was apparently found at the place of occurrence, which belonged to the appellant. With that, they are wanting to establish my presence at the PU. So, Milord, how do they, Milord, prove it? Page 6 of my written notes, Milord, PW6. Odun Roy, being a PSI of police, was the first person from the administration of justice who happened to visit the purported PO, wherein he saw the body of the victim and took photographs of the PO and the victim on his mobile phone. And Lord, this is very important because he took 21 photographs, not one, not two, 21 photographs of the victim lying in that condition and Milord the PO. Nowhere from the four corners of his evidence has he been able to explain as to why, even after having taken more than 21 photographs of the purported PO, as well as the girl lying therein, there was no sign of any school bag or digital ration card purportedly belonging to the appellant, being vital pieces of evidence germane to the prosecution case, could be found from those photographs. Mere bald statements stating that those items were a little away cannot interject their absence from the aforesaid photographs and the attempt on the part of the prosecution to plant evidence with an intention to falsely implicate the appellant. This is, my lord, also very important because the concept of this digital ration card firstly comes up at the time of evidence of this particular.
But if they wanted to plant this digital ration card, they would have just put beside the body.
That is what they did, my lord.
That is what that in the photographs.
Photographs it is not seen, but the.
See, if they wanted to plant, they would have. It would be seen in the photographs.
No, my lord. What the IO does,
just put in.
The IO later smears this particular digital ration card, which is picked up from the house of the appellant.
Oh, they did not have that digital.
No, my lord. They take this from me, they smear it in the blood of the victim, and then send it to the FSL. Does not match with the postmortem blood of the victim. It is found degraded. That is another fact of the matter. But this digital ration card was never there. It only comes up during the time of the deposition of the witnesses, these eyewitnesses who had seen
at the site where the body was discovered. I mean,
yes.
Isn't there a list of items which were found?
Nothing of that sort. The eyewitnesses, their 164 statements are recorded. All these.
No, normally what happens? The articles found there are also not. There is no list maintained.
There will be a panchnama. There is no panchnama.
No panchnama.
No panchnama. Nothing. What happened was this PSI Arun Rai went there. He took these photographs. Then he thought that the body may be alive or dead. He was confused. He took the body, called a emergency vehicle, took the body to North Bengal Medical College and Hospital. She was brought dead at the North Bengal Medical College and Hospital. Next morning, the inquest, as I had indicated, inquest by some other police officer altogether. He goes there and conducts that inquest in that completely degraded manner. Inquest was never conducted. And on the point of occurrence, there was no Panchnama. Now, my lord, takes up page 11 thereafter. Page 11, point number 2, my lord. It is also relevant to mention that the entire narrative of the existence of a digital ration card at the alleged PO was alien to the prosecution and the witnesses examined, and the said seizure is a table work of the investigating officer of the case at hand, and this entire narrative is the brainchild of the investigating officer to falsely implicate the appellant by implicating his alleged presence at the PO.
So to connect you with the incident, there were basically three things. One is
Yes.
your wearing apparel.
Yes.
One is the digital signature and the CCTV footage, which is circumstantial evidence to show that you went
Yes.
that way.
That is it.
So you are hitting at the root of all three. 65B for digital.
Yes.
Regarding wearing apparel, section 27, as well as wet condition when received.
Yes.
And this digital ration card not in the photographs, nor came out in the witness or anything.
Never there.
Or no punch number.
Only at the time of deposition. When they depose before the court, they say that yes, we saw a digital ration card.
In the statements, there was nothing of that.
In the statements under 164, no mention of
Whose
any
statement would carry that? I mean,
because, my lord, these three eyewitnesses, I'll tell you, lordship, what happened.
There was no eyewitness.
I mean, who saw this man coming out of
going
the
and
cave.
coming, yes.
So after they saw this man running away in his bicycle, they visited the PO. They saw this girl lying there in this condition. Then one of them, Pushpojit Burman, went and called a police vehicle which was stationed right
No,
across the road.
who informed the police about this incident?
Pushpojit Burman.
Who was here?
One of them says that PW13, there is also a discrepancy there. Because three of them were at the point of occurrence. Minoti Modok, Neha Modok, and Pushpojit Burman.
They came there. They were of the vicinity.
Yes. Neha Modok says that he heard she was coming back from school. When she reached her house, this PO is allegedly behind her house. So when she reached her house after coming back from school,
She's a classmate of this detective.
no link.
Some others.
No link.
Yes.
Yes. So when she reached her house, she heard the sound of a girl crying from somewhere behind her house. She came out of her house, saw her auntie Minoti Modak standing there. So after coming out from her house, she tells her auntie that I'm hearing a girl crying. Let's go and check what is happening. So she takes her auntie Minoti Modak and another auntie present there who is never examined. Another auntie present there, they go to this particular place. They say that when they reach this particular place, they see the appellant coming out, a boy coming out. His and on seeing them, he covers his face with a handkerchief, and then he flees away in a bicycle. After he flees away in a bicycle, they go inside that iron gate and see this girl lying with all her apparels and everything. Nowhere during their examination do they mention that they saw this digital ration card. And my lord, there is another important aspect to this. After they see this girl, they also see this Pushpojit Burman going crossing that particular T. They call this Pushpojit Burman. He comes there.
They means who? Minoti and the guards.
Minoti and Neha. They call Pushpojit Burman. He also visits the place, sees the girl, and then he rushes off to a police vehicle stationed right across the road, and then he informs that police vehicle. And from that police vehicle, this PSI Arun Rai is the first person who visits the PA, who takes these photographs.
He was in the police vehicle.
Yes. He was in the police vehicle. He came to the PO and took these photographs, and Milord, then the investigation initiates in the manner that I just indicated. So, Milord, from nowhere can my presence at the spot be implicated. My wearing apparels, the FSL evidence is completely, Milord, completely, what may I say, Milord? It is laughable, Milord, to say the least. So, there is nothing to connect me to the crime. I have been, Milord, falsely implicated. I am only 22 years of age because, Milord, there are two very crucial differences.
And CCTV cameras were installed on the streets.
On the streets?
By the police, the
By
usual.
the police. And because I referred to the NVR there, these CCTV cameras are a part of a chain of cameras, a network of cameras. They see two of these
That was the source of your identification. I mean, the first identifying that this is the person.
Yes, the first point of identification was this policeman posted at Lexicon Mall who had seen me going with this girl.
Ajay, these witnesses who came there and saw you flee, they identified you later on.
At the dock. No test identification period in between. At the dock. And Lord, there are material improvements. I have indicated those in the written notes of arguments. This Neha Modok, Minoti Modok, material discrepancies in their evidence. They say something in their 164, says something at the time of deposition. I have indicated all of them. And Lord, this is the crux of my argument. And Lord, the judgments that I have referred to are, I have indicated the points
given the points also. Very
Yes.
well. Thank you.
I've indicated the paragraph numbers as well.
Right.
So this is not the crux of my argument.
Thank you. Yes, Dr. Chaudhary, what is your answer?
My lord, though the case is of circumstantial evidence, but my lord, the circumstances, as my learned friend has claimed, that there are broken links in the circumstances, but my lord, that is not correct. From the evidences, my lord, it can be
You are for the de facto complaint?
I am from the. But from the evidences, it can be demonstrated, my lord, that there are no missing links in the evidence. My lord, starting from the identification of the victim by the first person, my lord, identification of the accused person, sorry, who has seen the accused person coming out from the place of occurrence. My lord, thereafter, my lord, the seizure of the
Neha, Minoti both identify him.
Yes, they have seen. My lord, thereafter, the police personnel, my lord, has also seen, my lord, this accused person taking the victim girl in the bicycle.
Not seen. In the camera, they later saw. Police personnel themselves did not see.
No, my lord, the person who was posted in the who was
Lexicon, that
Lexicon mode.
Oh, he had seen.
Yes, taking the victim on the bicycle. Now, my lord, these corroborations, my lord, finds place in the electronic evidences, my lord, which has been taken out.
Is it a remote place? I mean, many people can be going there by bicycle.
No, this appellant was taking the victim in the bicycle. So, my lord, that was witnessed by the police personnel posted at the Lexington mode. My lord, two other witnesses, my lord, after hearing the screaming of this girl, my lord, when they goes to the place of occurrence, they find that this Abbas is coming out from there. The appellant coming out, and after seeing this lady, these two ladies, my lord, he covers his face by the handkerchief. My lord, that is one of the circumstances. And later, my lord, all these my lord, things gets corroborated from the electronic evidence, my lord, where my lord, it is categorically my lord, seen that he was actually indeed taking the victim girl on the bicycle. So, my lord, these are the three links on which, my lord, it can be inferred and it can be said beyond reasonable doubt that it was actually the appellant who had taken the victim girl with him. Now, my lord, from the place of occurrence, my lord, the wearing apparels was seized. My lord,
place of occurrence.
From the place of occurrence.
Wearing apparel of whom?
My lord, wearing No.
He was speaking of the wearing apparel of the appellant.
Yes, sir. Sorry, I stand corrected.
Then he must have denuded himself of.
Yes, I stand corrected. Lord, the wearing apparel of the
From his house later.
Yes, it was seized. My lord, it was sent to the forensic laboratory.
9 days after it was found to be wet.
My lord, I'll come to that, my lord.
Might have been raining when it was taken or something.
My lord,
or the policeman was crying, his ears might have drenched.
My lord, there are, my lord,
several possibilities.
My learned friend has, my lord, has dealt with his issues, my lord, in brief, but he has not taken your lordship to the relevant portions of the evidence.
That is to ensure that it's over during the circuit.
No,
you can take us to the evidence.
My lord,
Definitely.
Tomorrow, my lord, I'll take your lordship in brief. In very brief, my lord, 15 to 20 minutes I will take. I will conclude my arguments.
But now give us an indication. I mean, if you...
my lord, these are the, my lord, brief, because I also need to go through. My lord knows I was. Well, lord, my friend Mr. Ganguly will.
Let the state take over. Yes, Mr. Ganguly. You knew that the matter is there in the list, all of you. You should have been prepared. This is a second item. Very good. Yes. What is your answer?
Lordship, in this case,
65B, you are not prepared probably with this argument.
no.
Could not have been.
Can
Could not
give
have been.
answer to this, Sam.
Anyway,
Lordship, no one talks about gate video photography.
pardon?
Gate video.
What is that? I don't talk because I don't know what it is.
So, was of the same opinion, but after going through the evidence.
No, actually, I don't know. Gate video photography.
Yes, sir. And
GAT, gate.
GIT.
Achha.
Lordship,
You seem to be very technically savvy. You yourself.
He is a man of science, we are men of commerce, so.
No, that does not make
Lordship,
any
the thing
difference.
is-
Many men of commerce also gain knowledge.
Everybody is a man. The thing is, the movement of a particular person, like the thumb impression,
Hmm.
like the corona test, the movement of hand movement, body movement of a particular person does not match with another person in this world.
Achha, I didn't know that.
It is an unique identification. Like I'm talking, I'm my
Your
gestures,
gestures and yes.
everything. If I follow someone doing the same, then there will be some certain.
So your gestures will leave a trail. I mean,
Trail. This person
which is
that
your insignia, which is your unique to you.
unique, and it cannot tally with any other person in this world.
All right.
So this expert PW4 is an expert who was brought from Kolkata to capture gate video photography. He went to the correctional home, took videography of the person, of the appellant, his movements in a similar portion, took photograph of the cycle which was seized, which he admitted to be his cycle.
Now, where did he do these things?
He went to the correctional home when
Achha.
the accused was arrested.
So he was asked to move around.
Yes, Doctor.
So these are all on record.
All records. Page 94, kindly see this.
This expert came and
This
gave
expert-
witness.
Yes, page 94. And the CCTV footage
Hmm.
and the photographs recorded by this expert, it was tallied. And it was found that the person moving with the ill-fated lady or girl and the person, the appellant, their movement and their gesture tallies. So it is this person who was seen to be the person taking the little girl on the bicycle.
Hmm.
So page 94 is the deposition of Dr. Chitra Sarkar.
If he deals with photography, Chitrakho is a very apt name. Yes.
The first person is the Assistant Director, State FSL, Belgachi, Kolkata.
Highly qualified.
Lordship.
Yes.
Now his
No, that does not mean his evidence is
he's a
but
person-
genuinely qualified. Yes.
It is
Yes.
question number 3. My office received the prayer dated 7/9/2023 from the end of Osimati. So it was a procedure which has been followed. So she comes to page 5,
Para.
para 5. After getting requisition and on getting it enrolled by the superior head of the office, my team and I visited Siliguri Special Correctional Home on 14/10/2023 for the above purpose of taking gate sample video of the accused, namely Muhammad Abbas, son of such and such, in Kolkata. So after getting approval from the superior,
All these gate videos and all were exhibited.
Lordship,
This gate video.
Lordship,
Achha, let us see.
and 65B certificate issued by this person.
All right.
Then Lordship, 6. After visiting the correctional home, the gate video of the accused was captured in my presence and as per my instruction in a micro SD card in the same correctional home. So the movement of the accused, all those the procedures were followed in his presence at the correctional home. I issued 7, Lordship, a certificate under 65B.
I act at that time. This is the certificate duly prepared as per my instruction and in my presence and signed by me. It is marked as exhibit P12 PW4. Subsequently, I went to Matikara PS to capture the photograph of the seized bicycle in connection with the case. Now I pause for a moment. Why this cycle photo was taken?
Movement of the cycle, gate photo of the cycle.
Tally that the cycle seen in the CCTV and cycle which he admits
Cycles
to be
also have typical movements.
Lordship, there are marks in the cycle and other
Achha,
things.
maybe a bit tilting. I mean, very well. Maybe spoke movement may be different. Maybe.
It was captured. Not only the person, but the photograph of the cycle. He went to Matigara police station to capture those. Yes. I also prepared certificate on 65B. So regarding the photograph of cycle, 65B was also.
Para 9, there is a discrepancy.
On the same day, video footage from the seized DVRs.
Now there is DVR and NVR in his own certificate. They don't tally. In the certificate, he says.
Come later on. There is not a big deal of discrepancy as submitted by my brother colleague here.
What was it? An NVR must have been.
NVR is a DVR.
All right.
It's the working and like one and LAN.
No, I have come across cases where there's a distinction between the storage. The storage, either it's a network storage or it's a storage on a device.
In the
Now,
NVR,
does it have any?
It is the storage on the device.
So that difference does not exist between DVR and NVR.
No.
That's a different something else.
Device.
No, is the storage in the network according to you? No.
Yes, the first storage is in the camera itself because
Camera is not the network. Well, take your seat. Not in the cloud. I mean,
All the storage are, be it a DVR or an NVR, it is taken in that device. DVR, two newly
so he says here DVR and there in NVR.
Here, DVR.
You say substantially maybe same. All right, let us see.
Of the IO, this case, after completion of the process, I prepared 65B. At the time of say certificate was prepared by him, such and such. Page 10. Thereafter, the IO sees the footages and prepared a scissor list. I have handed over the relevant items mentioned in this scissor list to the IO. The case is further examined. Of this case for further examination at the state FSL after maintaining proper chain of custody. Now, Lordship, I postpone second. So,
yes.
So, till this point, what we see, Lordship? An expert in this field comes to the correctional home, takes the video movement of the accused, takes photographs of the, goes to the PS, take photographs of the cycle, collects, issues 65P certificate in relation to each photographs and video taken by him. The site was seized by the police investigating officer, and he in his presence and he signs in the seizure list. So till it was handed over to the police, the chain is completed.
But gate videography is a different proportion altogether. Gate video photography may be a corroborative material of the camera recordings, but gate video, no, that cannot comply 65. That's not a compliance of 65.
The photography taken and handed.
It's a corroboration, maybe a corroboration of that. But gate photography is an independent process.
Yes,
that by itself is not a compliance of 65B. 65B has to relate to that. If you say rely on the gate videography, then also you have to produce those materials regarding gate photography. An independent 65B. Yes.
I'm saying that when the photographs and videos were
Corroborated.
handed over to the IO,
Yes.
the certificate of 65B was given, showing that it is genuine and no tampering has been done with the same.
All
Now,
right.
analysis part, I'm coming later. Now, Lordship, I examine the along with the officer, but in appeals of this, the report on signed by the Now, kindly see, Lordship. 15. Exhibit S1, S2, S3, S5, S6 were returned by me after being repacked by me, sealed and labeled by me. The label bears my signature. The entire seal package along with the label are collected by the end.
What are these things?
Now,
Isfah?
what you see is this is a list. Exhibit.
No, in para 19 onwards, he says what are there in S1. Para 19 to 20. Micro SD card wrapper.
SD cards and other things.
Yes.
Those things.
Yes.
So, Lordship, what I just wanted to apprise Milords is that there is no breakage or any scope of pilferage in the process till now.
There was no Panchnama sort of thing. What was recovered from that spot, place of occurrence?
There is. I'll come to this.
That mentions the school bag and.
No, I'm coming to that.
What does a soil stained school bag come from?
Lordship, actually, what happened? It has been explained by the witness that he goes to this spot, seeing the body, he was shocked, but he takes the photograph.
The police officer was shocked.
Obviously, Lordship, a body
Mutilated.
sees the photograph, Lordship,
Mutilated.
so he takes the photograph only of the that part.
The face was sought to be mutilated. Brick.
By the bricks. No, due to brick. So any person, any human being will be seeing the and if little girl in a school dress. So everybody, so he takes the video, the photograph of that body only, but in a little away, the school bag, it was just thrown away, and by doing so, the
How do you get that? It does not find anything in the list. In any list,
it is there. Lord.
List is there. Somebody else came and then recovered the body.
I'll show it, Lordship.
He himself recovered the body. That police officer who took the photographs.
Yes, Lordship. He informed his superior. Then other
They came.
They even in the night also, but with the help of the torchlight and other lights, it was the total entire area was searched and recovered those articles. Lordship, I was of the opinion, but he'll continue, so I did not prepare that list. Lordship, kindly see is one thing, page 31.
Page 30.
30. It is the Caesar list. Place of Caesar, Lordship will find.
Yes.
Lelin colony, that is his house. Now, the articles which I
This is Caesar list from the house of the appeal that they have.
that. Now, here a point has been noted or raised that this Razia Khatun was not examined. And only one constable, Ruben Ekka, was examined.
The only independent witness of the Caesar.
In this regard, I would like to point out that, Lordship, in absence of any independent witness of the Caesar, does not vitiate the entire Caesar. If the court finds.
True, but here there was an independent witness.
But Lordship, if we see, he has admitted those articles to be of his own. Now see, number one yellow color flexible wristband. What is, Lordship?
Wristband.
Now kindly comes to page 175. Point number 98.
Yes. Admitted.
Yes, the wristband is mine. Top, Lordship.
Yes.
So I'll come to other articles also. So these questions arises if the Caesar and the articles were denied to his during trial.
PW10 stated that he can identify. PW10 was who?
Ruben Ekka. That is the constable.
So you are saying he admitted?
No,
yes,
the accused admitted. Now, Lordship, one thing. Now, one point I would like to place, Lordship.
Right.
what has been stated brilliantly by my junior brother that in absence of any statement under 27. Lordship, I humbly submit, if the police goes and arrests some person for arresting some person, and by virtue of doing the same, if some articles are recovered or discovered, no, in absence of any statement number 27, that seizure does not get vitiated. It is the I'll submit the guideline of Supreme Court in this regard, because 27 says when a person is arrested and after when he is in custody, he gives some statement regarding discovery of any article.
He says that since there was a search warrant, otherwise either search warrant or section 27 should have been there. 27, our impression was operates in a different footing. I mean, when subsequently it is discovered on
And
his
he
leading.
gave those articles to the police. It is not that leading to his statement, those articles were found from a place which is not accessible to all.
It was contemporaneous.
Contemporaneous.
It was simultaneous.
Because Lordship knows in 27, if the articles were found or discovered from a place not accessible to all, then 106 Evidence Act comes into play, that
Special
special knowledge. But if the place is accessible to all, then anybody can see those articles and say that those articles are lying there. So the chain is not completed. But here, at the time when the police went there, on inquiry, the accused brought those wearing apparels and handed over to the investigating agency. And during 313 also did not.
Why did he hand over? Brought and hand over?
Dr. Times is cross-examination of PW10, page 110.
There are
54.
PW 22.
54. 110, page 110.
Yes.
From 50, let's say from 50. 59.
Paper book is very loosely bound. Badly prepared. By
110, Lordship, from 49, Lordship.
Yes.
When we had gone to for raid in the house of the accused, we have found the accused sleeping in the house, in his house. 50. We entered the house of the accused after the mother of the accused opened the door. There, 51. There are 2 rooms and 1 kitchen in the house of the accused. 52. The accused was sleeping in one of the 2 rooms. 53. In which the accused was sleeping, there was no door. 54. Abbas himself took out his wearing apparels from his room. At that time, Abbas was wearing a lungi and a banyan. All the 4 items, that is black colored, black trouser.
This is stated by the police. Police officer.
Caesar witness.
The police, the party who read it. I mean, the arrest. Yes.
In cross-examination, Lordship. This is cross-examination, Lordship, not chief.
Should not have been cross-examined.
No, it is there. So, but another thing is, during 313, the accused does not deny the same. That those articles do not belong to him.
Cross-examination, how far this is?
May I just?
Lordship?
Cross-examination, in cross-examination, if some question is put. Anyway, so let us continue. Yes.
Now,
why was the lady not brought as a witness at all? The independent witness, Razia.
that
She's not there. If she was there, he would not have argued.
but can you see in 313,
Huh.
regarding the seizure of the digital ration card, the accused makes a statement. 313 কত নম্বর স্যার? কত পেজ? পেজ কত? ওটা বলো, সেটিংটা বলো।
174, question number 95.
Regarding that seizure, regarding bicycle, the cycle, kindly comes to page 167. Point number 58. Question number 58. PW4 has stated that he has identified the cycle which he examined at Matigara OS on 14/10/2023 for the purpose of matching with the crime sample video extracted from the seized DBR, and thereafter identified the said cycle which was marked as MO13. What do you have to say? Yes, the cycle was seized from my house. So he does not deny the same. And then regarding that digital ration card,
Yes.
he takes a plea. Page 169. 169. Lordship here. 168, last question number 67 regarding digital ration card. PW, may I read, Doctor?
Yes.
That PW6 has stated that he informed IC regarding this and he called the ambulance, came to the spot at that time, and thereafter said Sri Ashutosh Singhu and Ruben Ekka got out the stretcher and picked up the body and the bag and placed it into it to the ambulance and took the body to NBMCH. What do you have to say? Here, a particular another question was brought regarding the same. What he gives answer? It is false. Police seized the digital ration card from my mother. Now, what obstructed the mother to step into the witness box and depose that yes, the police has seized the digital ration card from me? A particular another question was made, but as he was tutored, so he forgot in which on the question what to answer and states regarding this digital ration card is from my mother. But this mother did not come in support of his son before the witness as a witness. Lordship sees page 29. Page 29. This is a list. Place of seizure from the PO. From the PO, that is Motajo near Rabindranagar, where the body was found. Now, Lordship, number 4 is the digital ration card in the name of Abbas. Now, I submit, Lordship, I humbly submit that it is the accused who has given the statement that it was seized from his mother. So this fact was a special knowledge to the accused, and the burden was upon him to show or prove that the special that it was seized from his mother.
Now, how was the digital ration card connected? It also had blood stain.
The PO. The girl.
How could it be found at the PO and at the same time recovered from his mother?
It is their plea that it was recovered from the mother, not from the PO. Page 29 is the seizure list, which shows that digital ration card was seized from the PO. But they have taken a plea. No, it was seized from my mother, and it was brought and soaked in the blood and sent for FSL. So this fact that it was seized from his mother was a special knowledge. The accused does not discharge his burden. In absence of the same, our case that it was seized from the PO at 20:45 hours. Logically says there was an independent witness to the said seizure, PW14. Page 120.
Pushpajit.
Yes, Lordship.
Page
120. Page 120. Question number 13.
Yes.
See the time, Lordship. This is the time same. At 8:30. That is the reason what I was stating, Lordship. when in the evening the body was found, the police came and just took the photograph of the body. But subsequently, when the police, a big team came and the entire closed boundary area was searched at 8:30 p.m. The school bag, the other digital ration card, because Lordship, if Lordship sees the PO, it is not a plain place, Lordship. It is covered by bushes. And during struggle, all those articles were scattered. All those articles were found at 8:30 p.m.
Why did she go with the person
I'm coming
on
to
the
that.
carrier of his cycle?
The girl is an immature girl.
What was her age?
She was a late learner. She was reading in class 9, but kindly see, Lordship, it will be clear.
9 is not so mature.
From the evidence of headmaster, it will be clear, Lordship. Lordship, can you see page 103? 103. This is very relevant, Lordship. Page 103, the headmaster, Anil Kumar Pradhan. Can you see question number 6? From question number 6. May I read, Lordship? As per query, I have replied that VG attended the school on 21/8/2023, that is the date of occurrence, and left the school at about 4 p.m. on 20/8/2023. So 4 p.m. that is the reason she was wearing the
School
dress and school bag and everything. Next, the victim girl was immature for her age and she was a late learner. The victim girl was very weak in studies and she was able to get to class 11 only because of the pandemic situation where almost all the students was promoted.
So she was about 14, 15.
I was 14 between. At this juncture, we can only assume that
They did not have any prior acquaintance.
No, Lordship. The appellant might have told that you are going home, I'll take you. She is immature. She believed and sat on the cycle.
But late learner is something else. Being weak in studies, I mean,
Immature, Lordship.
then some of us judges are also late learners. We're weak in studies, and not only that, we learn late. But that may not mean that there has to be a motive. I mean, why a chain of events has to be established?
Why
How he was
committed nothing?
Yeah, after she went out from she came out from the school, must be. All these have been.
It must be the accused has told him that.
Suppose the school Darwan or someone that she went out at this time, something to connect with this person.
Lordship,
A day labor goes by cycle, and this girl, she may be a late learner in school.
Immature, Lordship, immature.
Immature, I mean, class 9 students have to be immature, obviously, but immature is a very general term. But some connection has to be established between the two. I mean, this person going by a cycle.
But the reason.
No prior acquaintance, nothing. And no connection also. He does not belong to the school. The person is a day labor. No connection between the two. She's a school girl.
Whatever reason it was,
the
girl was on the bicycle of this appellant. It has been captured in CCTV.
Whether that was the same girl, we don't know.
Lordship,
This person might have been going with a different girl. It has to be beyond reasonable doubt.
To establish that I have been.
No.
Because
no reverse button, please.
Our case.
No reverse button in a criminal case.
Our case, we and then the police has seen this.
The police has established that this person was going by a bicycle with a girl behind him.
Lordship.
The deceased girl's movements could not have been captured by gate videography, unfortunately, because she expired. Now, therefore, what was captured was that this person was going and seen.
They were school girl of same school.
With school girl was also said by the lexicon police station. School uniform was
seen. And the digital ration card at the place of occurrence.
Yes.
Connects this person and the wearing apparel is from his house. And the blood stain tallying with the blood of the breath.
Wearing apparel, we are having a difficulty in gulping that it was wet after 9 days. You have to go. You can take instruction from your IO also.
I call the IO to come to.
Yes, take explanations on these tricky issues.
And tally to the blood also, the sample.
That tallied. No, that will happen if you plant him. That will happen if you no, because that is the allegation. Obviously, the insinuation is there.
So I'll give explanation regarding
Now, because it will be wet when it is brought after 9 days, just stained and brought.
to keep the blood alive.
Hmm.
The articles can be soaked in
Yes,
preservative.
yes, we were thinking about that, but you don't want to suggest anything.
Also cases where article was
Maybe, but no we won't take into account conjectures. It has to be clear from some evidence. Okay. We'll rise and sit singly after say 10 minutes within 10 minutes. Tomorrow onwards we'll continue up to 3 at least so that this matter can be over by tomorrow. Please ensure that this matter is over by tomorrow.
Things are complete, my lord.
What? Yes. Hearing matter we cannot take up now further. Say appeal hearing no.
Extension of interim order.
Yes. At extension hearing as well. The technical challenge matter. Yes.
If lady was final to for declaration that a woman here talented for taking the share of a father who have to go with the would be a divorce. If the London trial doesn't displace what you're holding, in the sense that the notification has came before 1981 Act came into force. Therefore, she's precluded from getting the heirs of shares of.
This will take some hearing, Mr. Ghosh. If you
Allowed, part, allowed the appeal court reverse the finding.
but what do you want now, Mr. Ghosh?
One if you was kindly keep the some time, it will take half an hour to get this disposed of. Day, before.
Appeal is very difficult to fix.
Since the project can ship back after 2 hours, I shall be there in the virtual mode. I have come for the lordship. Since I have given you lordship, assurance that I shall be coming to work. We are also there to.
You're there till tomorrow.
After tomorrow, but more I will leave to Wednesday at 2 o'clock.
If you have no preference, Mr. Ghosh. If you do it online in any event, there is no urgency otherwise of your presence.
My man was taken up for getting.
Second appeal we cannot fix, Mr. Ghosh. No preference. We lost our opportunity yesterday when it was taken up. We can no preference, Mr. Ghosh. Because you will not be there in any event the day after tomorrow. No, we do. I don't write. No fixation of date. Hearing matter, no, Mr. Ghosh. Yes, please. Okay. Yes.
Item 25 of today's list, Milord, if Milord kindly upgrades it, Milord, tomorrow.
No upgradation, Mr. Ghosh. No upgradation. Yes.
Application, admission hearing, along with this step. Already.
Yes, hand over. It has been admitted. Has been admitted for admission hearing. No, this will be for admission hearing. This will come for, yes. No, for last week, no, miss. No, for the English. No. Whatever is there in the list is there. Yes, call on the list.
Lordship, time for the petitioner.
When does it expire?
Even till the month of last of July. My will be taken on record.
What was the nature of the interim order?
Chief, this matter, my application under Order 8 Rule 6C was rejected on the ground that the opposite party had filed a counterclaim and wherein they should have filed us, they should have taken the method by way filing of suit.
In your application, what did you pray? Rules
And
8.
it's an authorship, wherein my
No, they filed a counterclaim. You have challenged that. That is barred by law.
order 8 rejected, the particular order.
Will extend for a limited period. And
Yes.
the interim order granted earlier is extended till September 15, 2025 or until further order, whichever is earlier. Full stop. The matter be listed before the appropriate learned single judge on the reopening day of the next circuit. Right. Affidavit of service filed to be kept on record. Next.
Lordship, in item number 2, I am appearing on behalf of the appellant petitioner, Your Lordship.
Yes.
Well, Your Lordship, I am appearing on behalf of the respondent.
Who is for the petitioner?
Lordship, I am appearing on behalf of the
No,
appellant.
yeah, your interim order is expiring when?
On 31st of July 2020.
Nature of matter?
Lordship, it's a surface application matter where there is an erroneous calculation that has occurred.
My lord.
Like,
227 is maintainable.
indeed, Your Lordship,
Oh.
because on 12/4/2019, the petitioner have filed a surface application. But if Your Lordship kindly have a look onto page number 24 in para number 5, it has been said that the instant surface application has filed by the applicant challenging the order LD ADM passed on 27/2/2019, and the essay has been filed dated 22/4/2019. Lordship, there is because the surface application has been filed within 45 days. But the DRT, they're saying that it has gone 53 days, Your Lordship.
This will extend for a limited period.
May I, my lord?
Yes, Mr. Bonik.
My lord, as per section 18,
Yes.
as per section 18 of the Surface Act, it is categorically mentioned, if in case of any order, the
Yes,
petitioner.
we understand, but the 227 has been admitted and it has been, I mean, at this stage, you have, it was.
On earlier occasion, I have raised objection.
Achha.
My lord, kindly fix it day after tomorrow. I'll for the purpose of hearing, complete hearing of the matter. This the petitioner have no authority to prefer this CO application without availing the opportunity of DRAT to Calcutta.
Unless it's palpably, certain judgments are there, palpable jurisdictional error. Where do we get the dates?
Lordship, in the list of dates. Copy that to देखिए.
No, it was filed within 45 days.
Your Lordship.
No, 53 days. After 45 days.
Where do we get the filing date from the annexures? Have you annexed the application which you filed?
Lordship, in
This is your list of dates. How do you know actually it was filed on that date?
No. There is no annexure.
my
Only.
Lord,
Yes, please continue.
my Lord, Mr. Shamal Dash will be leading this case. So today he
We'll
was-
extend for a limited period, put it next circuit.
Uh,
At the outset, an objection as to maintainability of the application is taken by learned counsel for the opposite party bank, in according to whose submission, Section 18 of the Surface Act provides a clear right of appeal, and as
Yes.
such, the jurisdiction under Article 227 of the Constitution could not be maintainable, could not be exercised. For the
Yes.
next para, keeping the question of, we find from the orders passed previously that the application has already been entertained and interim orders have been passed. Full stop. Next para says the matter is appearing for extension of such interim order, comma. The interim order is extended for a limited period till August 31, 2025 or until further order, whichever is earlier. Full stop. The revisional application shall be listed before the appropriate bench of the next circuit on the reopening date of the said circuit, comma, keeping the question of maintainability of the application open.
Grateful.
You have kept that question open. Please raise that question.
Yes.
Okay. Next.
Lord, it was taken up, Lord, during the last week.
Appeal has been admitted.
Yes, admitted. Your Lordship was considering the stay application.
Yes.
Millet has had passed an order, Millet, to amend the
Yes, yes.
title of the injunction application.
There is no caveat in this.
There is no caveat. Millet also recorded in the order that a supplementary affidavit be filed indicating the details of the execution case.
This was against eviction.
Eviction decree.
So now you have incorporated those phrases.
Yes, Millet has been done.
Well, as per liberty granted to the appellant by virtue of the order dated July 22, 2025, comma, a supplementary affidavit is filed today, which is kept on record. Full stop. I find from the supplementary affidavit that the prayer for injunction as made in Can 1 of 2024 has been sought to be modified to a prayer for stay of execution of the impugned judgment and degree of the courts below. Full stop. Next para, since the prima facie case has been made out for hearing of the appeal, comma, in view of the appeal having been admitted on substantial questions of law, comma, unless a stay is granted, comma, the appeal would be at the risk of being rendered infructuous. Unless stay is granted, accordingly, there shall be stay of all further proceedings in title execution case number 09 of 2024, pending before the learned judge, civil judge, junior division, district Alipurduar, in connection with title suit number 09 of 2017 till disposal of the application. First of the appellant stroke petitioner shall serve copies of the application on the respondents, indicating that the matter shall be listed before the appropriate bench in the next circuit, subject to being mentioned by the parties. First of the petitioner shall file an affidavit of service on the returnable date. Full stop. There shall be the parties shall exchange affidavits in the meantime. Full stop. It is made clear that the question of imposition of occupation charges as a condition of stay and, comma, if so, comma, the quantum thereof is kept open for being decided at the final hearing, final disposal of the stay application. Thank you. Yes. Filed within time, restoration
within time.
within time. What is the ground we have made out?
Medical ground,
Of the advocate?
Advocate's mother was.
I find from the application that sufficient ground for the absence of the petitioner on the relevant date has been made out, inasmuch as the medical ground pleaded in respect of the learned advocate for the petitioner. Full stop. Since none appeared for the opposite party as well on the date of dismissal for default, comma, applying the principle of Order 9, Rule 4 of the Code of Civil Procedure, the matter is taken up, the application is taken up for hearing ex parte. In view of the above observations, comma, Can 2 of 2025 is allowed, thereby recalling. Sorry, Can 1?
Yes.
Can 1 of 2023 is allowed, comma, thereby recalling the order dated December 11, 2023, passed in CO 9 of 2023, whereby the said revisional application was dismissed and restoring the revisional application to its restoring CO 9 of 2023 to its original file and number. Was there any interim order granted? The interim order granted earlier is also revived.
Then Can 2 was for staying the.
You have served on the other side?
No, Can 2 was not served.
The petitioner shall serve a copy of Can 2 of 2025 on the opposite party, indicating that the same shall be listed before the appropriate bench in the next circuit. The interim order was still disposal of the revision.
Disposal of the revision. We had filed the Can 2 for getting for in this respect for interim order again. That is already.
তাহলে Can 2 সার্ভিসের দরকার নেই। Can 2 of 2025 is accordingly disposed of in the light of the above observations. So was there a direction on you to serve the revisional application on the?
Yes, we have tried 3 times, but due to the insufficient address, that is affidavit of service in the record.
Well, the revisional application shall be listed in the before the appropriate bench in the next circuit. Next.
Item number 5, Lordship, I am for the respondent. Lordship, I am praying for next service, Lordship.
No.
Senior is medical in and he is
Registration? No, not next circuit. You are there, there is.
he admitted in hospital
Maybe you are there. Registration application, this is within time.
within time, but
But-
the fact is that the case is of different nature. Actually, the plenty
In registration, why should you go into that?
there is recalling order, not
Recalling on merits?
recalling on merits.
Then let them come.
Yes.
Learned counsel for the opposite party seeks an adjournment till the next circuit. Full stop. Accordingly, let the matter stand adjourned till the next circuit. Please give your names. Your name, not your senior's name, because he's not there.
I was for the original applicant.
Registration or recalling?
Recalling.
Full-fledged recalling. Recalling merit, is it permitted, Mr. Raman? Unless it's a review.
What the ground that they have stated is that on that very day, there was a no adverse order on the part, resolution on the part of the bar. And another ground they have taken is.
They have means you have taken.
And that is.
Your application,
opposite
Mr.
party's application.
Mr. Roy's application.
Yes, opposite
But then whatever I said applies to you.
Yes.
You take your seat. You are on a more secure position. Yes. Yes.
Your Lordship, when it takes up the evidence service once.
Well, the last one, I believe.
Page 19, subject question of the evidence service.
Yes.
I got it.
Yes.
That is EW number such and such 913IN.
9?
Last 4 digit 3913IN. My lord, got it. Page 19 of the
3913, where do I get it?
evidence service. My lord, can you consider the
Evidence of service, yes.
19. This is a track report has been annexed, my lord. I got it.
Track report is at page, different page.
19.
19, the affidavit of service starts. Page 19, affidavit of service starts, begins. First page of the affidavit. The first track report, annex.
Track report.
That is page 22 in my copy, yes.
Yes.
It's very illegible here. Which one? What is the number again?
Number is, my lord.
That EWO number?
Yes, yes.
Yes, what is
73913.
Which one of all these?
The applicant before your lordship.
Which one? Which one? There are several track reports.
Well, it takes up page number 35. Well, that is the track report that they are referring to.
Thank you.
Page number 35, my lord would find
No,
in the
no,
middle part, my lord, thereafter.
Not 35, subject to
No,
question.
sir.
It's very well
This is
then.
not here.
Yes,
This is
yes, yes, Mr.
This is refused, my lord.
Yes, page 37.
37 it is.
37, yes?
Yes. My lord takes up in the middle part.
No, let him, yes. Yes, Mr. Rai?
Address cannot be located, my lord, if your lordship can consider.
Then,
Return to the sender.
right.
The service was not affected, but
No.
one can consider the affidavit of service based on which the matter was taken up. That your lordship find.
This
that
is in respect of
me, the petition before your lordship, now applicant before
the
your lordship.
other opposite parties.
Some received, some.
Refused.
No, they are contesting along with you in the trial court.
The pro forma opposite party. He
It's
is
the
the
same-
pro forma opposite party.
the
Did
same-
anyone who is selling on your same boat in the
Yes,
trial
yes,
court?
because these are previously by
No.
the subsequent.
No, you are contesting together in the court below.
No,
There is no other. Very well.
now, can you turn to page 20?
20, yes.
My lord will find paragraph 2.
Soft copy including that. Duly delivered.
Duly
Yours is included. So on the
Paragraph 3, refused. EW 073913, when I got it, page 20.
yes, 913, yes. Yes, 913 refused. No. It states item delivered sender
Sender means the
and remarks shown in the post refused.
No, in other cases, in other matters, other
Very well,
numbers
yes.
mentioned, that is refused.
So you are not served.
Now, may I discuss? The lordship can allow us. And so the other ground is concerned, I am not pressing the same, my lord. It is something which is
What was the order passed? Let us see.
My lord, said the occupant's order.
Where is the order annexed in your application?
Supplementary.
Not,
Not given to them?
no.
Then?
আমাদের application টা equal to the-
Oh.
Yes,
Uh,
lordship.
21st of July order?
Yes.
It is, the main order is with me. Yes, let us see. No, not refer to the internal pages or the paragraphs.
Paragraph. Your lordship, I'll turn to paragraph 11.
Oh, the 23 rule.
Order 23 rule 3.
Please, my lord.
What two things?
Whether this, any order passed, if your lordship can consider it is an order under order 23 rule 3.
Misnomer. It was a misnomer. Could not have been under order 23 rule. That is a jurisdictional error. Treated to be order 23 rule 3.
Then if that be so, my lord, then this application is not patentable here. In view of the Supreme Court judgment, it will be before the same court. Now, my lord is of the opinion whether there is a.
Why before the same court? Court proceeded on a wrong legal premise. It's a jurisdictional error, which is amenable to 227.
That means also, the premises of the purpose of adjudication is so limited that only on the ground that is there something which has been done mischievously or fraud has been practiced to that extent.
No question of mischievous or fraud, Mr. Rai. No fraud was practiced here. It was, there was no fraud practice. The person who said he has signed, they have signed. But they were only part of the total array of parties. So that was a jurisdictional error. Why not maintainable?
Now, what you can logically consider, one is the modification of the order of injunction. That two things, my lord is told that in absence of any application of order 13 rule 4, whether the order of injunction which was granted by way of status quo has been modified by allowing to execute the deed in favor of.
You are a pro forma opposite party.
Yes.
No injunction was sought against you.
Same order, but two deeds are there, my lord. Clear, your lordship.
This
Was any injunction sought against? Oh, this 23, 23.3. It's a different proof, not injunction. No, by 23.3, the injunction was sought to be varied. But you are not, nothing,
And another.
you don't have a locus standi even to object.
Another deed was in favor of same order. And that is also subject matter challenge before the sovereign court and your lordship. Please.
While we consider that, we'll consider. Here you don't have. This does not affect you also.
He cannot, because pursuant to that order, this order, my order also been challenged before the sovereign court. That is CO number, which is my land reference also challenged. It's CO number.
140, my lord.
140.
That is fixed on Wednesday, I believe. My lord has directed to serve notice. There is no interim order.
Where it is proved to the statute that a suit has been addressed.
And in this, my lord, in this application, he is the pro forma respondent. Pro forma. And the order 23 rule 3 application, he is not a party there. How is he prejudiced?
Yes, exactly. How are you prejudiced?
That is why two deeds are there, my lord. Two deeds are executed pursuant to the leave granted by the land record.
No, that is at a different point of time, at different points of time.
So this order will not affect me. It is a submission of my land record. Record that because the
No,
premise.
that I have not said. How are you prejudiced? That is what I have.
That is why I presume can take up the order. Ask this 104 of 2025. Where your
Now
lordship.
let us look into this first. What is the error in this order?
I, if your lordship can consider the order impugned before your lordship. What is the order impugned before your lordship? Basically, takes up the civil division that.
Yes. 27th April order.
Last paragraph, my lord, notwithstanding it. My lord got it. Order impugned.
Impugned.
Yes, my lord.
Order impugned, isn't it dated to
Revisional application?
27th April order?
Yes.
Oh, the first page last, yes, notwithstanding everything?
Anything this court observed, the terms of compromise have not direct bearing with the prayer made by the plaintiff. Instant essentially a suit for declaration whether the right of the deed perfectly executed by the principal of the plaintiff in favor of defendant number 1 is challenged. In the compromise petition, this court finds the admission of the parties thereof with regard to the ownership or portion of the suit land. In clause 4 of the terms of compromise, it has been inter alia mentioned that the portion of transfer of property effected through the impugned deed is valid and portion thereof is invalid. Such declaration touches the interest of the other parties of the suit, and this court cannot decree the suit on the compromise on such term. At this, at the cost of repetition has stated, it appears that the purpose of the aforesaid petition is to effect transfer in of the portion of the suit property by plaintiff in favor of the defendant number 3, defendant number 5. This court can appreciate that the order of temporary injunction in respect of the suit property in force, and there is a practical difficulty to effect such transfer immediately, since the intended transfer is limited with the parties and subject matter of the suit. This court has no impediment to allow such transfer to take place. In view of the discussion made above, provided that it does not adversely affect the interest of the other parties to this suit. Besides, this transfer will not late future proceedings. In view of the discussion made herein before, the prayer for decree in respect of suit in part on compromise or is rejected. However, the plaintiff is given a permitted to effect the intended transfer in respect of the portion of suit property. So therefore, my lord, it is not an order by allowing the degree so part under order rule 3.
The other defendants challenge this order.
Yes.
Other defendants, defendant number 1.
No, I'm not the defendant number 1.
Defendant number
I'm the defendant number 6.
Defendant number 6.
It prejudices me. The suit.
Let him complete, Mr. Rahman.
I beg your pardon.
Then there is, I am the plaintiff. I intend to transfer my share, whatever, because last word that it will without prejudice to the interest of the other parties to this suit, which means regard such transfer will be subject to outcome of this suit.
This is a variation of the injunction status quo order.
If that be so, my lord, it is grounds of variation, then my lord also happy lies.
Could not have been done under Order 23 Rule 3. That is the jurisdictional error. If it was an Order 39 Rule 4 order, then appeal would have lay. But this was not under Order 39 Rule 4. Under Order 23 Rule 3, court neither passes an order under Order 23 Rule 3, nor passes, but passes an order under Order 39 Rule 4 without there being an application for modification. If there was an application for variation under Order 39 Rule 4, Mr. Rai, the yardsticks of that ought to have been satisfied. There is no consideration of that. That's the jurisdictional error. It's palpably bad.
Immediate hardship which has caused to the parties is there reflecting in the order.
No, there is no hardship period at all.
Yes, this court appreciate.
Yes.
Appreciate that a portion of the suit land by plaintiff is defendant number 5. This court appreciate that the order of temporary injunction in respect of the suit property in force, and there is a practical difficulty to effect such transfer immediately. So, undue hardship.
Ridiculous. Ridiculous. An injunction order means, Mr. Rai, that somebody is restrained from effecting a transfer. And the court says that Order 39 Rule 4 undue hardship is that injunction restrains him from transferring. That is the hardship sought to be imposed by virtue of the injunction application itself. Where is the undue nature of the hardship? I get an injunction against you, all the defendants, they cannot transfer. Yes, status quo is passed, nobody can transfer any part of the property. No appeal is preferred against that. Unless there is an order 39 Rule 4, you have to specifically say what is the undue hardship. Because you were present when the injunction order was passed, status quo.
Then it can constitute an application wrongly allow.
It was not an application under Order 39 Rule. But 23(3) was treated to be Order 39 Rule 4 and allowed. That is the difficulty. Therefore, revision lies, but order is without jurisdiction.
Whether it can be termed to be without jurisdiction in that sense. Nomenclature forget the nomenclature order is Rule 3. If my lord is concerned, it is an order passed.
The prayer was for passing a compromise. The court modifies that.
Court rejected by application.
No, not rejected. If the court rejected, no difficulty. Court molds the relief and grants something which is under an entirely different provision.
What injunction is it modified?
Mr. Rai, I file an Order 12 Rule 6 application. Court says no, I am modifying it to an injunction application and grant injunction. It's like that. Something entirely different. Lesser relief could be molded. Could be molded to a lesser relief. It's a different relief altogether. 39(4) and Order 23 Rule 3 are different reliefs. I cannot mold Order 23 Rule 3 and grant Order 39 Rule 4. This is comparing apples with oranges.
So therefore, my lord, the transfer which I have intended, there is no difficulty of transfer. The plaintiff intended to transfer. This is injunction sought for by the plaintiff. And my lord is considering on the
Status quo is granted on all parties.
status.
You are a pro forma opposite party.
Yes. Now, my lord, what happened?
You are a pro forma defendant in the suit.
No, not in the suit.
Here they have.
You are defendant number?
Defendant number 5.
Nine.
Defendant number, he is the defendant number 9.
And one can consider why I am aggrieved. Order টা কোথায় গেল? The
By
same-
virtue of this transfer must be some other transfer was effected in your favor.
same- Another order, similar order was passed, and your lordship was while admitting this application was pleased to hold that
Because of this order, that
because of that order is also liable to cancel.
so both will go. Both will go. I am first rejecting this.
Well,
And when it comes up on Wednesday, just remind me.
that is the premises. London Council cites the order that such and such in CO number 13 of 25, which is before your lordship.
This is a perfectly good order. No question of revisiting.
That way also. Even if my lord, whether the 23 lies, if that be so, if it is doesn't like that, my lord, it is a nomenclature of 39(4). My lord, I am bound to your lordship, order passed is illegal, per se illegal. Then my lord, can you consider whether this revision will happen, lies or not?
Revision lies.
Uh,
Learned Council,
And so for the
I'll allow the recall application and affirm this order.
then my lord, both the hard application be hard together, my lord. Because if that will become infructuous. When just my lord fixing that better, if you recall both the hard.
That is the intention. That is the intention. Then this will be cited and I'll say again a similar thing. It has been done, sir. Mr. Rahman just has to point out and Mr. Mukherjee will help him obviously. Unless you are there to help him. Yes, and you learned junior is
He said we are doing section 151. So he can.
he requires some more experience for that. He's right. I mean, I would have said the same thing if I was in his place. Rightly so. I appreciate that, but
Praying for. Otherwise, it will be that will be infractuous in view of this order passed. And
even if you are present beside the same order would be.
yes. I am not.
No, not you. I mean, your client. I mean, it was represented, then it would be the same.
I am not on that, my lord. Privacy, my lord. If that be so, my lord, then other revision applications no merit. I'll try.
Remind that on Wednesday.
That is why both the applications.
I've made up my mind on this. I'll do this. Right.
The application.
And one of 25 is an application for recall of an order dated July 21, 2025. Full Learned Council appearing for the petitioner argues that the petitioner, who was one of the pro forma opposite parties in the revisional application, was not served properly, which is borne out by the concerned postal track report annexed to the affidavit of service which had been filed on the relevant date by the revisionist petitioner, which indicates that the item was delivered to the sender, clearly indicating that the service was not effected on the present applicant. Full stop, next para. Upon hearing Learned Counsel for the parties, it transpires that the court proceeded on the premise that good service had been effected on all the opposite parties and had taken up the matter, whereas the present applicant, being a pro forma opposite party to the revisional application, was not served properly. Full stop, accordingly, there is merit in the application. Full stop, hence, can 1 of 2025 is allowed on contest, thereby recalling the order dated July 21, 2025. Full stop, the heard Learned Counsel for the applicant as well as the revisionist petitioner on merits of the revisional application. Full stop, by the order impugned in the revisional application, while taking up an application purportedly under Order 23, Rule 3 of the Code of Civil Procedure, the court molded the relief sought therein and allowed the application, in effect varying a previous order of status quo passed in the suit. Full stop, next para. In the impugned order, the learned trial judge clearly recorded that in the compromise petition, the learned trial judge found admission of the parties thereof with regard to ownership over portions of the suit land. First up, in clause Roman 4 capital of the terms of compromise, it was inter alia mentioned that a portion of transfer purportedly effected through the impugned deed within bracket impugned in the suit bracket closed was valid and a portion thereof was invalid. Full stop, the learned trial judge recorded that such declaration touches the interest of the other parties to the suit and the court cannot decree the suit on compromise inter alia on such terms. Full stop. The learned trial judge was perfectly justified up to this extent, comma, since, comma, unless all parties to a suit are parties to the compromise petition, comma, no compromise decree can be passed. Full stop. However, comma, the learned trial judge went one step ahead and going beyond the scope of Order 23, Rule 3 of the Code, comma, virtually modified the order of status quo which had previously been granted, comma, permitting a transfer to be effected between the plaintiffs in favor of the defendant number 5. Full stop. Next para. Such a modification was not only beyond the purview of Order 23, Rule 3 of the Code of Civil Procedure, comma, which was the entire premise of the prayer made before the trial judge in the application which was being decided by the learned trial judge in the impugned order, comma, the same falls within the same traverses into the domain of Order 39, Rule 4 of the Code of Civil Procedure, which provides specific parameters, comma, including including change of circumstances and or undue hardship being established for the purpose of a variation of the order of injunction stroke status quo. For the next para, since no application or prayer for variation of the injunction order was made, comma, it cannot be said that there was any application pending for adjudication before the court on the date of the impugned order within the ambit of Order 39, Rule 4 of the Code of Civil Procedure. For the next para, learned counsel appearing for the applicant herein, comma, who was a pro forma opposite party in the revisional application, contends that if the order is deemed to be one under Order 23, Rule 3 of the Code, comma, this court does not have jurisdiction under Article 227 of the Constitution to interfere with the same. Full stop. Even if it was an order deemed to be under Order 39, Rule 4 of the Code, comma, an appeal would lie and a revisional application would also not be maintainable in such case. Full stop. Next para. However, comma, neither of the said analogies are applicable here, since it is the impugned order is not an order passed under Order 23, Rule 3, granting a compromise, comma, as the application under Order 23, Rule 3 and the prayer made therein was itself turned down. Full stop. The jurisdictional error in the impugned order comprises of the learned trial judge having thereafter, comma, granted a relief which was beyond the scope of Order 23, Rule 3, comma, in the absence of any application having been filed at all under Order 39, Rule 4 of the Code of Civil Procedure. Full stop. The concept of undue hardship and stroke or change of circumstances is inbuilt in Order 39, Rule 4, and a specific case has to be made out by way of an application under the said provision by either of the parties to have an interim order of injunction varied, modified, and or set aside. Full stop. In the absence of any such specific application or case being made out, comma, the learned trial judge acted entirely without jurisdiction in suo motu modifying the interim order of status quo granted earlier, full stop. Thus, comma, the impugned order also does not pertain the character of an order passed under Order 39, Rule 4 of the Code of Civil Procedure, simply because there was no prayer under the said provision, nor any application for modification of the status quo order filed as such. Full stop. Thus, comma, the jurisdictional error as indicated above taints the impugned order in all respects. Full stop. Accordingly, comma, even after hearing affirmative, comma, yes.
This order was 2023. This revision challenge is 25. In the meantime, deed which was executed, which is lordship was pleased to direct to cancellation. I am praying before your lordship. Ultimately, the plaintiff, the suit is decreed. Then I can get the
Suit may not be decreed.
may not be decreed. Then
Accordingly,
we avoid with the result, but only that.
no, CO number 13 of 2025
Loan on the basis of the deed.
is allowed, comma, thereby setting aside the impugned order bearing order number 122 dated April 27, 2023, passed by the learned civil judge Senior Division at Jalpaiguri in title suit number 44 of 2008. No orders to cost.
My lord, the deed that has been executed, my lord, had mentioned it in the earlier order, my lord, which.
It is made clear that any action taken pursuant to the order impugned herein, comma, which has been set aside, and or any deed which might have been executed in pursuance of the same, stand hereby reversed, comma, revoked and annulled.
Grateful, lord, grateful.
Yes.
Number 7.
My lord, in item number 7, I am appearing on behalf of the respondent bank.
You are for the petitioner? Move your matter? Yes.
But only one submission I can make, that possibly my other side cannot take the point of maintainability.
Why
Only
not?
on the question of entertainability, whether the High Court will entertain.
This is against DRT.
Yes, against DRT.
That is against you. He is not required.
No, Millet, only if your lordship kindly
DRT section 18.
permit me, Millet.
This is against the DRT order or DRAT?
DRT order.
DRT Shiliguri.
It will open a floodgate.
Millet,
You are Mr. Pal or Ghosh?
Pal.
Yes, Mr. Pal.
1.5 minutes by the
1.5 hours?
minute
Oh,
by the
fine.
clock. Kindly permit me to rely upon a decision.
Definitely.
Millet is aware of. But the only thing I want to submit, Millet, is that Millet, it's a question of entertainability. It does not take away the
Maintainability.
Maintainability is not the issue. It's
Self-imposed restriction.
Self-imposed restraint and all this.
True, true.
And so that's my first.
No, whether we will
endeavor to-
entertain, we are only on that.
One thing, my lord, I'll just show your lordship why at the first day the Honorable High Court had entertained it. Once it has been entertained, the 11/9/2024 order is there. But it is a case, without going into the records and all, it is a case, my lord, where DRT has passed an order on the basis of, if your lordship kindly come to page 362 once, my lord, passed an order on the basis of a document which running into 8 pages and only 2 pages are filed. Can you see? And on the basis of this and the photostat copies of the all documents, a decree is passed against me and liability is fastened on me. Can you consider
You
page
can take
3?
all these points in an appeal under section 18. Take those points. Those are kept open. I'll keep.
Submit one thing.
Yes, I'll keep those points open. I cannot adjudicate. If I don't entertain, I cannot also touch the merits. And I'll leave it open for you to prefer a proper challenge, and you will get the benefit of section 14 of Limitation Act.
2017, my factory physical position taken over, all the things are lost. 2018,
In fact, in an appeal, the scope will be wider. You will be able to take factual.
for me.
Why would you say that?
Because in 2017, my factory position has been taken over by them. All the goods are lost. I am fighting as essay against them. In 2018, one fine morning, they came and ousted me from a residential house. And I am continuing this litigation from the street. So from this particular case, it's a completely illusory. Your lordship knows much better than me.
Illusory. If it,
18, the proviso mallet. I need to.
that does not mean it's illusory.
Me.
No, illusory. Suppose no materials are there before the trial court. The suit is decided either way. If I go.
That I can show your lordship from here. That
No, you said there was a dearth. The entire material was not produced. This is a factual question which has to be looked into.
And then these factual issues it's an admitted position because A to Z, all the orders I have, my lord, annexed from page number 402 to
Yes.
448,
Hmm.
which shows, my lord, there was not even a single order which records the original documents or even filed. Far to speak of me getting an opportunity of inspection and discovery. My lord,
Did you take this point in the tribunal?
Yes. And my argument has been brushed aside.
Was it recorded that you have taken this point?
I can demonstrate from my notes of argument I have filed, and the notes of argument, it has been recorded that in notes of argument, whatever points I have taken, that is not being considered. Even the judgments I have submitted. Is
My learned predecessor judge, while admitting this, has recorded that you are aggrieved that while deciding the point of maintainability, tribunal could not have entered the merits. What was the issue of maintainability you had taken?
After transco, there was a judgment, my lord, of Patna High Court, which said, my lord,
You are a prior tenant.
no, I'm the owner of the property.
Yes.
My lord, it said, my lord, what happened, my lord, initially the surface proceeding initiated. I continued, I challenged that, filed section 17, certain amounts were deposited, around 95 lakhs. Thereafter, they initiated OA application. Now the Transcourt said, my lord, even during pendency of the OA, the surfacey application can be proceeded. I mean, bank can proceed surfacey. But there is only one judgment, was only one judgment of the Patna High Court, which said, my lord, it's not vice versa. If the surfacey proceeding had been initiated by the bank, then it has to reach to a logical conclusion, right? Sale or physical possession, then only bank can file a OA application. Now, I can show you, Lordship, there is an order which records that the tribunal proceeded to hear my matter, the IA and OA both. I did not waste the tribunal's time. Page 447 is that recording, 448, where my lord will find that both the IA and OA I argued. Then while passing the order, there is no reflection of anything in the IA, and that particular point, my lord, it was not required that he should write it mechanically, I take up IA number such and such, but that issue itself has not been addressed or at all dealt with by the learned tribunal below in the final order. And apart from that, my lord, my lord, page 448, the matter is listed today for the argument on behalf of the defendants, but in the meantime, OA bearing has been filed regarding maintainability. Heard the learned counsels of both the parties on IA as well as OA. List the matter on such and such for passing of order on IA as well as the OA. Now, if your lordship kindly takes up which 457 onward, my lord, it is a little voluminous order, but my lord...
Was the maintainability point decided at all?
No, he has not even...
And IA not reflected also?
IA not. It is like a situation where my suit is disposed of, my IA is kept pending. And my lord, there is one more point, my lord.
So you say that IA, the maintainability had to be decided. It could have been decided with the final, with the OA, but the maintainability point had to be addressed at least.
At least.
Not addressed here
Not
anywhere.
All, my lord.
On merits, totally on merits.
Totally on merits.
Yes, Mr. Bonik, why shouldn't this be a palpable jurisdictional error?
My
We'll
lord,
direct a rehearing on the point of maintainability along with the OA. First decide maintainability, immediately after decide the OA.
my lord, everything could be decided.
Could be. That this is a palpable jurisdictional error. Why should we relegate the party to deposit that proviso deposit and all? I mean, this is 227 jurisdiction is not curtailed. Yes, we impose a self-imposed restriction, Mr. Bonik, definitely hundreds of judgments on that. But if I choose not to impose that self-imposed restriction on valid grounds, that this is a palpable error, we don't need to look into any document whatsoever, only the orders of the tribunal itself, two orders, the final order and the order at page 448 is sufficient. IA was kept with OA for maintainability issue to be heard together. Then at least if you do, even if you don't decide IA, decide maintainability and then OA. Had to be decided. Justice must also appear to be done. This is palpable jurisdictional error. We are going only by the orders of the tribunal, Mr. Bonik. I am not looking into one page. The other point raised by your learned friend, we are not looking into. Maintainability point only first. Then the other point, yes. If it was only on whether the entire document was produced as initially raised by your learned friend, then I was in some doubt whether the tribunal should be canvassed in appeal. But this is palpable. IA fixed, maintainability point fixed to be heard along with main matter. Not a single line of maintainability. Will set aside the final order, will direct the IA to be heard along with the OA and the tribunal to decide the maintainability point first, and then it can repeat its judgment. He will go up in appeal. We'll do that, Mr. Bonik.
My lord, recently there is a judgment of Honorable Supreme Court,
yes,
wherein in Bharimodgu Reddy
yes,
versus B. Srinivasan
yes,
in 16th November 2022.
What has been held, Mr. Bonik?
It is also mentioned any kind of order in paragraph 32 of the said judgment. It is mentioned any order of the tribunal was an appealable under section 18 of the Surface Act 2002, and in the ordinary course of business the borrower person aggrieved was supposed to avail the statutory remedy of appeal, which the law provides under Section 18 of the SARFAESI Act. In the absence of efficacious alternative remedy being availed, there was no reasonable justification tendered by the respondent borrower in approaching the High Court and filing writ application assailing order of the tribunal dated 1st August 2019 under its jurisdiction under Article 226 without exhausting the statutory right of appeal available at its command. This is the judgment. I am referring the judgment.
Have you got a copy of the judgment?
Yes, I am tendering the judgment. My junior is there.
Have a copy of the judgment.
Uh,
You are his junior. Lordship, I am his junior. I have not.
Yes, I am forwarding. I am forwarding through online, my lord.
In the course of the day.
I am forwarding through online, my lord.
I'm considering the judgment.
My lord,
Yes,
may,
yes.
may I respond to this?
No, we are allowing your application.
But this judgment is on surface and this is in way RTDBFI Act. It's not a surface.
Yes, but the
Principle applies.
Principle, but the principle. That is my submission, my lord.
Where is the application original OA?
Original way, my lord, starts from, my lord, page number 49, my lord. Can you come to page 51 is the index under it. Constantly is at page 53, my lord.
$49.
You took a point that unless the 17(1) proceeding was concluded, this section 19 proceeding could not be taken up. That was your point. The present dispute arises out of an order, out of a final order passed by the Debts Recovery Tribunal in connection with an application filed by the opposite party number bank under section 19 within bracket 1 of the Recovery of Debts Due to Bank and Financial Institutions Act 1993. The act name has changed.
Recovery of Debts and Bankruptcy Act 1993, but it is
But
amended now.
when it was filed, it was 1993. Full stop, in connection with the said proceeding, comma, the present petitioner stroke borrower filed an application challenging the maintainability of the said proceeding on the ground that unless a pending application under section 17 within bracket 1 of the SARFAESI Act 2002, comma, which was pending at that juncture, comma, was finally disposed of, comma, the bank could not initiate a proceeding under section 19 within bracket 1 of the 1993 Act. Full stop. By an order dated January 8, 2024, comma, the learned tribunal categorically recorded that it heard learned counsel for both parties on the IA within bracket the maintainability application bracket closed, as well as the OA within bracket the substantive application under section 19 within bracket 1 of the 1993 Act bracket closed, and the matter was to be listed on the next day for passing final order on the IA as well as the OA. Push up next para. However, comma, while passing the final order on February 26, 2024, comma, which is impugned here in comma, the learned tribunal, comma, without spending a single line or adverting to the objection as to maintainability at all, comma, as raised in the IA, comma, went on to decide the OA on merits. Push up next para. Learned counsel for the petitioner argues that the said judgment and order dated February 26, 2024 was not only in violation of the tribunal's own order dated January 8, 2024, but was also patently without jurisdiction, comma, since it is well settled that if an objection as to maintainability is raised in any proceeding, comma, it is the cardinal duty of the tribunal or the court to decide such issue first before going on to proceed the main matter on merits. Who's up next para? Learned counsel places reliance on the judgment of Godrej such and such, namta dekhe kore deben, reported at 2023 SCC Online SC 95 in support of the proposition that even if there is an available equally efficacious alternative remedy, comma, it is a question of the court, of the High Court, imposing a self-imposed restriction if it does not want to interfere therewith, but not a question of maintainability of a challenge under a constitutional provision. Full stop. Next para. As such, comma, it is argued that in view of the palpable jurisdictional error committed by the tribunal, comma, the petitioner may not be relegated to the alternative remedy of appeal under Section 18 of the SURFACE Act, under the 1993 Act, comma, pardon?
Appeal is,
2002.
appeal is under section 20.
SURFACE Act.
The appeal is under section 18,
Mine is section
2002.
17.
Appeal is under
Appeal-
2002 Act.
2002 Act, my
That is
lord.
what we are saying, yes.
Yes.
Under the SURFACE Act. Push up next para. Learned counsel appearing for the respondent bank, opposite party bank, further contends that the Supreme Court, comma, in the recent judgment of, please give on a slip of paper, please give
Yes,
the cost title list at least to my officer so that they can incorporate the cost title and we'll look into such and such, comma, কি সেন্টেন্সটা বললাম শঙ্কর? Contents that in the recent judgment of such and such, comma, has held that ordinarily, comma, any order passed by the tribunal is amenable to an appeal under Section 18 of the SURFACE Act. Full stop. Next para, comma, accordingly, comma, in view of availability of an equally efficacious alternative remedy, comma, the High Court ought not to interfere in its jurisdiction under Article 226 of the Constitution of India with such an order of the tribunal. Full stop. Next para. Upon a careful consideration of submissions of learned counsel for the parties, comma, this court is of the opinion that even taking into consideration the judgment cited by learned counsel for the bank, comma, the said judgment lays down the ratio that under ordinary circumstances, comma, the in view of availability of an alternative remedy of appeal, comma, there shall not be any interference by court under its constitutional review jurisdictions. Full stop. Next para. However, comma, it is a well-settled proposition of law that there is a qualitative difference in interference where there is an implicit bar in the Code of Civil Procedure and where there is a bar under other statutes pertaining to tribunals insofar as interference under Article 226 and 227 of the Constitution is concerned. Full stop. Whereas in the former case, comma, the bar is construed to be near absolute, comma, in the latter cases, comma, the court has to look into whether there has been an error of jurisdiction which is palpable on the face of the records. Full stop. Next para. In tune with the ratio laid down in Godrej Sara Lee Supra, comma, it is not a question of an application under Article 226 or 227 of the Constitution not being maintainable in view of the availability of an equally efficacious alternative remedy, but more of a question of entertainability. Full stop. A constitutional remedy under the constitutional remedy of jurisdictional of judicial review as enshrined in the Constitution of India has been held to be a part of the basic structure consistently by the Honorable Supreme Court as well as different high courts of the country, and as such, thus such right cannot be fettered or curtailed by any provision of any statute which is subordinate to the authority of the Constitution. Full stop. Next para. Undoubtedly, comma, learned counsel for the bank is justified in submitting that in normal circumstances, comma, such jurisdiction is not exercised where there is an equally efficacious alternative remedy. Full next para. The question in the present occasion is, however, whether the tribunal has committed a gross jurisdictional error and an abuse of the process of law, to ascertain which not a single document or averments made before the tribunal are even required to be looked into. Full stop. Even on a cursory perusal of the order dated January 8, 2024, passed by the tribunal, it is clear that the tribunal had fixed the question of maintainability as raised in the IA taken out in the IA taken out by the petitioner bearing number 24 of 2024, along with the main OA. Full stop. Thus, as per the said order, it was incumbent upon the tribunal to at least consider the question of maintainability prior to deciding the OA on merits. Full stop. Here, twofold jurisdictional error has been committed by the tribunal, which is glaring ex facie, Roman 1 niche. The OA itself was disposed of without disposing of the connected application bearing IA 24 of 2024, niche line Roman 2. The question of maintainability having been raised on the face of it and based on law, had to be taken up by the tribunal before proceeding to decide the OA on merits. Full stop. In the present case, by the impugned order, the tribunal did not advert to the maintainability objection at all in any manner whatsoever, let alone deciding IA 24 of 2024. Full stop. Hence, the impugned order is palpably tainted by jurisdictional error, and this court finds no necessity to unnecessarily relegate the petitioner to the alternative remedy of appeal under section 18 of the 2000 of the SURFACE Act, which would be illusory as rightly contended by learned counsel for the petitioner in view of the prohibitive prior pre-appeal deposit mandated under the appropriate under section 18 of the said act. Full stop. As such, CO 113 of 2024 is allowed on contest, thereby setting aside the impugned order bearing bearing the order dated impugned order being the order dated February 26, 2024, passed by the learned presiding officer, Debts Recovery Tribunal at Shiliguri in its TOA.
Yes, madam.
TOA number 636 of 2017, arising out of OA number 555 of 2015, and remanding the matter to the tribunal for a fresh adjudication. It is made clear that the learned tribunal shall first decide the question of maintainability of the said OA by deciding IA 24 of 2024, and thereafter, subject to the outcome of IA 24 of 2024, either take up the OA for disposal on merits or drop the OA, if the maintainability is decided in favor of the present revisionist petitioner. Full stop. It is expected that in view of the long pendency of the matter, the tribunal shall expedite the matter as far as the business of the tribunal permits.
My lord, kindly fix the time, my lord. 1 month.
Tribunal, how is the tribunal placed, Mr. Bonik? We don't know that.
Tribunal is functioning regularly.
Very well. যেখানে বললাম, as the business of the tribunal
kindly fix the time.
Permits, preferably within 3 months from the date of communication of this order to the tribunal.
Grateful. Grateful.
I'm just giving the name, cost title of the citation.
Yes, but yes, very well.
Yes, I'm sending the.
Yes.
That last paragraph, your lordship has.
No, you file a copy also. That number right now you give to my officer.
I'll do it.
But file a copy for the records also.
Yes, yes, yeah. I'm sending.
No, Mr. Bonik, I'm telling you junior. Yes.
Yes.
Paragraph.
What did I say?
Your lordship has recorded that because of the punitive and the pre-deposit, that would be under section 21 of RDDB Act.
Oh, sorry. 18 বলেছে, 21 হবে. Thank you. Yes, you are right.
I'm grateful.
Thank you.
She's grateful.
Thank you, Mr. Bonik, also. Yes.
I am grateful, my lord.
Yes, next. But
Number 8. I'm for the wife opposite party number 1.
opposite party. Although the opposite party is present, none appears for the petitioner. Let the matter stand adjourned for the day. There's a resolution, so I'm promise bound to the bar to not to. Yes. Yes.
Lordship, the mediator was present, Lordship. I was appointed a mediator in item number 8, Lordship. I will give my name. Yes.
No, come back to.
Or I'll come back.
এটা কোনো order record করতে not today করে দেয় পরেরটা no in this next matter 9
No, in 8.
no 8 come back tomorrow 9টা কোনো order record করতে হবে না যে বাড়ির রেজলিউশন আছে এগুলো কেউ না থাকলে not today করতে দেবো কল করুন not today করুন 10 9 not today bar resolution not recorded in any order 10 also same
10, Lordship, I am appearing for the respond number. There is a resolution,
let it be not today we are not recording in
I am for the respondent bank, Your Honor.
right we are just making it not today have a resolution of the bar so
Yes, Your Lordship. Yes.
I appear for the petitioner, madam.
you did not know of the resolution because when you came for you are there till tomorrow Mr. Sen stay on for one day enjoy Jalpaiguri why Jalpaiguri apart from the rains there's a specific time the rain is going on according to a schedule so if you go out right now you can catch some glimpse of the beauty of either the jungles or whatever come back tomorrow the other side is there if you are agreeable I can take up
State of West Bengal, not a private party.
do you seriously expect that they'll be there Mr. Lakshmi is there I can regularize his appointment and come back tomorrow Mr. Come back tomorrow
Number 12.
Lordship, I am for the resolution.
both sides present
Lordship, I am handing over the copy to you and praying for in the next circuit, this matter.
next circuit
Next circuit.
what copy here
Last order is given was recorded to serve copy.
Acha.
First copy.
A copy of the revisional application is handed over to the learned advocate for the opposite party here and now. Please don't record the name of Mr. Mujumdar. Is he appearing online? Don't record his name. You give your own name, yes. To the learned, because I've stated learned advocate for the opposite, that's right. Learned advocate for the opposite parties here and now. Puts up on the prayer of the petitioner, let the matter stand over till the next circuit.
Grateful, Lordship.
Thank you.
Lordship, next item.
Same, Lordship.
Same.
12 and 13 same.
Same order? But don't hand over the same copy.
Grateful, Lordship.
Order is same, yes.
Order.
14, yes. By default not today করতে যাও যদি both side থাকে নিয়ে নেবো
Number 15.
same
Number 16.
Under the petitioner, Lordship.
is there any caveat
No, Lordship.
if you want to do the matter I'll hear you if there's no caveat there is no compulsion it's your choice somebody appeared for the opposite party
But there was this direction of service on the opposite party and I have served also.
oh then don't not today somebody might be appearing in there first time motions no caveat you can move I can take up any matter if you want to do but it will embarrass you later in the bar
Number 17.
same not today
Number 18.
any matter in which both sides are there both sides give an ad who is on your other side give an advertisement if the other side is unless both sides are there then I'll no use calling on all the matters and exhausting my officers
There, 9 opposite party from the lower court.
you can see
29.
call him which item
Item number 21 and 22, Mr. Rai will conduct.
Which Rai?
Karthapatindra. So the matter of 12 and day after tomorrow.
that's why he was hiding
He will come.
so not today let us he will come physically
Yes. Day after tomorrow. Day after.
no let him in the list tomorrow let him renew his prayer if I call You will also have to come from somewhere. You practice here. So you renew your prayer again if I call. Tomorrow we don't know whether I'll reach this much. Very good. Yes. Chalo. We are rising then. If both sides are not there in any matter, I'm
New motion, Russell item number 23.
accent. 23.
23.
ঠিক আছে,
Sir, I am for the other 23, Lordship.
Mr. Devashish Chakraborty will virtually appear. Lordship.
Was there any direction for service?
No direction. New
20
motion.
23.
23.
23 তাহলে 19 থেকে ডেকে যাও, পরপর ডেকে যাও 19. Not today.
Millet, item number
No,
19.
no, you'll move the
Millet.
matter. Are you wanting to move the matter? This is appearing for the first time or there was a direction for service?
Affidavit service is ready.
Mr. Ghoshal, there is a bar resolution, local bar resolution here.
I understand.
So we'll
Millet,
take
I
it up
understand.
tomorrow. Yes,
Fair
19,
enough, Millet.
20 টাকা. Same, not today.
Opposite party, Mr. Parthapratim Roy will be appearing.
Not today.
Lordship, day after tomorrow.
No, not today. Next. Not recording any order. Same. 23 টাকা.
Sir, I am appearing on behalf of
This is appearing for the first time, no caveat, right?
first time, Lordship.
Yes. What is the
There is
matter?
no direction for service, Lordship. Lordship, challenging the order of the learned District Court Tribunal, Jalpaiguri, this civil revisional application has been filed, Lordship. I know my fast
No,
filed
no.
issue.
Won't entertain. Normal course, no.
Lordship,
Go before the go before the appellate tribunal.
Let me give you one submission, Lordship.
Yes.
Lordship,
Yes, Mr.
this is a second law. Lordship passed the order. Lordship, second law, the CGM has to record the satisfaction before passing the order under section 14. And
Right.
in my case, I have challenged this clause because the CGM does not record the satisfaction before passing this order. It is transferred from his order, Lordship, and we have raised this issue before the tribunal, and we have relied upon the judgment of Krishna Builders and Silam Lordship passed this order. Lordship knows very well. And Lordship, kindly see once. Lordship, kindly come to page number 82 once. 82. Not a single word recorded that the CGM has considered or produced the affidavit, 9 points affidavit, and not even record the satisfaction. Let's kindly see the paragraph from rupees such and such. Thereafter, respondent submitted original document. Respondent submitted original registration documents. Then applicant submitted original documents at the time of hearing. The documents were duly verified and returned. Later, the authorized officer also shown an affidavit stating that there is no stay order from any of the court on the Schedule A property and that is not in possession of any lessor or sublessee tenant. It is abundantly clear from the documents submitted by the applicant that the respondent borrower submitted original title deeds and such and such. This is regarding the mortgage. Now, considering the materials and record, this court finds it necessary to pass an order as
No, the essential ingredients are satisfied. They
Nothing
showed
has
the
been
authorized
recorded.
officer had shown an affidavit.
There is not a single word recorded that the affidavit, 9 points affidavit has been filed, or he has perused the affidavit, or he has considered the affidavit, and not the satisfaction. And regarding this issue, Lordship, kindly see the impugned order once, page number 4. He has the learned tribunal recorded.
Yes.
This paragraph recorded by this tribunal, and no observation, Lordship. It is stated law, Lordship, before passing the order under section 14, the CGM or DM has to record satisfaction. Lordship, it is stated law. There are other points.
But then essential ingredients of that affidavit, those are recorded in this order.
No, Lordship, not recorded. And learned tribunal relied upon the judgment of Jalpaiguri cold storage, and he said that recording of 9 causes affidavit is not necessary. He has to only consider that whether the 9 points affidavit has filed or not. If you Lordship kindly see page number 4 of the impugned order and page, as well as page number
No, where is the
Yes.
certified copy of the impugned order? You should have given that. There is no certified copy of the impugned order. You are challenging that section 14 order.
No, no, Lordship, I have challenged the order of the tribunal, Lordship.
No,
We have-
that
we
you
have
have to
filed-
prefer. That you prefer a challenge
Lordship,
before the appropriate forum.
Lordship, kindly.
This is
Lordship,
post facto.
palpable-
Section 14 is post facto. No, no.
Lordship, for palpable irregularity, Lordship, palpable irregularity. I am relying on the judgment of the Godrej family, which is just now referred by another council, Lordship, and I am relying upon judgment of the Kerala High
No,
Court.
no.
Lordship.
Why should I? Normal circumstance, it is not done. There is nothing abnormal
Lordship,
here. The main
it is
order,
palpable
main judgment, main
irregularity.
order is on. Sorry, main order is on merits. There is nothing in the main order. It requires a
No,
consideration under.
nothing observation has been recorded, Lordship, in this issue, nothing observation. And even Lordship knows very well under section 14, the 9 points affidavit has to be filed. And one clause is that whether the payment has been made or not after any payment has been made or not after the issuing the notice 13.2. We have made the payment after notice under section 13.2, but Lordship, the Latin tribunal did not observe a single word regarding that issue, Lordship. If you Lordship kindly come to page number 5, the paragraph 11.
Several
he has
judgments
only
have been
spoken
in page number 7. Several judgments have been cited. Now, court
Lordship,
considers
Krishna Windows has been cited, but not
considers syndicate
regarding the observation.
considers syndicate bank also that no format. There is
No
no format for
observation has
passing
been
the
made.
order.
Clear observation has not been made, Lordship. That will be Lordship. I am relying upon judgment the Kerala High Court and the
No, Kerala
Honorable-
High Court. Several Supreme Court and Calcutta High Court judgments have been referred to.
If palpable ambiguity is there, Lordship, the civil divisional application, Lordship, is
This is a
reasonable, Lordship.
detailed. This is a why should I interfere? This is a
No,
detailed
Lordship,
order.
Lordship, it looks detailed, but nothing has been there, Lordship.
No,
It's
no,
a
all the
card copy
judgments have
paste
been
order.
considered. No, no.
It is Lordship card copy paste order, Lordship. Kindly, if you Lordship,
Just
very
see, so
thoroughly,
many
very
orders have
thoroughly
been.
appeal.
Let us come back tomorrow. We won't
Lordship,
hurry
may I,
on this.
Lordship, I beg to appear on behalf of the NBFC, Lordship. Autumn Investment, not Lordship.
Acha, let us come back tomorrow. We'll take up this matter.
Lordship, very fine, Lordship. Alternative officious remedy is available with them, Lordship. This is my submission, Lordship.
Yes,
And
yes.
a detailed order is being passed, my Lord. This is not the first round of litigation.
Apparently,
Earlier
yes,
one-
detailed order is passed. Apparently, you are right, but since I am against your learned friend, therefore he should get some more opportunity of hearing. Prima facie against him. I'm unable to change.
No,
So let us
that's-
come back.
that-
Let us
I
come
go
back
down
tomorrow.
to that, my Lord. My
We
Lord,
cannot
only
be too
one
hasty
fact-
on this. If I
only
was in
one fact, my Lord.
his favor, I would be hasty. But if since I am against the petitioner, he should be given some opportunity. I'll hear you also, Mr. Mishra. Come back tomorrow.
Grateful, my Lord.
Yes,
Much
sir.
obliged, my Lord.
Yes, yes, Mr. Mujumdar.
Matters was listed before your lordship today, but could not be taken.
Which four matters? Just.
Food corporation.
Right.
My lord, I'm very tricky to expose, my lord. Tomorrow I have to go away to.
No difficult. Why are you?
I am for the petitioner bank.
My lord, kindly places this matter on Thursday. Your single bench top of the list.
Mr. Mujumdar, just because you have this is sufficient notice, the bank is present, the other side is there. হ্যাঁ আছেন আপনি সো এটা বৃহস্পতিবার তাহলে রাখলে কোনো অসুবিধা নেই তো ভেরি ওয়েল দিস ইজ হুইচ আইটেম মিস্টার মজুমদার একটা আপনি স্লিপে জাস্ট ইন আ স্লিপ অফ পেপার প্লিজ জাস্ট মিস্টার মজুমদার ইউ নিড নট রাইট ইউ ওয়ান অফ
I'm asking Mr.
ask your juniors to write
29 to 37.
29 to 37 29 to 37 দীপঙ্কর লিখে রাখো এটা কালকে এটা 36 29 to 36 ব্র্যাকেটে কালকে লিস্টে অ্যাপিয়ার করবে ব্র্যাকেটে ডেটটা থাকবে বৃহস্পতিবার বুঝতে পেরেছো
Obliged, my lord.
থ্যাংক ইউ 23 নম্বর কোনো না অর্ডার নয় ওদের বাড়ির রেজলিউশন হচ্ছে কিছু অর্ডার দেওয়া দরকার
আচ্ছা